President Trump's pick to serve as the next Attorney General of the United States goes before members of the Senate this morning. Welcome to live coverage from the Washington Post. We're looking at the hearing room, Hart 216, where William Barr will face the Senate Judiciary Committee today. And he'll face tough questions about the Mueller investigation into Russian interference in the election and President Trump. I'm Libby Casey here at the Washington Post with reporter Devlin Barrett, who covers national security and law enforcement, and Aaron Blake, senior political reporter for The Fix. Welcome to you both. We'll bring you live and uninterrupted coverage of today's hearing, which is scheduled to start at 9:30 Eastern Time. So until then, we'll keep an eye on Hart 216, the hearing room, as members of the Judiciary Committee come in and get seated. And we'll also talk to our guests about just what to expect for today. So William Barr, in some ways, seems like an easy pass for this committee. He has served as Attorney General before. He was unanimously passed through the committee process almost 30 years ago, Devlin. And yet, he has raised some flags himself by addressing the Mueller probe and getting himself in the mix and really weighing in over the past year on just what he thinks of this Justice Department and the Mueller investigation.
Right, and it really speaks to, frankly, how much of a different time it is now than it was 30 years ago. You know, you would think a once and future Attorney General would be sort of an easy lift for the Senate, but I think this is going to be a fairly contentious hearing, and it's going to be contentious in large part because, as you said, he said things and wrote things during the Mueller investigation that made people believe he had a strong opinion against the Mueller investigation. And so we fully expect he's going to be pressed very hard on that.
Let's take a moment and just talk about who this man is and what his background and history is before we get into the tough questioning he's going to face today. He's 68 years old. He served in Justice Department in the highest capacities. Tell us about his background.
So Bill Barr is, in many ways a DOJ lifer if you start at sort of the front end of his career. He worked his way up through the senior ranks of the Justice Department in Republican administrations in the 80s and 90s, serving as the Deputy Attorney General, serving in another senior capacity in that building, before becoming President H.W. Bush's Attorney General. And he took that job at a fairly young point in his life. It's kind of amazing to think about now that, when he became the Attorney General the first time, he was 41, 42. Not many 41-year-olds run the Justice Department as a general rule, but he did that. And he's pretty well regarded in conservative legal circles. I think he's considered, a very respected establishment GOP lawyer. In some ways, frankly, he's sort of the antithesis of a Trump Republican, right? He comes from the Bush political universe. And by most accounts, he had to be talked into accepting the nomination and taking the nomination. So it'll be interesting to see how much he feels he is there to present sort of a continuation of Justice Department traditions, and how much he feels he has to, pledge any kind of public allegiance to his actual boss, which is President Trump.
So he wrote a memo over the summer, Aaron, and he also wrote some op-eds for the Washington Post over the last couple of years, specifically addressing the Mueller probe and even getting into questions about, should the president have fired James Comey? Should Sally Yates have stepped down or been fired? Why was he raising these questions? Because he was essentially a private lawyer at the time, right?
It's a good question. Democrats would argue, and some have argued, in fact, Chris Coons, who's on the Judiciary Committee, I would expect would ask some of the toughest questions today, has suggested that William Barr was basically trying out for the job of Attorney General. As Devlin points out, some people have disputed that and say he didn't actually want the job and had to be talked into it. We had this with Matthew Whitaker, too, of course, who is the acting Attorney General right now. Before he became acting Attorney General, indeed before he joined the Justice Department as Jeff Sessions' chief of staff, he was a pundit on CNN who was weighing in on many of these issues of the Mueller investigation, saying things that were perhaps unhelpful for somebody who was going to be overseeing that probe, or perhaps overseeing that probe. With Barr, I think we have that maybe a little bit to a lesser extent. There is a history of Justice Department, top Justice Department aides writing these kinds of memos, weighing in on contemporary legal issues, sharing those with their, people who might actually be in positions of power at that point. So it wasn't completely unusual in that sense, but an obstruction of justice, to have weighed in on collusion in certain ways, to have weighed in on whether the Clintons should still be being investigated, which was also something that I think he talked to maybe you or our colleague Matt Zapotosky about. Right. These are all things that he is going to be confronted with as Attorney General, and his decisions are now going to be colored by that commentary that he's given. So it's not ideal for him unless it really was an audition for the president to pick him as Attorney General.
It's important to dwell on this memo because Democrats are going to bring it up a lot today.
Absolutely.
So take us back. So why, in your estimation, would he, unprompted, write this memo that really addresses the heart of the Mueller investigation?
So I think one of the big questions here is, we are, as best we can tell as reporters, this memo was unprompted, but I'm not 100% certain that that's true. There was a letter sent last night by Barr to Lindsey Graham, the chairman of the committee that's going to be running this hearing. And in that letter, they said something pretty interesting, which was that Barr actually shared the memo and discussed its contents with a whole bunch of people, including not just a bunch of the president's lawyers, but Jared Kushner's lawyer as well. A bunch of the folks who were essentially on the defense side of this investigation talked to Barr about these legal positions regarding the obstruction case. That strikes me as potentially problematic. The other thing the letter says, which really struck me, was that Barr says that he had a conversation with Rod Rosenstein, the Deputy Attorney General, who has been running the Mueller investigation since the Mueller investigation began, about the contents of the memo before he wrote the memo. So the obvious question in my mind that I assume some lawmaker is going to ask today is, what did you say to the Deputy Attorney General in that conversation? And what did he say to you in that conversation? Did he ask for you to write this down? Did he ask for you to circulate this? If that was, in fact, a solicited legal opinion, essentially, from a former Attorney General, I think that really could change the complexion of all this. Now, I don't know what he's going to say to that question. The basic posture has been this was an unsolicited memo. But the letter really makes a suggestion that I think needs to be explored a little further.
And I think it's worth noting that in the letter that came out last night that he sent to Lindsey Graham, this wasn't just a list of people that he sent the memo to afterwards. He said that he spoke to Rosenstein beforehand. Correct. He also said he spoke to a number of other people in the president's legal orbit before he actually wrote the memo and sent it around. He was consulting with people. It wasn't just a situation where he sat down and wrote this or even just talked to Rosenstein. He was talking to a bunch of people about this. And so the question was, like you said, why was that? Is this something that people wanted to get out there and for some reason or another? I imagine that will be a severe point of emphasis today.
As you can see, live images here from Hart 216, where the committee will gather in just a short time. Let's go now to Capitol Hill and reporter Rhonda Colvin. Rhonda?
Thanks, Libby. Yes, we are here at Hart 216, right in front of the doorway where this hearing will take place in less than a half an hour from now. Of course, people are starting to trickle in, and members of this committee will likely also start coming in and getting settled for at least 10 minutes each of questioning to Mr. Barr. The feel here is not like it was when we were here covering the Kavanaugh hearing. There seems to be less public interest. I did take a walk down the hallways. There is a line of people who are going to be attending this just as members of the public, but there isn't that same mood. So as you mentioned earlier, Libby, I believe that Republicans see this as sort of an easy pass for them, that this should not be very contentious. We spoke to one Republican member of this committee, Senator Ted Cruz, last week. Here's what he had to say about his thoughts of the Barr confirmation.
Tensions between the Department of Justice and the White House have been really significant, and I think it will be good to see new leadership in the Department of Justice. I think Bill Barr's nomination, Barr is clearly someone who is strong, who is experienced. He's previously served as Attorney General of the United States, and I think it's good to see the department with a strong leader with gravitas. I think that's important.
So that was the perspective of one Republican member of this committee, and we're likely to see very similar remarks later on today. So back to you, Libby, in the studio.
Great, thanks so much, Rhonda. Rhonda makes a great point about Republicans' confidence in this. And we expect him to essentially play defense and sort of help him along a little bit through this process, Devlin.
Right, and that's, the math works for Republicans, right? There is no evidence that any Republicans are weakening on their support of Barr. So mathematically, he should be fine. I think what the sort of the interesting dynamic, though, is to what degree do Democrats seek to make Barr make certain promises about the Mueller investigation. This is really, in a lot of ways, more about Mueller than it is about Barr. And so the question is, what promises, if any, can the Democrats extract from him? And frankly, there's 3 Democrats on this panel who are probably going to run for president. So I think you should expect there to be some effort for those 3 to sort of distinguish themselves with a big platform and a big spotlight like this.
And we're talking about Kamala Harris of California, Cory Booker of New Jersey, and also Amy Klobuchar of Minnesota, who's been on air this morning on various news outlets talking about her goals and expectations of this hearing.
Right. These are all people who are in the process of actually launching their campaigns now. This is starting. Elizabeth Warren is in. I think Klobuchar has said her decision will come soon. She had a very big moment during the Kavanaugh hearings, of course, that really kind of put her on the map for people who maybe hadn't heard of her before. This is an opportunity for them, even more than those Kavanaugh hearings. There were obviously more people watching those hearings, but this is actually a moment in time where these campaigns are getting off the ground. I would expect we'll hear, those 3 will be a big focus. Chris Coons will be a big focus. He's been kind of the conscience of the Democratic Party on some of these issues. And Mazie Hirono, who is another person who's not running for president, but has called for a recusal in the case of William Barr. I would expect that she wouldn't be the only one calling for recusal, but the fact that she was out front on that, I think, is a significant one.
And Senator Hirono has really found her voice, I would say, in the last year, in terms of being someone who's willing to push back hard against the Trump administration in a way that she really wasn't as vocal on the national stage. She was much more focused on Hawaii issues prior to this. And in the last couple of series of hearings in this committee in particular, she has been like no holds barred. And finding that voice. And then we also look at, there are so many lawyers on this committee, so many former prosecutors and the like. We will definitely hear from people like Richard Blumenthal. Even Dick Durbin has had some memorable moments as he's kind of taken this like direct and folksy line of questioning sometimes with people.
Test 1, 2.
Yeah.
One thing that I would point out too, and this is to Devlin's point earlier that the math is really favoring Republicans here. The committee obviously has a new chairman in Lindsey Graham. Before it was Chuck Grassley. But also key here is that Jeff Flake was able to get some concessions when he was on the Judiciary Committee last year when we were talking about I forget what we were talking about. But basically, he was able to hold things up because the committee was an 11-10 committee, and by voting against what the Republicans wanted to do, he could extract some concessions from the leadership of the committee.
And
Jeff Flake is no longer in the
absolutely.
Senate. There is not that person on this committee who is not going to play ball with Republicans. If there was maybe one person who could gum things up and who has been critical of the president, been very concerned about Russian election interference, maybe it would be somebody like Ben Sasse, but he hasn't been willing to kind of put his money where his mouth is. So, not having Jeff Flake on this committee, I don't think should be underestimated as securing Barr's recommendation to the fuller Senate.
And Jeff Flake's voice was so key, as you point out, Aaron, in the Kavanaugh hearing process when he wanted to slow things down and bring it up again and not just let it pass through, but instead have some more conversation about just what allegations were against him.
Right.
And that really did make a big difference. Expectations of having Lindsey Graham as a chairman on the committee now?
So it's funny, because we were talking Aaron was just talking about Ben Sasse, and there was a time when you could look at this list of lawmakers and say, well, Lindsey Graham might be the guy to give the president trouble. Well, as a general matter, chairmen don't play that role. Chairmen don't play the flamethrower role on committees. So, and in addition to that, Lindsey Graham has moved closer and closer to the president in the last, let's say, year. So it's less and less likely that Graham would play that sort of role. I do think what you might see is a more forceful personality in the gavel in this hearing, in that, Grassley, the person who was the chairman prior to Lindsey Graham was Charles Grassley of Iowa. Fairly low-key person, not prone to outbursts, at least not loud, angry outbursts. He would complain sometimes about all manner of, letters not being replied to, let's say. But he didn't shout down, as a rule, his fellow lawmakers. Lindsey Graham has done that and may very well do that here today. We just don't know how hot it may get as this goes on.
And
And
Grassley
don't
also...
forget, I would just point out on Graham, while he's certainly come closer to the president, he has criticized him on matters of foreign policy, especially the Syria withdrawal, Jamal Khashoggi. And he was and has been among the leading members of the Senate as far as the idea that Mueller needs protecting. So the question is, he may, be kind of low key on that. He may not press as hard as some of the other lawmakers do. But if he's going to be consistent with what he has talked about before, that would maybe be something that he would actually press Barr on.
I want to point out that there are a couple of women Republicans on the committee now, something that was sort of glaringly lacking during the Kavanaugh confirmation process, especially Joni Ernst of Iowa, also Marsha Blackburn, a newly seated member of Tennessee. So we will see some Republican women represented, which has gotten a lot of focus, especially in the light of what 2018 brought.
Right, and I think that goes back to the Kavanaugh hearing and the fact that when there was an issue for Kavanaugh's, past interactions with women, basically all the Republicans defending him on that committee were men. It's not clear to me that Barr is going to have much of the gender politics going on in his hearing, but I do think long term that could make a meaningful difference in other hearings and just in the politics of the committee.
You can see Senator Kennedy there of Louisiana, and we'll see more members coming in shortly. We saw the testimony released yesterday from William Barr, and this happens sometimes. We see the testimony; it's released publicly before the hearing process, and it really did sort of start the news cycle here of building expectations of what we anticipate Mr. Barr will say today. So much of it ultimately has to address this question of the Mueller investigation and what his role will be. So let's look at how he laid out in the first thing he wanted to get off his chest in this written testimony. First, I believe it is vitally important that the special counsel be allowed to complete his investigation. Important statement, but it's complicated, Aaron.
Well, it's also a situation in which the Mueller investigation, at least by all outward appearances, appears to be almost reaching a conclusion. The idea that William Barr was going to come in as Attorney General in February of 2019 and shut this thing down right as it was about to conclude, I think would be very difficult. Even it would have been difficult to shut it down before. Doing it at the very end would look very craven and I think very difficult to do. The other point of this letter that I think was interesting, and it maybe was the big takeaway quote, was where he pledged the amount of transparency that the law allows, or something to that effect. Right. That was seen as a nod to the idea that the Mueller report would in fact be released publicly. That's how some reported it. I think if you parse it very closely, that's not quite what he said. He could believe that there are legal constraints on that or reasons not to disclose certain things. There are going to be major questions about whether he sides with the administration when it comes to claims of executive privilege on certain things. That's going to be a major question here. So there are many ways in which this could, he could make an argument that certain things aren't belonging in the public realm or are. He didn't fully commit to actually releasing the entire report.
Another excerpt, he said, second, I also believe it is very important that the public and Congress be informed of the results of the special counsel's work. But Aaron, you point out that he has this caveat of wanting to stay within legal parameters. Now, Devlin, in some ways that sounds reasonable.
Right.
But on the other hand, how far does that go? And Democrats will surely today be trying to pin him down on just where that legal line is.
Right, and I think it may seem a little silly to say, but you have to remember, Bill Barr is a very smart lawyer. So when he makes statements, he has crafted the language very carefully. And so when he says, I believe there should be transparency and the results of Mueller's work should be known to the public, results is a very different thing than everything Mueller found. Those are two very different categories of information. And so I think that statement is interesting, and I assume he'll be pressed to explain exactly what he means by it. But that sentence in and of itself doesn't actually tell a whole lot. And I'll say this: he doesn't know what he's going to be confronted with when he gets that job. Assuming he's confirmed, he will then be read into the case and everything that's happened up till that point, and then he may have a completely different understanding of the situation and what his role in it is likely to end up being. So I think he's going to have to walk a tight line here between talking about things where he doesn't know the underlying facts, many of the underlying facts, and at the same time trying to reassure the public, because that's really what a lot of this is about, even more so than the Democratic minority, that he is an honest stand-up guy. The thing that was sort of jarring and amazing to me going through some of the history was when an Attorney General nominee had his confirmation hearing during the Watergate crisis, he actually had the special counsel sitting at the table next to him because the lawmakers wanted him to make the promise right next to the guy, and they wanted the guy to hear the promise and basically be fully on board. So if at any moment the special counsel felt like, actually, Senator, I have a concern, he could literally raise his hand or just like grab the microphone and say it in that moment. This isn't going to be that dramatic, that you know, face to face. But it does strike me that the dynamic is actually somewhat similar.
Yeah, Robert Mueller is the strong presence that's absent from the room.
Correct.
Other strong presence is James Comey, just because that was at the center of a lot of what William Barr has weighed in on so
Yes.
far. So is it possible for this Attorney General nominee to believe the president was in his rights to fire James Comey and yet still have a very open mind about what the Mueller investigation might reveal?
It's certainly possible. I mean, I think one of the ways, you know, I would sort of hope the committee tries to unpack Barr's past statements, because what Barr has said is the president was completely in his power to fire James Comey, that pursuing an obstruction case based on the firing of James Comey would create huge precedential problems for everyone who comes after them, both in the Justice Department and in the White House. It's actually an interesting argument. I think some of Barr's language that he uses to make that argument in the memo is a little incendiary and surprising to me that a lifelong law enforcement person would say that. For example, referring to FBI questioning as an interrogation. You know, there's no federal prosecutor or FBI person I know who calls an interview an interrogation. That's the language of defense lawyers. But having said all that, I do think that there's an interesting dynamic of in these op-eds where he writes about Comey, he's throwing out ideas and sort of casting aspersions on Comey and casting the president in a good light. I think the underlying question is, well, how seriously does he take that? How much is that truly his view, or is he just sort of, you know, giving impressions that are malleable or changeable based on new facts?
Let's head back to Capitol Hill and our reporter, Rhonda Colvin. Rhonda?
Libby, I'm joined here with our staff writer and colleague, Karun Demirjian. Thank you for stopping on your way into the hearing room. Tell me two things that you are going to be watching today in this hearing.
Well, I think that the first thing that everybody's going to be paying attention to is, what does Bill Barr say about Bob Mueller? He released that statement yesterday that said he was interested in having that report released publicly, but Democrats are going to be looking for guarantees under oath that he's actually going to protect the special counsel's probe, that he's not going to interfere with it in any way, and that he's also going to commit to doing that in a conclusive fashion, because they want that report to come out. The other thing that I guess I'm looking for is related. I mean, how is Bill Barr going to explain his past in many ways? He has this memo questioning whether Mueller's probe could look into obstruction of justice issues surrounding the firing of Jim Comey. He has made statements in the past that give Democrats pause, not just about Mueller, but about generally his views on how broad the reach of executive power is. And he's going to have to face those types of questions too. And the answers he gives, I think, are not going to really... He seems to have enough of the votes in the Republican side, at least, to be confirmed, but they are definitely going to set the tone for how his tenure is seen once he becomes confirmed as Attorney General.
All right, thank you, Karun, for stopping for us, and I will let you get back to work, and I will send things back to you in the studio, Libby.
Thanks so much. You know, there is this question of how much Democrats can pin him down on today, and what sort of concessions or guarantees or promises, Aaron, they can extract from him. Now, you point out that this is not his first rodeo. This is someone who's very experienced at going through the confirmation process multiple times, at parsing his language very carefully. But Democrats are going to be trying to ask everything for a recusal, which is, I'm going to say, not going to happen. Is that fair to say?
I think the recusal question is a huge issue because Whitaker, the current acting Attorney General, has sort of in some ways made life harder for Bill Barr to get confirmed, but he's also in some ways, by being so heavily criticized, made life a little easier for Bill Barr, because there is an argument that Republicans are privately making, which is if you want to get rid of Whitaker, the way to do that is to confirm Barr.
Right.
But this recusal question, I think, is a tough one, because I think what the Democrats would like out of Barr is some promise that he will follow the ethics advice of the Justice Department ethics officials. And we already know that Whitaker did not do that when he was in that position. And it's
So
not clear to
Barr-
me that Barr is going to make that promise.
Barr has publicly said that he agreed with Sessions' decision to, when he was advised to recuse himself, that he
Right.
did the right thing by doing so.
Right.
We don't know how he feels about Whitaker's decision not to recuse himself, despite ethical advice to do so.
Correct.
Okay.
And one of the challenges of ethics advice is the tradition within the Justice Department is it's just advice. You don't have to do it.
I mean, I laughed when I asked about recusal because this is what got Jeff Sessions in hot water with the President of the United States. So Jeff Sessions makes the choice to recuse himself, and that makes President Trump irate, Aaron. And so you'd have to figure that this would be a calculation that President Trump's making as he puts forward a new name for the Attorney General position.
It may be a calculation. I think it's important to note in the memo that Barr says rather explicitly that the president did not seek any assurances, either implicitly or explicitly, and I did not make any promises either implicitly or explicitly.
Right.
I looked at that language pretty closely, and I was unable to penetrate that and look for the loopholes there. I don't think there was any. Certainly, this is a president who has sought loyalty from people before, according to James Comey on multiple occasions. He's talked about how Jeff Sessions wasn't loyal to him. It was logical to maybe assume that if he was interviewing William Barr for this job, he would have suggested at least that maybe you could be loyal to me in a way that Jeff Sessions wasn't. But Barr says that that was not something the president brought up with him. At least that's what it seems like he's saying. So I would imagine that they will press him on that particular question. But I think the language that he, and Devlin can tell me if he disagrees, but I think the language in the memo was, or in the opening statement rather, was pretty firm on that point.
Absolutely. The language is very explicit on that point. I think the challenge is among Republican lawyers who interact with the White House or Congress, I don't think there's any shadow of a doubt that in the president's mind, the number one job of the next attorney general is not to recuse from the Russian investigation. I think that may be, and this isn't to cast aspersions on what Barr says. I think I take it at face value that that's absolutely true. I think that may actually not need to be spoken.
Well, also the memo that Barr wrote of his own volition, it appears, last year, says a lot. I mean, it does
19
really,
pages.
it waves some flags and indicates sort of where he would fall on things. So.
Right, and I think there's an interesting
In
dynamic.
terms of how the president could read it. Now, Barr
Yes.
may say, look, this is a narrow scope. I was only weighing in on one aspect of what I knew publicly about the Mueller investigation and the firing of James Comey.
Right.
But if the president's reading that and his advisors are reading that, it does seem favorable to President Trump.
It does, and remember, there's one thing in that memo that I think has been sort of not forgotten about, but is lost in a lot of the noise, which is in that memo, Barr uses the argument about obstruction not being a valid thing to pursue to say, therefore, the president should not be questioned by the FBI about obstruction. And that obviously is a really tense issue between the White House and the Justice Department, and in some ways between the Justice Department officials and Mueller's people about whether or not the president should be forced to answer questions. Barr has signaled he already has an opinion on this. I think that would be of supreme interest to the president himself as the person who might be questioned, and of supreme interest to the Justice Department and Mueller and members of Congress.
I want to address briefly other issues that are likely to come up at today's hearing because the Mueller investigation will be a huge focus. But we also expect him to be pressed on criminal justice issues. President Trump just signed into law this criminal justice reform bill. Barr was known to be, quote unquote, tough on crime. 30 years ago was a very different climate. Will he adhere to this new law in a way that is not just literally the letter of the law, but also the sort of the feel and the ethos of the law? What are some other issues that he's likely to be asked about today outside of the scope of the Mueller investigation?
Right, so executive power. I mean, executive power speaks to the Mueller investigation, but it also speaks to a much broader set of issues, which is how much power does the president have to exert his will over the government and the law? Barr historically has very strong opinions that the president is very powerful. And I think, frankly, that touches the Mueller investigation, but that also touches a whole bunch of other things. I mean, one of my, so I'm admittedly a DOJ nerd, one of my worries is that the committee hearing may spend so much time talking about Mueller that we actually don't know what the next Attorney General thinks about a lot of subjects.
You can see William Barr entering now. And if you saw Orrin Hatch a few moments ago and thought, wait a minute, what, did I step back in a time machine? Didn't he just retire from the Senate? Yes, he did, but Orrin Hatch is expected to make introductions of Bill Barr. You can see the two men there.
If we're going to go back to the tough on crime idea here, I thought the language was really interesting in his opening statement. He's going to say, the recently passed First Step Act, which I intend to diligently implement if confirmed, recognizes the progress that we made over the past 3 decades. Like Attorney General Sessions, I believe we must keep up the pressure on chronic violent criminals. We cannot allow the progress we have made to be reversed.
He's sort of saying two things at once.
He is. He's saying, I will do my job because it is my job as Attorney General, but it's not exactly a ringing endorsement of the First Step Act, and I think it speaks to the idea that this is a guy who was part of that tough on crime generation. Now, a lot of this momentum for this stuff is coming from newer members of Congress and not necessarily the old guard. He is very much that old guard, so it'll be interesting to see what he says today on questions about that issue.
And you can see there Chuck Grassley, other members of the committee coming in, Ted Cruz. You can see Joni Ernst, one of the few and brand new women Republican to serve on this committee. Immigration may also come up. He does address that in his opening statement. We may hear questions along those lines. So let's just give a sense of what's going to happen now after we see opening statements from the new chairman, Lindsey Graham, who you can see there. Also opening statements from Dianne Feinstein, the most powerful Democrat on this committee. We'll see Mr. Barr make his opening remarks and statements, and then each senator will get 10 minutes to ask questions. That's round one. Then there's a second round. We'll get about 8 minutes, we expect, to ask another set of questions. So this hearing can go deep into the day. We saw the hearing for Attorney General Jeff Sessions that went into evening hours. I will point out that things that Jeff Sessions said during his nomination hearing, his confirmation hearing, came back to haunt him and came back to be remembered and reported on, Devlin, by you and members of our Justice and National Security team for months and months and months. And Bill Barr certainly has to have that in his head, that what he says today will be remembered in many ways.
Right. Jeff Sessions' recusal, the thing that made him the unforgivable act in Donald Trump's eyes of Jeff Sessions' recusal really stems from something he said at his confirmation hearing, which is he denied meeting with any Russians during the campaign. And when it turned out that wasn't accurate, within, I think, 48 hours, the Attorney General had announced he was recusing from the Russia investigation. So it is absolutely important what he says here and how he says it. But it takes two to tango. One of the oddities, are we starting now?
We are getting started, so we'll go now live to the hearing room of the Senate Judiciary Committee.
Thank you all. You're not going to get a good shot of me, so thank you all. So happy New Year, new Congress, and we'll see how this goes. Recognize Senator Grassley.
Okay. I do this as a point of personal privilege, Mr. Chairman, and I appreciate that courtesy of you and the members. This is the first meeting of the Senate Judiciary Committee in this 116th Congress. It's also the first time that we convene while my friend Lindsey Graham holds the gavel and will proceed to be chairman. So I'd like to congratulate the new chairman, thank him for his leadership, and say that I look forward to working with you and other members of this committee as we seek to address some of our nation's most pressing problems. I have every confidence that you'll steer our 200-year-old committee in the right direction.
Well, thank you. I really appreciate that. In my view, nobody looks over 100, so we're actually we're aging well as a committee. The bottom line is, how do you get this job? Your colleagues have to vote for you. Thank you. You have to get reelected and outlive the person to your right. So I've been able to do that. And I look forward to working with Senator Feinstein, who I have a lot of affection and fondness for. She, to me, represents a seriousness that the body needs and a demeanor that I think we should all aspire to. To the new colleagues, Senator Hawley, Blackburn, and Ernst, thank you for being part of this committee. To Senator Blackburn and Ernst, thank you for making history, I think, on our side. As to the hopes and dreams for this committee, to get as much done as possible and to fight when we have to over things that matter to the public and show two different views of an issue that's important, but do it as respectfully as possible. Sentencing reform, criminal justice reform was a very big deal. And this committee delivered for the country. Senator Durbin, I want to thank you very, very much for working with Senator Lee and Senator Grassley and Senator Booker. That's a big deal that's going to change lives, I think, in a positive way. So this committee has within it the ability to do big things long overdue. I know Senator Blackburn wants to do something on social media. Senator Klobuchar's got some ideas about how to make sure if you put an ad up on social media, you have to stand by it. We're all worried about the social media platforms being hijacked by terrorists and bad actors throughout the international world. We're worried about privacy. Do you really know what you're signing up for when you get on one of these platforms? I'd like this committee working with Commerce to see if we can find some way to tame the Wild West. Intellectual property, Senator Tillis and Senator Coons have some ideas that I look forward to hearing about. Senator Sass wants to make sure that we act ethically. You got a package of ethic reforms, and I look forward to working with you there. On this side, I know there are a lot of ideas that I'm sure that if we sat down and talked, we could embrace, and I look forward to solving as many problems as we can and having a contest over ideas that really matter to the American people. Senator Hatch, thank you for coming. In terms of my chairmanship, if I can do what you and Senator Grassley were able to do during your time, I will have done the committee a good service. Senator Grassley, thank you very much. Last year was tough, but I think you and Senator Feinstein did the best you could in the environment in which we live. The times in which we live are very difficult times. I don't see them getting better overnight, but I do see them getting better if we all want them to. So about me, I want us to do better, and I'll be as measured as possible. The immigration Lindsay will show up, but the other guy's there too, and I don't like him any more than you do. So the bottom line is we're starting off with something that would be good for the country. We have a vacancy for the Attorney General spot. We have a chance to fill that vacancy. Mr. Barr is, you can't hold a job. When you look at what he's done in his life, it's incredible. So I want to thank the President for nominating somebody who is worthy of the job, who will understand on day one what the job is about, and can right the ship over there. I think we all have concerns. I know Senator Whitehouse is passionate about cybersecurity and Fort Cyber and all these other ideas that Sheldon has been pushing. It's just a matter of time before we hit hard if somebody doesn't step up to the plate with some solutions. But a little bit about the nominee. He's been Attorney General before, from 91 to 93, by voice vote. Those were the days. Deputy Attorney General from 90 to 91, unanimous consent without a recorded vote. Assistant Attorney General, Office of Legal Counsel, voice vote. That's pretty amazing. I think you're going to have an actual vote this time. Academically gifted, George Washington Law School, Columbia University undergraduate. Outside of DOJ, he was the General Counsel, Legislative Counsel for the CIA. That's how he met Bush 41. He's been a law clerk. He's worked in private practice. I'm not going to bore the committee with all the things he's done. He's been the Senior Vice President, General Counsel of GTE. He's lived a consequential life, General Counsel for Verizon. You've lived a life that I think has been honorable and noteworthy and accomplished, and I want to thank you for being willing to take this task on. We got a lot of problems at the Department of Justice. I think morale is low, and we need to change that. So I look forward to this hearing. You will be challenged. You should be challenged. The memo, there'll be a lot of talk about it, as there should be. But I just want to let you know, Mr. Barr, that we appreciate you stepping up at a time when the country needs somebody of your background and your temperament to be in charge of the rule of law. And with that, I will turn it over to my colleague, Senator Feinstein.
Thanks very much, Mr. Chairman. And I want you to know I really look forward to working with
Me
you.
too.
And I think we can work productively together. And Senator Grassley, I want to thank you for the time we worked together. It really was a pleasure, and I had an opportunity to get to know you as the fine person that you are. So thank you very much. I want to say just one word or two or three about women. 25 years ago, there were no women on this committee. I'll never forget watching the Anita Hill hearing on a television in the London airport with a lot of people gathered around. So I went over to take a look, and I saw this all-male Judiciary Committee. And it took all these years, but here we are. And I want to particularly welcome Senator Ernst and Senator Blackburn. I think it's extraordinarily important that this committee be representative of our society at large, and we are growing that way, and so thank you very much for being here. I'd also like to welcome Bill Barr and his family. I know you're proud to be here, and you served as Attorney General before, from 91 to 93, and I think we all have great respect for your commitment to public service. When we met, your previous tenure marked a very different, we talked about a very different time for our country. And today we find ourselves in a unique time with a different administration and different challenges. And now, perhaps more than ever before, the country needs someone who will uphold the rule of law, defend the independence of the Justice Department, and truly understand their job is to serve as the people's lawyer, not the president's lawyer. Top of mind for all of us is the ongoing Mueller investigation. Importantly, the Attorney General must be willing to resist political pressure and be committed to protecting this investigation. I'm pleased that in our private meeting, as well as in your written statement submitted to the committee, you stated that it's vitally important, and this is a quote, that the special counsel be allowed to complete his investigation, end quote, and that, quote, the public and Congress be informed of the results of the special counsel's work, end quote. However, there are at least two aspects of Mr. Mueller's investigation. First, Russian interference in the United States election, and whether any U.S. persons were involved in that interference. And second, possible obstruction of justice. It's the second component that you have written on. And just 5 months before you were nominated, I spent the weekend on your 19-page legal memo to Deputy Attorney General Rod Rosenstein, criticizing Mueller's investigation, specifically the investigation into potential obstruction of justice. In the memo, you conclude, I think, that Special Counsel Mueller is, quote, grossly irresponsible for pursuing an obstruction case against the president. And pursuing the obstruction inquiry is fatally misconceived. So I hope we can straighten that out in this hearing. But your memo also shows a large sweeping view of presidential authority and a determined effort, I thought, to undermine Bob Mueller, even though you state you have been friends and are in the dark about many of the facts of the investigation. So it does raise questions about your willingness to reach conclusions before knowing the facts and whether you prejudge the Mueller investigation. And I hope you'll make that clear today. It also raises a number of serious questions about your views on executive authority and whether the president is, in fact, above the law. For example, you wrote, the president, and I quote, alone is the executive branch. As such, he is the sole repository of all executive powers conferred by the Constitution. Thus, the full measure of law enforcement authority is placed in the President's hands, and no limit is placed on the kinds of cases subject to his control and supervision. This is in your memo on page 10, and I will ask you about it. This analysis included cases involving potential misconduct, where you concluded, and I quote, "The President may exercise his supervisory authority over cases dealing with his own interests, and the President transgresses no legal limitation when he does so." That's on page 12. In fact, you went so far as to conclude that, quote, "The framers' plan contemplates that the President's law enforcement powers extend to all matters, including those in which he has a personal stake." You also wrote the Constitution itself places no limit on the President's authority to act on matters which concern him or his own conduct, page 10. Later, you conceded that certain supervisory actions, such as the firing of Director Comey, may be unlawful obstruction. However, this too is qualified. You argue that in such a case, obstruction of justice occurs only if first a prosecutor proves that the President or his aides colluded with Russia. Specifically, you conclude, and I quote, "The issue of obstruction only becomes ripe after the alleged collusion by the President or his campaign is established first," end quote. So that's some of the things I hope to ask you about. And in conclusion, let me just say that some of your past statements on the role of Attorney General and presidential power are concerning. For instance, you've said in the past that the Attorney General is the President's lawyer. In November of 2017, you made comments suggesting it would be permissible for the President to direct the Justice Department to open an investigation into his political opponents. And this is notable in light of President Trump's repeated calls for the investigation of Hillary Clinton and others who disagree with him. I believe it's important that the next Attorney General be able to strongly resist pressure, whether from the administration or Congress, to conduct investigations for political purposes. He must have the integrity, the strength, and the fortitude to tell the President no, regardless of the consequences. In short, he must be willing to defend the independence of the Justice Department. So my questions will be, do you have that strength and commitment to be independent of the White House pressures you will undoubtedly face? Will you protect the integrity of the Justice Department above all else? Thank you very much, Mr. Chairman.
Thank you, Senator Feinstein. Senator Hatch, welcome back. We truly miss you. You were a great chairman and an incredible member of this body, and you're very welcome to share your thoughts about Mr. Barr with this committee.
Well, thank you so much, Mr. Chairman, Ranking Member Feinstein as well, and members of the committee. It is my distinct pleasure to be here today to introduce William Barr, the President's nominee to be Attorney General of the United States. I have known and worked with Bill closely over the years, and I'm glad to call him a friend. Bill has had a distinguished career in public service and in the private sector. He started his career at the Central Intelligence Agency. While there, he went to law school part-time at George Washington University. Following graduation, he was selected for a prestigious clerkship with a federal judge on the D.C. Circuit before heading to private practice. Later, he served in the Reagan White House in the Office of Policy Development. Following another stint in private practice, Bill began his distinguished career at the Department of Justice under President George H.W. Bush. Bill served as the Assistant Attorney General for the Office of Legal Counsel, then as Deputy Attorney General, and finally as Attorney General of the United States. As Attorney General, Bill oversaw a number of sensitive criminal investigations including the investigation into the Pan Am Flight 103 bombing. He prioritized fighting violent crime and became known as the Law and Order Attorney General. Throughout his time at the Justice Department, Bill earned a reputation as a fierce advocate for the rule of law, as a principled and independent decision maker, and as a lawyer's lawyer. He has shown his commitment to the Constitution time and time again while serving our country. That is why he has been confirmed by the Senate unanimously 3 times. After completing his service at the DOJ, Bill returned to the private sector working at law firms and as counsel for some of America's largest companies. I could go on at length describing Bill's distinguished career. There is no question, none whatsoever, that Bill is well qualified to serve as Attorney General. He has held this position before and won high praise during his tenure for his fairness, his tenacity, and his work ethic. So instead of droning on about Bill's resume, I want to tell you about what Bill identifies as the most important achievement of his private service as Attorney General. At least I believe this is what he believes. I believe his answer tells you much about how he will approach the job and who he is. When asked what his most important accomplishment was as Attorney General, Bill does not point to one of his many policy successes. He doesn't talk about his role in setting antitrust merger guidelines. He doesn't say it was his role leading the DOJ's response to the savings and loans crisis. No, for him, it was something more. It was something more tangible. It was Talladega. 3 days after Bill was named acting Attorney General by President Bush, 121 prisoners noted and seized control of the Talladega Federal Correctional Institution in Alabama. This was a very serious matter. And they took 10 hostages. Planning at the DOJ began immediately for how best to resolve the situation and secure the safe release of the hostages. In such a situation, some would have sought political cover, not Bill. He was in charge. He knew the response was his decision to make, his responsibility. He maintained his focus on the safety of the men and women held hostage by the prisoners. The standoff lasted 10 days. Then, on Bill's order, FBI agents stormed the prison. 3 minutes later, it was over. The hostages were safe. The mission was well planned and executed. That federal agents did not even have to fire a single shot. Bill's decision-making and judgment helped save lives. When President Bush nominated Bill to be Attorney General in 1991, I noted why he had been selected. He was not a member of President Bush's political or personal inner circle. He was not a part of the president's brain trust. He was not a politician or former politician who brought political clout to the position from prior elections or prior elected office. Bill Barr was a lawyer's lawyer. Talent, merit, and performance. Those were the reasons President Bush selected him to be the Attorney General at that time. That statement holds true today. Bill Barr, in my opinion, is an outstanding choice for Attorney General. His vast experience, renowned judgment, and reputation as an ardent defender of the rule of law make him a nominee that the American people, the President, and the Senate should all be proud of. So I feel very honored to be here today to speak in his favor, and I hope that his nomination will be approved expeditiously. Thank you, Mr.
Thanks, Senator Hatch. I'd like to note at the outset that the rules of the Senate prohibit outbursts, clapping, or demonstrations of any kind. This includes blocking the view of people around you. Please be mindful of these rules. As we conduct this hearing, I'll ask the Capitol Police to remove anyone who violates the rules of this committee. Thanks, Senator Hatch. Ms. Barr, would you come forward, please?
Thank you.
Raise your right hand, please. Do you affirm that the testimony you're about to give to this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Floor is yours.
Before I begin, Mr. Chairman, could I introduce my family?
Absolutely.
My wife of 46 years, Christine, a retired librarian. My daughter, Margaret, who we called Meg, she was an assistant United States attorney in the District of Columbia, but now has moved up to Capitol Hill and works for Senator Braun. My middle daughter, Patricia, who's also an attorney, and she has been counsel to the House Agriculture Committee for how long now, Patty? 10? 11 years. And my daughter, Mary, who is a longtime federal prosecutor and is currently the coordinator for opioid enforcement in the Office of the Deputy Attorney General. Mary's husband, Mike, who is also an attorney at the Department of Justice in the National Security Division, and their son, Mary and Mike's son, Liam, who will someday be in the Department of Justice. Patricia's husband, Pelham, who is a founding partner of a consulting firm, and Meg's husband, Tyler, who is also an assistant United States attorney in the Eastern District of Virginia. Did I leave anyone out?
Think about medical school, Liam. Somebody needs to make money in the family.
When Meg was starting at Notre Dame, I told her I wanted a doctor in the family, and I made her take organic chem. Needless to say, she's now a lawyer, so. Good morning, Mr. Chairman, Ranking Member Feinstein, and members of the committee. It's a privilege to come before you today, and I'm honored that President Trump has nominated me for the position of Attorney General. I regret that I come before this committee at a time when much of our government is shut down, and my thoughts are with the dedicated men and women of the Department of Justice and other federal workers, many of whom continue to perform their critical jobs. As you know, if the Senate confirms me, this would be my second time I would have the honor of holding this office. During the 4 years I served under President George H.W. Bush, he nominated me for 3 successive positions in the department: the Assistant Attorney General for the Office of Legal Counsel, the Deputy Attorney General, and finally the Attorney General. And this committee unanimously approved me for each of those offices. 27 years ago at my confirmation hearing, I explained that the Office of Attorney General is not like any other cabinet post. It is unique and has a critical role to play under our constitutional system. I said then, the Attorney General has a very special obligation, unique obligations. He holds in trust the fair and impartial administration of justice. It is the Attorney General's responsibility to enforce the law even-handedly and with integrity. The Attorney General must ensure that the administration of justice, the enforcement of the law, is above and away from politics. Nothing could be more destructive of our system of government, of the rule of law, or the Department of Justice as an institution than any toleration of political interference with the enforcement of the law. I believe this as strongly today as I did 27 years ago, indeed more strongly. We live in a time when the country is deeply divided. In the current environment, the American people have to know that there are places in the government where the rule of law, not politics, holds sway, and where they will be treated fairly based solely on the facts and the even-handed application of the law. The Department of Justice must be that place. I did not pursue this position, and when my name was first raised, I was reluctant to be considered and indeed proposed a number of alternative candidates. I'm 68 years old, partially retired, and nearing the end of a long legal career. My wife and I were looking forward to a peaceful and cherished time with our daughters and grandchildren. And I've had this job before. But ultimately, I agreed to serve because I believe strongly in public service. I revere the law. I love the Department of Justice and the dedicated professionals who serve there. And I believe that I can do a good job leading the department in these times. If confirmed, I will serve with the same independence I did in 1991. At that time, when President Bush chose me, he sought no promises and asked only that his Attorney General act with professionalism and integrity. Likewise, President Trump has sought no assurances, promises, or commitments from me of any kind, either express or implied, and I have not given him any, other than that I would run the department with professionalism and integrity. As Attorney General, my allegiance will be to the rule of law, the Constitution, and the American people. This is how it should be, this is how it must be, and if you confirm me, this is how it will be. Now let me address a few matters I know are on the minds of some of the members of this committee. First, I believe it is vitally important that the special counsel be allowed to complete his investigation. I have known Bob Mueller for 30 years. We worked closely together throughout my previous tenure at the Department of Justice. We've been friends since, and I have the utmost respect for Bob and his distinguished record of public service. And when he was named special counsel, I said his selection was good news, and that knowing him, I had confidence he would handle the matter properly, and I still have that confidence today. Given his public actions to date, I expect that the special counsel is well along in his investigation. At the same time, the President has been steadfast that he was not involved in any collusion with Russian attempts to interfere in the election. I believe it is in the best interest of everyone, the President, Congress, and the American people, that this matter be resolved by allowing the special counsel to complete his work. The country needs a credible resolution to these issues, and if confirmed, I will not permit partisan politics, personal interests, or any other improper consideration to interfere with this or any other investigation. I will follow the special counsel regulations scrupulously and in good faith, and on my watch, Bob will be allowed to finish his work. Second, I also believe it is very important that the public and Congress be informed of the results of the special counsel's work. My goal will be to provide as much transparency as I can consistent with the law. I can assure you that where judgments are to be made, I will make those judgments based solely on the law, and I will not let personal, political, or other improper interests influence my decision. Third, I would like to briefly address the memorandum that I wrote last June. I wrote the memo as a former Attorney General who has often weighed in on legal issues of public importance, and I distributed it broadly so that other lawyers would have the benefit of my views. My memo was narrow, explaining my thinking on a specific obstruction of justice theory under a single statute that I thought, based on media reports, the special counsel might be considering. The memo did not address or in any other way question the special counsel's core investigation into Russian efforts to interfere in the election, nor did it address other potential obstruction of justice theories or argue that some have wrongly suggested that a president can never obstruct justice. I wrote it myself, on my own initiative, without any assistance, and based solely on public information. I would like to comment very briefly on my priorities if confirmed as Attorney General. First, we must continue the progress we've made on violent crime, while at the same time recognizing the changes that have occurred since I last served as Attorney General. The recently passed First Step Act, which I intend to diligently implement if confirmed, recognizes the progress we have made over the past 3 decades in fighting violent crime. As Attorney General, I will ensure that we will continue our efforts to combat violent crime. In the past, I was focused on predatory violence, but today I am also concerned about another kind of violence. We can only survive and thrive as a nation if we are mutually tolerant of each other's differences, whether they be differences based on race, ethnicity, religion, sexual orientation, or political thinking. And yet we see some people violently attacking others simply because of their differences. We must have zero tolerance for such crimes, and I will make this a priority as Attorney General if confirmed. Next, the Department will continue to prioritize enforcing and improving our immigration laws. As a nation, we have the most liberal and expansive immigration laws in the world. Legal immigration has historically been a huge benefit to this country. However, as we open our front door and try to admit people in an orderly way, we cannot allow others to flout our legal system by crashing in through the back doors. In order to ensure that our immigration system works properly, we must secure our nation's borders, and we must ensure that our laws allow us to process, hold, and remove those who unlawfully enter. Finally, in a democracy like ours, the right to vote is paramount. In a period of great political division, one of the foundations of our nation is our enduring commitment to the peaceful transition of power through elections. If confirmed, I will ensure that the full might of our resources are brought to bear against foreign persons who unlawfully interfere in our elections. Fostering confidence in the outcome of elections also means ensuring that the right to vote is fully protected, as well as ensuring the integrity of elections. Let me conclude by making the point that over the long run, the course of justice in this country has more to do with the character of the Department of Justice as an enduring institution than with the tenure of any particular Attorney General. Above all else, if confirmed, I will work diligently to protect the professionalism and integrity of the Department as an institution, and I will strive to leave it and the nation a stronger and better place. Thank you very much for your time today, and I look forward to answering your questions.
Thank you, Mr. Barr. We'll try to break around 11:30, I think, to get a quick bite and break up the day for you. But one thing I want to tell you is that I support the idea that politicians, no matter what party, should not interfere with criminal investigations. That makes eminent sense to me. Once you go down that road, then the rule of law collapses. But there's another side to this equation, if I may say a two-way street. What about those in charge of enforcing the law? What about those with the power to bring charges against American citizens, including people up here? I remember Senator Stevens' case in Alaska. So we should always be on guard about the politician interfering in an investigation, but we should also have oversight of how the department works and those with this tremendous power use that power. Are you familiar with the January 11th New York Times article about FBI open inquiry into whether Trump was secretly working on behalf of Russians?
Yes, Mr. Chairman.
Would you promise me and this committee to look into this and tell us whether or not, in the appropriate way, a counterintelligence investigation was opened up by somebody at the FBI/Department of Justice against President Trump?
Yes, Mr. Chairman, I think there are a number of investigations, as I understand it, going on in the department.
Have you ever heard of such a thing in all the time you've been associated with the Department of Justice?
I have never heard of that.
Are there rules about how you can do counterintelligence investigations?
I believe there are, Mr. Chairman.
So if you want to open up one against the president, are there any checks and balances?
Not outside the FBI.
Okay, well, we need to look at that. In terms of people who are actually enforcing the law, don't we want to make sure they don't have an agenda?
That's right, Mr. Chairman.
Do you know a Lisa Page or Peter Strzok?
I've heard their names.
But do you know them personally?
No, I don't.
This is a message, August 8th, 2016, a text message. Trump's not ever going to become president, right? Right. Strzok responded, no, he's not. We'll stop him. Strzok was in charge of the Clinton email investigation. Ms. Page worked at the Department of Justice. August 15th, 2016. I want to believe the path you threw out for consideration in Andy's office, that there's no way he gets elected, but I'm afraid we can't take that risk. It's like an insurance policy in the unlikely event you die before 40. March 4th, 2016. Page to Strzok. God, Trump is a loathsome human being. October the 20th, 2016. Trump is an effing idiot, is unable to provide a coherent answer. To all those who enforce the law, you can have any opinion of us that you like, but you're supposed to do your job without an agenda. Do you promise me as Attorney General, if you get this job, to look in to see what happened in 2016?
Yes, Mr. Chairman.
How do these statements sit with you?
I was shocked when I saw them.
Okay, please get to the bottom of it. I promise you we will protect the investigation, but we're relying upon you to clean this place up. FISA warrants, are you familiar with a FISA warrant?
Yes, Mr. Chairman.
Okay. During the process of obtaining a warrant, is there a certification made by the Department of Justice to the court that the information being provided is reliable?
Yes, sir.
Are you familiar with Bruce Orr?
No, I'm not.
Bruce Orr was Associate Deputy Attorney General for Organized Crime and Drug Enforcement. His wife worked at Fusion GPS. Are you familiar with Fusion GPS?
Yes, I've read about that.
Fusion GPS, Mr. Barr, was hired by the Democratic National Committee and the Clinton campaign to do opposition research against candidate Trump and maybe other candidates. But we now know that they hired Fusion GPS, Michael Steele, who was a former British agent, to do opposition research and produce the famous dossier. Were you aware that Mr. Orr's wife worked for that organization?
I've read that.
Does that bother you if he had anything to do with the case?
Yes.
Are you aware that on numerous occasions he met with Mr. Steele while his wife worked with Fusion GPS?
I've read that.
Okay. The warrant certification against Carter Page on 4 different occasions certifies that the dossier, which was the main source of the warrant, was reliable. Would you look in to see whether or not that was an accurate statement and hold people accountable if it was not?
Yes, Mr. Chairman.
Mueller. You say you've known Mueller a long time. Would you say you have a close relationship with Mr. Mueller?
I would say we were good friends.
Would you say that you understand him to be a fair-minded person?
Absolutely.
Do you trust him to be fair to the president and the country as a whole?
Yes.
When his report comes to you, will you share it with us as much as possible?
Consistent with the regulations and the law, yes.
Do you believe Mr. Mueller would be involved in a witch hunt against anybody?
I don't believe Mr. Mueller would be involved in a witch hunt.
What are the circumstances that would allow a special counsel to be appointed, generally speaking?
Well, I appointed 3, Mr. Chairman, a special counsel, and generally, when something comes up, an issue comes up that needs to be investigated, and there are good reasons to have it investigated by a special counsel outside the normal chain at the department, someone usually of public stature that can provide additional assurance of nonpartisan.
Do you believe that Attorney General Sessions had a conflict because he worked on the Trump campaign?
I'm not sure of all the facts, but I think he probably did the right thing recusing himself.
I agree. I think he did the right thing to recuse himself. Do you know Rod Rosenstein?
Yes, I do.
What's your opinion of him?
I have a very high opinion of Rod Rosenstein and his service in the department.
Okay. Why did you write the memo?
I wrote the memo because starting, I think, in June of 2017, there were many news reports, and I had no facts, and none of us really outside the department have facts. But I read a lot of news reports suggesting that there were a number of potential obstruction theories that were being contemplated, or at least explored. One theory in particular that appeared to be under consideration under a specific statute concerned me because I thought it would involve stretching the statute beyond what was intended, and it would do it in a way that would have serious adverse consequences for all agencies that are involved in the administration of justice, especially the Department of Justice. And I thought it would have a chilling effect going forward over time. And my memo is very clear, that is the concern that was driving me. The impact, not the particular case, but its impact of a rule over time. And I wanted to make sure that before anyone went down this path, if that was in fact being considered, that the full implications of the theory were carefully thought out. So I wanted my views to get in front of the people who would be involved in, and the various lawyers who would be involved in those discussions. So I first raised these concerns verbally with Rod Rosenstein when I had lunch with him early in 2008. And he did not respond and was Sphinx-like in his reaction, but I expounded on my concerns. And then I later attempted to provide a written analysis as follow-up. Now, I initially thought of an op-ed, and because of the material, it wasn't working out, and I talked to his staff, and I said, you know, I want to follow up and send something to Rod in writing, but is he a one-pager kind of guy, or you know, how much will he read? And the guy said, he's like you. He doesn't mind wading into a dense
Don't you
legal
think
memo.
President Trump is a one-pager kind of guy?
Excuse me?
President Trump is a one-pager kind of guy.
I suspect he is.
Okay, just remember that. Go ahead.
Yeah. And so I provided the memo to Rod, and I provided it, distributed it freely among the other lawyers that I thought would be interested in it. And I think it was entirely proper. It's very common for me and for other former senior officials to weigh in on matters that they think may be ill-advised and may have ramifications down the road. For example, just a few months before that, I had weighed in repeatedly to complain about the idea of prosecuting Senator Menendez. I think I made 3 calls. I think it was 2 to Sessions, to AG Sessions, and 1 to Rosenstein. Now, I didn't know Senator Menendez. I don't represent Senator Menendez. No one was paying me to do it. And in fact, I don't support Senator Menendez politically. But I carefully watched this case. My friend Abby Lowell was his defense counsel, and it was very much like a line of cases that I had been concerned about when I was AG, and so I was watching it, and I thought the prosecution was based on a fallacious theory that would have bad long-term consequences, and so I freely weighed in at the department. And I did so because I care about the rule of law. And I want to say one final thing on the rule of law because it picks up on something you said, Mr. Chairman. What is the rule of law? We all use that term. In the area of enforcement, I think the rule of law is that when you apply a rule to A, it has to be the same rule and approach you apply to B, C, D, and E, and so forth. And that seems to me to suggest 2 corollaries for an attorney general. The first, that's why we don't like political interference. Political interference means that the rule being applied to A isn't the rule you're applying to A. It's special treatment because someone's in there exerting political influence. The corollary to that, and this is what you're driving at, Mr. Chairman, is that when you apply a rule, when a prosecutor is applying a rule to A, you've got to be careful that it's not torqued, especially for that case, in a way that couldn't be applied down the road, or if it is applied, will create problems down the road. And I think the Attorney General's job is both. It is both to protect against interference, but it's also to provide oversight to make sure that in each individual case, the same rule that would be applied broadly is being applied to the individual.
Thank you, Mr. Chairman. 6 quick yes or no questions. Will you commit to no interference with the scope of the special counsel's investigation?
I will, the scope of the special counsel's investigation
By not
is
limiting
set by his charter and by the regulations, and I will ensure that those are maintained.
Will you commit to providing Mr. Mueller with the resources, funds, and time needed to complete his investigation?
Yes.
Will you commit to ensuring that Special Counsel Mueller is not terminated without good cause, consistent with department regulations?
Absolutely.
If Special Counsel Mueller makes any request, for instance, about the scope of his investigation or resources for his investigation, will you commit to notifying Congress if you deny that request?
I think the regulations require notification of Congress if there's a disagreement.
Thank you. And I have 2 questions from the chairman of the House Judiciary Committee. Will you commit to making any report Mueller produces at the conclusion of his investigation available to Congress and to the public?
As I said in my statement, I am going to make as much information available as I can, consistent with the rules and regulations that are part of the special counsel regulations.
Will you commit to making any report on the obstruction of justice public?
That's the same answer.
Thank
Yes.
you. In your June 2018 memo about obstruction of justice to the Mueller investigation, you repeatedly referred to Mueller's, quote, sweeping and all-encompassing interpretation of Section 1512, which is a statute on obstruction. How do you know what Mueller's interpretation of 1512 is?
Well, as I said, I was speculating. I freely said at the beginning, I was writing in the dark, and we're all in the dark. Every lawyer, every talking head, everyone who thinks about or talks about it doesn't have the facts.
So I spent my Saturday reading that memorandum.
Yeah.
So are you saying this is all your speculation? It's a big memo.
Well, it was informed to the extent that I thought that was one of the theories being considered. And I don't know how seriously, whether it was being considered or how seriously it was being considered. But as a shorthand way in the memo of referring to what I was speculating might be the theory, I referred to it as Mueller's theory, rather than go in every time I mention it, say, well, this is
Do
speculative.
you know what Mueller's interpretation of 1512 is?
No, I don't know what Mueller's interpretation. But, and just one point, Senator, I think, you said in your opening statement, I said he was grossly irresponsible. I think I said if something happens, it would be grossly irresponsible. I was not calling Mueller grossly irresponsible.
I understand. Thank you. I appreciate that. Has anyone given you non-public information about Mueller's investigation?
I don't recall getting any confidential information about the investigation.
Your 2018 in it, you stated, and I quote, "The framers' plan contemplates that the president's law enforcement powers extend to all matters, including those in which he had a personal stake," end quote. Please explain what you base this conclusion on.
Yes. Here's the Department of Justice right here. And within the Department of Justice, enforcement decisions are being made. The president's over here. And I think of it as there are 2 categories of potential communications. One would be on a case that the president wants to communicate about that he has no personal interest in, no political interest in. Let's say the president's concerned about Chinese stealing trade secrets and say, I want you to go after this company that's being, that may be stealing trade secrets. That's perfectly appropriate for him to do, to communicate that. But whether it's bona fide or not, the Department of Justice's obligation and the Attorney General's obligation is not to take any action unless the Department of Justice and the Attorney General, reach their own independent conclusion that it is justified under the law, and regardless of the instruction. And that's my quote that everyone is saying I'm sicking the, it's okay for the president to direct things. All I said was, it's not per se improper for the president to call on the department for doing something, especially if he has no personal or political interest in it. The other category of cases, and let's pick an easy bad example, would be if a member of the president's family or a business associate or something was under investigation and he tries to intervene. He's the chief law enforcement officer, and you could say, well, he has the power, but that would be a breach of his obligation under the Constitution to faithfully execute the laws. So, in my opinion, if a president attempts to intervene in a matter that he has a stake in to protect himself, that should first be looked at as a breach of his constitutional duties. Whether it also violates a statute, depending on what statute comes into play and what all the facts are.
Including the emollients clause of the Constitution.
Well, I think there's a dispute as to what the emoluments clause relates to. I have not personally researched the emoluments clause. I can't even tell you what it says at this point. Off the top of my head, I would have said, well, emoluments are essentially a stipend attached to some office, but I don't know if that's correct or not. But I'm sure, I think it's being litigated right now.
I don't know either, so I'm going to try and find out. We'll come back another day and maybe discuss it. Your memo stated a fatal flaw in Mueller's interpretation of 1512C2 is that while defining obstruction solely as acting corruptly, Mueller offers no definition of what corruptly means. My understanding is that there's nothing in the public record that sheds light on his definition of obstruction. Do you know what his definition is?
I don't know what his definition is. I read a book where people were asking whether someone was, I don't know if it was accurate, but whether the president was acting with corrupt intent. And what I say in my memo is actually people don't understand what the word corruptly means in that statute. It's an adverb, and it's not meant to mean with the state of mind. It's actually meant the way in which the influence or obstruction is committed. That's its adverbial function in the statute, and what it means is, using it in the 19th century sense, it meant to influence it in a way that changes something that's good and fit to something that's bad and unfit, namely the corruption of evidence or the corruption of a decision maker. That's what the word corruptly means, because once you dissociate it from that, it really means very hard to discern what it means. It means bad. What does bad mean?
Let me go on because my time is so limited. You argue that and I quote, the Constitution's plenary grant of those powers to the president also extends to the unitary character of the executive branch itself. Specifically, you argue, and this is a quote, while Mueller's immediate target is the president's exercise of his discretionary powers, his obstruction theory reaches all exercises of prosecutorial discretion by the president's subordinates, from the attorney general down to the most junior line prosecutor, end quote. So if the president orders the attorney general to halt a criminal investigation for personal reasons, would that be prohibited under your theory?
Prohibited by what?
By
the Constitution.
the Constitution.
I think it would be a breach of the president's duties to faithfully execute the law. It would be an abuse of power. Whether it would violate a statute depends on all the facts and what statute someone would cite me to. But I certainly think it would be an abuse of his power. And let me just say that the position...
Would that be the same thing if an attorney general fired U.S. attorneys for political reasons?
No, because U.S. attorneys are political appointments.
According to news reports, President Trump interviewed you and asked you to be part of the legal team defending him in the Mueller investigation twice. First in the spring of 17, when the investigation was just beginning, and again earlier this year. Is that correct?
No, no. I had one conversation with him that related to his private representation, and I can describe that for you. That was in June of 2017. That's the only time I met him before I talked to him about the job of Attorney General, which obviously is not the same as representing him.
Have you discussed the Mueller investigation with the president or anyone else in the White House?
I discussed the Mueller investigation, but not in any particular substance. I can go through my conversations with you if you want.
Well, not at this time, but I may come back to you
Okay.
and ask you about that. I don't want to take any more time. Thank you, Mr. Chairman.
Senator Bratz.
Before I ask my first question, and I don't want you to respond to this, I just want you to know what my interest is in the transparency of the Mueller report. When we spend I don't know whether it's $25 million or $35 million, the taxpayers, that's billions of dollars, the taxpayers ought to know what their money was spent for. So if you've got some reservations about some part of it not being public, I hope that that's related to traditional things that of the public's business that shouldn't be public, like national security as an example, not being made public. But beyond that, the only way I know for the taxpayers to hold anybody that spends the taxpayers' money responsibly is through transparency, because that brings accountability. My first question, as you would expect from our conversation in my office, 86, Reagan signed the False Claims Act. I worked hard to get that passed, especially provisions empowering whistleblowers to help government identify fraud. More than a decade ago, you said the key TAM provisions in the False Claims Act were, your words, an abomination and were unconstitutional. You said you, in your words, wanted to attack the law, but the Supreme Court upheld the law's constitutionality. Prosecutors from both sides of the aisle have praised the law as the most effective tool government has to detect and actually recover public money lost to fraud. Since 1986, the law that was passed in 1986 brought in $56 billion into the federal treasury. Most of that's because patriotic whistleblowers found the fraud and brought the case to the attention of the government. Is the False Claims Act unconstitutional?
No, Senator. It's been upheld by the Supreme Court.
Do you consider the False Claims Act to be an abomination?
No, I don't.
Does the False Claims Act benefit the taxpayer, specifically its provisions to empower and protect whistleblowers?
Yes, Senator.
If confirmed, do you commit to not take any action to undermine the False Claims Act? Further, if confirmed, will you continue current Justice Department staff and funding levels to properly support and prosecute False Claims Act cases?
Yes, I will diligently enforce the False Claims Act.
Now, with all those positive answers, you'd think I'd be done, wouldn't you, with that? But let me go on. Just to show you that there is some forces out there that I'm suspicious about within the Department of Justice, we have a new Department of Justice guidance document out last year known as the Granston Memo. Provides a long list of reasons that the department can use to dismiss False Claims Act cases. Some of them pretty darn vague, such as preserving, these are their words, preserving government resources. Just think of all the mischief those three words can bring. Of course, the government can dismiss obviously meritless cases. I don't argue with that. But even when the department declines to participate in False Claims Act cases, the taxpayer can in many cases still recover financially. So it's important to allow whistleblowers to pursue cases even when the department isn't able to be involved. Under what circumstances can or should the Justice Department move to dismiss false claims cases?
Senator, I haven't reviewed that memorandum, so I'm not familiar with the thinking of the people in this. I think it's the Civil Division that did that, but if I'm confirmed, I will review it, and I would be glad to come and sit down with you and discuss it, and if there are areas you're concerned about, I'd be glad to work with you on that.
Unless you find that my presumption is wrong, that there's reasons to be suspicious, I hope you'll take into consideration my feeling about how, in various suspicious ways, people that are faceless bureaucrats can undermine this effort. In circumstances where the government doesn't intervene in false claims cases, if confirmed, will you commit to ensuring the department doesn't unnecessarily dismiss false act cases?
Yes, Senator, I will enforce the law in good faith.
Okay. Now, got an act that the Justice Department just took, and I can't obviously expect you to respond specifically to their act, but I use it as an example of their uncooperation with the Department of Congressional Oversight. This uncooperative behavior needs to change. On December the 10th last year, the department confirmed a briefing for your staff regarding asset forfeiture fund, and to do that last week, January the 8th. On January the 7th, Department of Justice, Office of Legal or Legislative Affairs informed our staff that they will no longer provide the briefing because they consider the matter closed as a result of the change in chairmanship, and because you released a public memo, because I released a public memo on the Marshal Service study or investigation. It's important to gain your commitment on how you would handle this as an example. Let me explain how ridiculous it is to get somebody in this administration saying that they don't have to answer if you aren't chairman of a committee. We went through this in January, the first month this president was in office, when he said, or he put out a memo, we aren't going to answer any oversight except for chairman of committees. So you're going to write off 500 members of Congress not doing oversight. So we told them all about this and the constitutional cases on this. We got them up. They wrote a memo again 2 months later that said that they were going to respond to all this stuff. Now you got people in the bowels of the bureaucracy that are still saying, if you aren't a chairman, you ain't going to get an answer to anything. How ridiculous. It's our constitutional responsibility. So then I laid out, I'll give you an example. I sent the Justice Department a classified letter regarding information acquired from the Justice Department Inspector General report on the Clinton investigation. The department ought to answer for what the Inspector General has found, but I haven't heard a peep, not a peep, on that yet. On December the 10th, the Justice Department, well, I'm repeating here. So the question is, do you understand that if you're confirmed, you have an obligation to ensure the Justice Department, and particularly the FBI is a problem, respond to congressional inquiries, and to do it in a timely manner?
Absolutely, Senator.
You understand that this obligation applies regardless of whether you're a member of Congress or a committee chairman?
Yes, Senator. You and Senator Leahy, I think, are the only members of the committee now who were here 27 years ago when I was first confirmed. But I think you will recall that we were able to establish very cooperative and productive relationships with all the members and try to respond to their questions and deal with their concerns and work with them on projects they're interested in. And that will be the same approach that I will bring to the job if you confirm me.
Okay. Then let me be specific on my last question on oversight. You remember when you were in my office, I gave you, as I gave Attorney General Sessions, as I gave Holder, a long list of things that the department has not answered. And one of these was an October 17, 2018 letter. And I'd like to have your response to answering that letter and respond to all outstanding and future oversight requests in a timely manner. And then, remember, I said, all you cabinet people come up here to tell us yes when we ask you if you're going to answer our stuff. I said, maybe you better say maybe. So if you want to say maybe now and be really honest, say maybe. Otherwise, I hope you'll answer that October 17th letter once we get you voted into office.
Yes, Senator.
Throughout your career, you've expressed concern with congressional attempts to enact criminal justice reform and at times advocated for stricter mandatory minimum sentences. In '92, under your direction, DOJ published a report entitled The Case for More Incarceration. This report declared that the problem with our criminal justice system was that we were incarcerating too few criminals. More recently, in 2015, you signed a letter opposing the Sentencing Reform and Corrections Act of 2015. This letter states quite clearly your opposition to sentencing reform, particularly the lessening of mandatory minimum sentences, any sort of retroactivity. The First Step Act was signed by President Trump. As Attorney General, it'll be your job to implement the legislation. Even though you've opposed criminal justice reform in the past, will you commit to fully implementing the First Step Act?
Yes, Senator. But you know, in 1992, when I was Attorney General, the violent crime rates were the highest in American history. The sentences were extremely short. Typically, in many states, the time served for rape was 3 years. For murder, time served 5 to 7 years. It was, the system had broken down. And I think through a series of administrations, Reagan, Bush, and Clinton, the laws were changed. And we targeted chronic violent offenders, especially those using guns. And I think the reason the crime rate is much lower today is because of those policies. So I don't think comparing the policies that were in effect in 1992 to the situation now is really fair. And I think, and I've said, that right now we have greater regularity in sentencing. There's broader recognition that chronic violent offenders should be incarcerated for significant periods of time to get them off the streets. And I think the time was right to take stock and make changes to our penal system based on current experience. So I have no problem with the approach of reforming the sentencing structure. And I will faithfully enforce that law.
Don't take it personal if I raise my voice to you. I'm not mad at you.
If I were you, I'd answer his letters just as sort of a tip that may help you through your job if you get it. I'll take the time away from my second round. I'm very curious about the conversations you had about personal representation being Attorney General. You mentioned it, Senator Feinstein. Can you kind of give us a summary of what you were talking about?
Yeah, so in June of 2017, middle of June, Ambassador David Friedman, who's the U.S. ambassador to Israel, who I didn't know. I knew that he was a top-tier lawyer in New York and apparently a friend of the president's. He reached out to me, and we talked one evening, and he said that my understanding was he was interested in finding lawyers that could augment the defense team, and failing that, he wanted to identify Washington lawyers who had experience, broad experience that whose perspective might be useful to the president's. And he asked me a number of questions like, what have you said about the president publicly? Do you have any conflicts and so forth? And I told him that I didn't think I could take this on, that I had just taken on a big corporate client that was very important to me and I expected a lot of work. And I said at my point in life, I really didn't want to take on this burden and that I actually preferred the freedom to not have any representation of an individual, but just say what I thought about anything without having to worry about that. And I said that my wife and I were sort of looking forward to a bit of respite, and I didn't want to stick my head into that meat grinder. He asked me if I would nonetheless just briefly go over the next day to meet with the president. And I said, sure, I'll go and meet with the president. And he brought me over and was squeezing me in. It looked to me like it was before the morning staff meeting because people were grouping by the door to get in, and I went in. And he was there, the ambassador was there, sat through the meeting. It was a very brief meeting where essentially the president wanted to know, he said, oh, you know Bob Mueller. How well do you know Bob Mueller? And I told him how well I knew Bob Mueller and how, the Barrs and Muellers were good friends and would be good friends when this is all over and so forth. And he was interested in that, wanted to know, what I thought about, Mueller's integrity and so forth and so on. And I said, Bob is a straight shooter and should be dealt with as such. And he said something to the effect like, so are you envisioning some role here? And I said, actually, Mr. President, right now I couldn't do it. My personal and my professional obligations are such that I'm unable to do it. So he asked me for my phone number. I gave it to him, and I never heard from him again until.
Well, I tried that once. You did better.
Well, I didn't hear from him until later, but about something different, which was the Attorney General position.
Thank you, Mr. Barr. Good to see you again. As you mentioned, Senator Grassley and I were here at your hearing a number of years ago. Let me go back even before that. 46 years ago, I was not in the Senate. I was state's attorney in Vermont, and I watched with a great deal of interest the Elliot Richardson hearings. He'd been nominated to be Attorney General in the midst of Watergate. He made several commitments to the committee, including appointing a special prosecutor, and he promised to protect his independence. And as one who had total independence as elected prosecutor in Vermont, I thought how important it was to have that same independence at the national level. And Mr. Richardson said it was necessary to create the maximum possible degree of public confidence in the integrity of the process. I've never forgotten that. But I think the integrity of our institutions is just as much at risk today. President Trump has made it clear he views the Justice Department as an extension of his political power. He's called on it to target his opponents. He obsesses over the Russian investigation, which looms over his presidency, may define it. He attacks the special counsel almost daily. He fired both the previous FBI director and attorney general for not handling the investigation as he pleased. That tells me the rule of law can no longer be taken for granted. So if confirmed, the president's going to expect you to do his bidding. I can almost guarantee you he'll cross the line at some point. That's why the commitments you make here today, just like those I watched Elliot Richardson make years ago, matter greatly. So will you commit, if confirmed, to both seeking and following the advice of the department's career ethics officials on whether you must recuse from the special counsel's investigation?
I will seek the advice of the career ethics personnel, but under the regulations, I make the decision as the head of the agency as to my own recusal. So I certainly would consult with them, and at the end of the day, I would make a decision in good faith based on the laws and the facts that are evident at that time.
Same thing if you're talking about a conflict of interest?
Well, no, some conflicts, as you know, are mandatory.
I'm thinking what Attorney General Sessions, and when asked a similar question, he said he'll seek and follow the advice. Seek and follow the advice of the Department of Justice's designated ethics officials. So let me ask you, maybe in a different way. I know you promised to not interfere with the special counsel. Are there any circumstances that would cause you to terminate the investigation or any component of it, or significantly restrict its funding?
Under the regulations, Bob Mueller could only be terminated for good cause, and frankly, it's unimaginable to me that Bob would ever do anything that gave rise to good cause. But in theory, if something happened that was good cause, for me, it would actually take more than that. It'd have to be pretty grave, and the public interest would essentially have to compel it, because I believe right now the overarching public interest is to allow him to finish.
I would agree with that, but I also think over the past 18 months, you rather harshly prejudged the investigation in some of your writings.
Well, I don't see that at all, Senator. You know, when you strip away a lot of the rhetoric, the two things that have been thrown up as me sort of being antagonistic to the investigation are two things. One, a very mild comment I made that, gee, I wish the team had been more balanced. I wasn't criticizing Mueller. I believe that prosecutors, and I think you would agree, they can handle the case professionally, whatever their politics are. You know, a good prosecutor can leave their politics at the door and go in and do the job. And I think that's what Justice Department prosecutors do in general.
But you also are very critical of the Russian probe. And I mean, I can't think of anything that would, in your memo, for example, that would jump out more for this president because of his commitment to it. And I ask that because some have said, on both sides, that it looked like a job application. And so that's what I want you to refer to.
Well, you know, that's ludicrous. If I wanted the job and was going after the job, there are many more direct ways of me bringing myself to the president's attention than writing an 18-page legal memorandum,
or
sending it to the Department of Justice and routing it to other.
But also publicly criticizing a Russian probe. I mean,
how have I criticized the Russian probe?
You don't have any criticism of the Russian probe?
Not at all. I think I believe the Russians interfered or attempted to interfere with the election, and I think we have to get to the bottom of it.
So you would be in favor of releasing the investigative report when it's completed?
As I've said, I'm in favor of as much transparency as there can be, consistent with the rules and the law.
Do you see a case where the president could claim executive privilege and say that parts of the report could not be released?
Well, I don't have a clue as to what would be in the report. The report could end up being, you know, not very big. I don't know what's going to be in the report. In theory, if there was executive privilege material to which an executive privilege claim could be made, it might, you know, someone might raise a claim of executive privilege.
That'd be pretty difficult following U.S. versus Nixon, when the Supreme Court unanimously rejected President Nixon's claims of executive privilege over the Watergate tapes. But I ask it because the president's attorney, Mr. Giuliani, said the president should be able to correct the Mueller report before any public release. So in other words, he could take this investigative report, put his own spin on it, and correct it before it's released. Do you commit that would not happen if you were Attorney General?
That will not happen.
Thank you. You had, when you're AG, I remember this well because I was here in the Senate at the time, you encouraged President George H.W. Bush to pardon all 6 individuals who were targeted in Iran-Contra. The independent prosecutor investigating the matter labeled that a cover-up. Now, you and I talked about this in my office, and I appreciate you coming by. I found the conversation the two of us had be well worthwhile. Do you believe a president could lawfully issue a pardon in exchange for the recipient's promise to not incriminate him?
No, that would be a crime.
Thank you. In 1990, you argued that Congress appropriation power is not an independent source of congressional power to control the allocation of government resources. There are only 3 committees in the Senate to have a vice chairman. Appropriations is one of them. Obviously, as vice chairman, I kind of looked at that. You claim that if a president finds no appropriated funds within a given category, he may use funds from another category, as long as both categories are in his constitutional purview. Now, this says Vice Chairman Appropriations Committee. Don't be surprised, I disagree. Congress's power of the purse, Article 1, Section 9, I believe constitutes one of the most fundamental and foundational checks and balances on the executive branch. So do you believe the president can ignore Congress appropriations allocations, conditions, and restrictions in law? Just ignore them and take the money and transfer it?
Not as a general proposition, but I just, that was a
general proposition.
I actually thought that was a good law review article. I gave it as a speech, and it was really a thought piece. And what I was really saying was, and I say right up front, that the more I thought about the appropriations power, the more confused I got. And I was just laying out a potential template, which is this. People frequently say, you know, the power to, you know, spend money on this division or this missile system is part of the power of the purse. And what I was actually saying was, you know, actually what the power being exercised there is the substantive power that Congress has to raise armies. And it's not, it doesn't come from the power of
specific appropriations on agriculture or on defense. I mean, for example, could a president just build a wall along our southern border because he wanted to and just take the money, whether appropriate or not? What about eminent domain?
What about eminent domain?
Well, if you're going to build a wall, you got to take a whole lot of land away from landowners in Texas and elsewhere.
Well, you know, you'd have to show me what statute is being invoked and also what appropriations is being used. I can't answer that in the abstract.
So you're saying the president, though, can have the power to go into money even if the Congress is appropriated for a different purpose?
I didn't say that. But some
You mean that?
I don't mean that. I'm saying that you know, there are monies that the president may have power to shift because of statutory authority.
But that would have been because Congress gave him that authority.
Right.
Not because he has it automatically.
I'm not taking that position. As I said, my law review, it was published as a law review article, and it was a thought piece exploring what limits there might be to the appropriations power and where Congress's power comes from in certain areas.
Thank you. Thank you, Mr. Chairman.
Just to follow up on that real quick, and I won't take this against the recording. To the Article 2 powers, the inherent authority of the Commander-in-Chief, give him the ability to take appropriated dollars for the Department of Defense and build a wall?
I can't, without looking at the statute, I really couldn't answer that.
I'm not talking about a statute. I'm talking about the inherent authority of the President as Commander-in-Chief.
That's the kind of question I would go to OLC to answer.
Okay. Get back with us on that. Senator Corn.
Well, Mr. Chairman, let me congratulate you on your election as chairman of the Judiciary Committee and tell you we look forward to working with you and supporting this committee's efforts. Thank you for convening today's hearing. And I want to express my profound and sincere thanks to the nominee, Mr. Barr, for agreeing to serve a second time as Attorney General. I noted in your statement, you said it was 27 years ago that you sat in this chair and went through your first confirmation hearing. And to me, that says a lot about your character and your commitment to the rule of law, that you would be willing to go through this process again and serve once again as the chief law enforcement officer of the country. Thank you for doing that.
Thank you, Senator.
Thank you to your family as well. To me, the Attorney General is one of the most challenging cabinet offices to hold because, as you point out in your opening statement, you are committed to the rule of law and enforcing the laws of the land, but you are also a political appointee of a president. If you are serving another cabinet position, certainly you're committed to implementing the president's agenda or the agenda of an administration, but as Attorney General, that is not an unequivocal commitment, because there may be some things that the administration wants you to do that you cannot do consistent with the rule of law, correct?
That's right, Senator. One of the reasons I ultimately decided that I would accept this position if it was offered to me was because I feel that I'm in a position to be independent. You know, over the years, a lot of people have, some politicians have called me up saying, you know, I'm thinking of going for the Attorney General position in this administration and so forth. And I say, you're crazy. Because if you view yourself as having a political future down the road, don't take the job. Because if you take this job, you have to be ready, you know, to make decisions and spend all your political capital and have no future. Because you have to have that freedom of action. And I feel I'm in a position in life where I can do the right thing and not really care about the consequences, in the sense that I can truly be independent.
Mr. Barr, thinking back about the run-up to the 2016 election, where the nominee of both political parties for President of the United States ended up being investigated by the FBI, can you think of any precedent in American history where that's occurred that you know of?
No, I can't, Senator.
And thinking back to James Comey's press conference of July the 7th, 2016, where he took the step of talking about the evidence against Mrs. Clinton, talking about the legal standard that would apply as to whether she might or might not be indicted for committing a crime under the Espionage Act. Have you ever seen a situation where an FBI director would usurp the authority of the Department of Justice to make that charging decision and hold a press conference and talk about all of the derogatory information that the investigation had gleaned against a potential defendant, and then say, now we're not going to, no reasonable prosecutor would indict her? Have you ever seen anything like that happen before?
No, I've never seen that, and I thought it was a little bit, more than a little bit. It was weird at the time, but my initial reaction to it was, I think Attorney General Lynch had said something, you know, she was under pressure to recuse herself, I think, because of the so-called tarmac meeting. Right. And I think she said something like she was going to defer to the FBI. Mm-hmm. So my initial reaction to that whole thing was, well, she must have agreed, or it must have been the plan, that he was going to make the decision and go out and announce his decision.
Under the normal rules, if the Attorney General has a conflict of interest,
it would go to the deputy.
It would go to the deputy,
correct,
not to the FBI director to make that decision, correct?
Right, so that's why I thought it was very strange, but I think later it became clearer, to the extent there's anything clear about it, that I don't think Attorney General Lynch had essentially delegated that authority to the director. And I think Jim Comey is as I've said, is a extremely gifted man who's served the country with distinction in many roles. But I thought that to the extent he actually announced a decision was wrong. And the other thing is, if you're not going to indict someone, then you don't stand up there and unload negative information about the person. That's not the way the Department of Justice does business.
I was shocked when Mr. Comey later wrote a letter saying that based on the discovery of Clinton emails on the Wiener laptop, that they were reopening the investigation that he had already announced closed. And then finally, just days before the general election, November the 6th, 2016, said we didn't find anything on the laptop that would change my conclusions based on the press conference of July the 6th. Did you likewise find that to be an extraordinary, I will use the word bizarre, but certainly unprecedented event?
Yeah, the whole sequence was very herky-jerky and bizarre, but at that time, I was a little of a contrarian in that I basically took the position that once he did what he did in July and said the thing was over, and then found out it wasn't over, he had no choice but to correct the record. So I said that he had no choice but to do what he did, but it sort of shows you what happens when you start disregarding the normal procedures and established practice, is that you sort of dig yourself a deeper and deeper hole.
Why is it that the Department of Justice rules, which also apply to the FBI, make it clear that our chief law enforcement agencies in this country should not get tangled up in election politics? Are there policies in place that try to insulate the investigations and the decisions of the Department of Justice and FBI from getting involved in elections?
Yes, Senator, there are.
And why is that?
Well, obviously, because the incumbent party has their hands on among other reasons, they have their hands on the levers of the law enforcement apparatus of the country, and you don't want it used against the opposing political party.
And that's what happened when the counterintelligence investigation of the Trump campaign began in late July and continued on through, well, presumably to Director Comey's firing and beyond.
Well, I'm not in a position to, make a judgment about it because I don't know what the predicate was for it. I think I said, it's strange to have a counterintelligence investigation of a president, but I'm not, I just don't know what the predicate is, and if I'm confirmed, I assume I'll find out.
Rod Rosenstein's memo recommending the termination of James Comey as FBI director was dated May the 9th, 2017. It's entitled Restoring Public Confidence in the FBI. I take it you've read the memo, and do you agree with its conclusion?
I completely agree with Rod Rosenstein, and I thought the important point he made from my standpoint was not the particular usurpation that occurred, but it was, as I think he says, that Director Comey just didn't recognize that was a mistake, and so it was going to potentially be a continuing problem, that his appreciation of his role vis-a-vis the Attorney General.
As I said, the title of the memo is Restoring Public Confidence in the FBI. Do you agree that restoration of public confidence in the FBI and Department of Justice as a apolitical or non-political law enforcement organization is important?
It's critical
and needed.
It's critical, and that's one of the reasons I'm sitting here. I'd like to help with that process.
Well, Mr. Barr, I think you're uniquely qualified to do that, and I wish you Godspeed.
Thank you, Senator.
It couldn't be more important. Thank you.
Mr. Barr, we've never had a chance to meet, but I welcome you to this committee.
Thank you.
You seem like a rational person. I'd like to ask you a question. When you consider what Jeff Sessions went through as the Attorney General for President Donald Trump, where he was subjected to unrelenting criticism, primarily because, as a matter of conscience, he decided he had a conflict of interest and should remove himself from any decisions by the special counsel concerning the Russia investigation. When you consider that this president has lashed out on a personal basis against federal judges who ruled against his administration, when you consider the criticism which he has leveled at the chief law enforcement investigative agency of the Department of Justice, the FBI, as well as our intelligence agencies, when you see the exit lanes glutted those leaving the White House at every single level. Why do you want this job?
Well, because I love the department, I love and all its components, including the FBI. I think they're critical institutions that are essential to preserving the rule of law, which is the heartbeat of this country. And I'd like to think that there was bipartisan consensus when I was last in this position, that I acted with independence and professionalism and integrity, and I had very strong and productive relationships across the aisle, which were important, I think, to trying to get some things done. And I feel that I'm in a position in life where I can provide the leadership necessary to protect the independence and the reputation of the department and serve in this administration.
A number of my colleagues on both sides have asked, and I'll bet you'll hear more, questions along the line of what would be your breaking point? When would you pick up and leave? When is your Jim Mattis moment when the president has asked you to do something which you think is inconsistent with your oath? Doesn't that give you some pause as you embark on this journey?
It might give me pause if I was 45 or 50 years old, but it doesn't give me pause right now because I had a very good life. I have a very good life. I love it. But I also want to help in this circumstance, and I am not going to do anything that I think is wrong, and I will not be bullied into doing anything I think is wrong by anybody, whether it be editorial boards or Congress or the president. I'm going to do what I think is right.
You have a very nice family behind you.
Thank you.
I'm glad you introduced.
Thank you, sir.
And I don't want to give your grandson any career advice. He's received quite a bit this morning already. But he ought to consider, at least for some balance, being a public defender. One of the things that you alluded to as a major issue of concern is immigration. I'm glad you said it. Our government is shut down now over the issues of border security and immigration. And the Attorney General plays a central role, which many people don't know as they look at the Department of Homeland Security for most of the action on the issue of immigration. I was surprised at the exit interview by General Kelly when he said, and I'm paraphrasing, that Attorney General Sessions was responsible for the zero-tolerance policy that was announced in mid-2018, and that it was because of that policy, that was one of the reasons why he was being asked to leave. That's the first I'd ever heard. Are you familiar with the zero-tolerance policy?
Generally, Senator, yes.
I can tell you that it was an effort to take escorted children, infants, toddlers, and children, and forcibly remove them from their parents at the border. This policy by our government separated up to 2,800 of those children and put them into the system, the same system as unaccompanied children. The results were horrible. I saw them firsthand. And you have alluded in your opening statement to stopping people from crashing through the border, breaking and flouting the laws. Those young children, for the most part, were being brought to this country by their parents to seek asylum. You can present yourself at America's border and seek asylum legally, can you not?
Yes, Senator, you can.
So separating those children from their parents in an effort, as Attorney General Sessions explained, to get tough with families presenting themselves at the border was a policy decision on his part. Do you agree with that policy decision?
Well, I'm not sure I know all the details because one of the disadvantages I have is I'm not in the department and don't really have the same backing I did in terms of information that I had last time. But my understanding is that DHS makes the decision as to who they're going to apprehend and hold. Now, you can claim asylum, but that doesn't mean you can waltz into the country freely.
Of course not.
Okay, and you have to be processed. And my understanding is a majority of people do not qualify for asylum. But DHS makes a decision who to hold and charge with the crime of illegal entry. And then they refer it to the Department of Justice. And I believe the department's policy, when the department says zero tolerance, they're saying whatever DHS refers to us in the way of illegal entry prosecutions, we'll prosecute. Now what is being done, because I think the administration has changed the policy, is DHS is not referring for prosecution family units that would lead to the separation of children from the family unit.
It's true that the president and the administration abandoned the policy after there was a public reaction to the separation of these children. I'm concerned, I want to go back to your University of Virginia Miller Center speech, which is...
It's a gem, isn't it?
It's a classic, and it goes back many years. But you described your previous tenure as Attorney General, and you said, after being appointed, I quickly developed some initiatives on the immigration issue that would create more border patrols, change immigration rules, streamline processing. It would furthermore put the Bush campaign ahead of the Democrats on the immigration issue, which I saw as extremely important in 1992. I felt that a strong policy on immigration was necessary for the president to carry California, a key state in the election. That's a pretty revealing statement about a political agenda.
Yeah, there's nothing wrong with that, because as I've said, you know, the attorney, and I've spoken on this a number of times, there's sort of three roles the Attorney General plays. One is the enforcer of the law, and that the role of the Attorney General is to keep the enforcement process sacrosanct from political influence. The second one is as legal advisor, and that is in the Judiciary Act of 1789, legal advisor to the President and the Cabinet. And there I say the Attorney General's role is to provide, you know, unvarnished, straight-from-the-shoulder legal advice as to what the Attorney General believes is the right answer under the law. And then the third role is the policy role, which is law enforcement policy, which includes immigration policy. And there you are a political subordinate of the President, and it's okay to propose policies that are politically advantageous.
Well,
but I have to say that, you know, that was casual conversation. The point was, I was pursuing a strong immigration policy even when I was deputy, long before, you know, the election was on the horizon. And in traveling around the country, visiting the border, paying a lot of visits to California, I saw how important the issue was, and I thought the administration had to be more responsive to it. And yes, there was a political benefit to it.
I just have a short time left. The chairman, our new chairman, congratulations, Graham, noted 10 years of work by a number of us on this committee on a bipartisan basis to deal with criminal sentencing and prison reform. And the First Step Act, signed by the President around Christmas, I think is a significant departure. I learned, as many have, that the approach, the Get Tough approach that we imposed with 100-to-1 sentencing disparity between crack and powder didn't work. Did not work. The number of drugs being sold on the street increased. The price of the drugs went down. The people being incarcerated went up dramatically. And we learned the hard way. That was not the way to deal with the issue. And now we're trying to clean up 10 years later, more 25 years later, from the 100-to-1 disparity. I voted the wrong way on 100-to-1. Now I know, in retrospect. You've made some hardline statements about this issue in criminal sentencing in the past. And many of us believe, on a bipartisan basis, we've got to look at this anew and not repeat these mistakes again. So I would like to hear your assurance that you have learned, as I have, that there is a better way, could be a more effective way, and that as Attorney General, you will help us implement the First Step Act and design the second step.
Absolutely, Senator. From my perspective, the very draconian penalties on crack were put into place initially because when the crack epidemic first hit, it was like nuclear weapons going off in the inner city. And as I think you'll recall, a lot of the community leaders at that time were saying, you gotta, you know, this is killing us, you have to do something. So the initial reaction of draconian penalties was actually, you know, trying to help those communities. And over time, and now the same leaders are saying to us, this has been devastating, you know, generation after generation of of our people are being incarcerated, have been incarcerated and lost their lives because of this, and you have to change the policies. And I think that is, we should listen to the same people we were listening to before. I supported generally strong penalties on drugs because, not just crack, because I felt the money involved was so high that, you needed something to counteract that. I also said repeatedly over the years of the drug war that I felt that the head of the snake is outside the country. And the place to fight this aggressively is at the source more than on the street corner. And I used to say we could, stack up generation after generation of people in prison, and it'll still keep on coming. And so I always felt that, and I support a adjustment to these sentences and the safety valve and so forth. To me, the corollary is we have to really start thinking and using all our national forms of power in the sense of our diplomacy and our economic leverage and so forth to get better results overseas. So, for example, now fentanyl is sort of the new crack. Fentanyl and fentanyl analogs are sort of the new crack, and they're coming in from China. So,
Across the Mexican border.
correct. Correct.
At ports of entry, 90%.
So that's a long-winded answer to your question, which is I understand that things have changed since 1992. I held on a little bit longer to keeping strong sentences maybe than others. Part of that was I wasn't involved in the business anymore. I wasn't at Justice Department looking at reports and studies, learning about different things in the country. I was, arguing with the FCC about telecommunications rules. So,
Ms. Barr?
yes.
That was a great answer, and it was long-winded.
Okay.
Senator Lee.
Mr. Barr.
After this, we'll break to 12:15 for lunch and a comfort break.
Mr. Barr, thank you very much for your willingness to spend time with us today and your willingness to be considered for this important position yet again.
Thank you.
Great to have your family here. And I can't help but comment, a lot of people have talked about Liam today, probably more than any of his other friends or classmates, people of his age cohort. People are thinking about what he might do for a living. Unlike some of my colleagues who have suggested medicine, I want to just sort of suggest what I've suggested to my 3 children, which is that I'm not going to push them into any career choice, which in our family means that you can be any kind of lawyer you want. Just keep that in mind with Liam. I'd like to talk to you first about civil asset forfeiture. As you know, civil forfeiture and criminal forfeiture are 2 very different things, 2 very different species of government taking someone's asset. With criminal forfeiture, of course, the government's ability to take something away is predicated upon a conviction of a crime. With civil asset forfeiture, that happens even in the absence of a conviction. There are some serious questions, of course, regarding the legality and constitutionality of civil asset forfeiture. Justice Thomas, for example, has questioned whether some of these practices are constitutional. I was encouraged to note that in your testimony in 1991, you identified this as an issue. When you testified before this committee, you criticized what you described as the speed trap mentality of forfeiture. Your point was that, quote, agencies should not feel that just because they seize money, they're going to get the money, close quote. Now, since 1991, I've seen our government, our law enforcement agencies actually move more toward this sort of speed trap mentality rather than away from it, as many of us would have preferred. Too often, law enforcement agencies have too strong an incentive to use civil asset forfeiture in a way that lines their own coffers outside of the relevant appropriations process. So let me just ask you the question: Do you think that the speed trap mentality is a problem? And if so, is that something that you'll work to address within the Department of Justice if you're confirmed?
Yes, I think constant vigilance is necessary because, there are incentives there that should be of concern in administering the law. And I understand that there are some people who are concerned about it, have some horror stories. The people at the Justice Department have been trying to clamp down. I think Attorney General Sessions put out some guidelines that were supposed to address that. I haven't gotten into it myself. I plan to get into it and see exactly, what the horror stories are, where the problems and potential abuses are, and also whether Attorney General Sessions' guidelines are providing sufficient protection. At the same time, I think it is a valuable tool in law enforcement, and the state and local law enforcement officer, our partners, it's very important to them. So I want to make sure we strike the right balance, and once I have a chance to review it, I'd be glad to come up and talk to you about that.
Thank you. I appreciate that. I understand that it's a tool that many consider valuable, but a tool that can be considered valuable for some of those same reasons. Something that's considered valuable to the government can, in many instances, jeopardize an individual right that is protected under the Constitution. We've got to be careful of that. When you refer to the partnership that sometimes takes place between state and federal authorities, this is sometimes where we see it abused. In the case of procedure known as equitable sharing, where sometimes state law might prohibit the use of civil asset forfeiture under certain circumstances. And in those circumstances, those state law enforcement agencies might work with federal law enforcement for the specific purpose of evading state law that would otherwise prohibit that. So I hope that's something you'll look into as well.
Yes.
Let's talk about antitrust for a minute. Along with Senator Klobuchar, I chair the antitrust subcommittee. And as I'm sure you're aware, there are a growing number of people who take the position, who embrace the viewpoint that we should use antitrust law to address a whole host of social and economic harms, to, among other things, to ensure that companies respect the First Amendment, or to prevent large companies from becoming too big, or to shape labor markets, or to conform industries to a particular aesthetic, or achieve some other broadly defined social interest. I'd like to know what your view is on this. Are you a believer in the sort of big is bad mentality, or do you gravitate more toward the idea that our antitrust laws are there to protect consumers and should focus on consumer welfare and prices that consumers face?
Yes, I mean, generally that's where I stand, which is the purpose of the antitrust laws, obviously, is to protect competition, and that it is competition that ultimately redounds to consumer benefits. At the same time, I'm sort of interested in stepping back and reassessing or learning more about how the antitrust division has been functioning and what their priorities are. I don't think big is necessarily bad, but I think a lot of people wonder how such huge behemoths that now exist in Silicon Valley have taken shape under the nose of the antitrust enforcers. And you can win that place in the marketplace without violating the antitrust laws. But I want to find out more about that dynamic.
Right. Yeah, and in some circumstances, a company that becomes too big ends up behaving in a way and exerting market dominance in a way that impairs consumer welfare anti-competitively. In other circumstances, consolidation can bring about lower prices and increased competition. I assume you wouldn't disagree with either of those statements.
No, Senator.
As you know, and as several of my colleagues have mentioned, President Trump signed into law the First Step Act about a month ago. This is legislation that I applaud and legislation that I've been working on in one way or another for 8 years, and was pleased to team up with Senator Grassley, Senator Durbin, Senator Booker, and others to work on that over the course of many years. As you know, the Attorney General has an important role under the First Step Act in appointing members to something called the Independent Review Commission. That Independent Review Commission will make recommendations concerning which offenders might be eligible for earned credits under this legislation and which programs will be approved. When we drafted this legislation, there were some members who were concerned that whoever was the Attorney General at the time of this law's passage and implementation might be able to undermine the effectiveness of this law by appointing members who didn't agree with or believe in the objectives of the bill. So will you commit to me, Mr. Barr, that you will appoint people to that Independent Review Commission who are honest brokers to decide which offenders should be eligible and which programs should be eligible to participate?
Yes, Senator.
Thank you. You familiar with the Ashcroft-Sessions policy, namely the policy requiring prosecutors to charge the most significant readily provable offense?
Yes, Senator.
Tell me how that should best be balanced out with the discretion of a prosecutor, most frequently, of course, with the discretion of a local U.S. Attorney's office.
Well, I was going to say, I think the best way of balancing it out is to have a supervisor who is able to approve departures from that policy based on the specific circumstances. And there are countless different, permutations of facts that might justify a departure from it. So I think it's best handled by supervisory people. But I also think it has to be looked at centrally. I'm not saying that each case has to be approved centrally, but there has to be some monitoring of what's going on because, as you know, one of the things that led to the sentencing guidelines was, just big differences in the way the laws were being applied and enforced around the country. And I think we need to try to strive for as much uniformity as we can.
But you intend to continue that policy?
Yes.
And
unless someone tells me a good reason not to.
If I'm understanding you correctly, you're saying that if you do follow it, you will defer to the judgment of the office in question in the case of determining when to not charge the most serious readily provable offense.
No, I mean, I won't defer to my subordinates. I mean, I'm not going to say, yeah, I will defer to my subordinates. I mean, usually you do defer to your subordinates, but there might be a case I disagree with, and I'll assert myself on it.
Okay. I see my time has expired. Thank you, sir.
Thanks, Senator Lee. We'll take a recess to 12:15 and start with Senator Whitehouse when we come back. Go ahead.
You're watching live coverage from the Washington Post as William Barr faces questions from the Senate Judiciary Committee. As you heard the chairman say, they'll break for about 45 minutes, and we will be with you until they come back. You see there Senator Klobuchar talking with Senator Graham. Senator Klobuchar is one of the many Democrats. We are waiting for her questions, and we know that they will have some real consequences here, both in terms of where the Mueller investigation goes and how this Attorney General nominee is seen by Democrats as well as Americans. My guests right now are Devlin Barrett and Aaron Blake. Thanks so much to both of you for being with me. I'm Libby Casey. I want to start off with just some of the big headlines that have come out from this so far. Devlin, what are your takeaways in terms of William Barr's ability to reassure Democrats who might have concerns about protecting the Mueller probe, and yet also what signals is he sending to Donald Trump and his allies?
I think a lot of the signaling he's doing right now is to try to assure the public and Democrats, I'm a good guy. Like at one point he said, he was talking about a conversation he had with the president, and he said, the Barrs and the Muellers have been friends for 30 years, and when all this is over, the Barrs and the Muellers are still going to be friends. And I think there is, aside from the lawyerly language, I think there is a body language here, and the body language is trying to say, look, I've been around a long time. I really don't care that much about if I don't have any future political ambitions. I don't have any career goals for myself. I'm nearing retirement. I'm just going to be there to do a good job. And you don't need to worry that I've got some ulterior motive or some larger plan, and I'm going to throw the Justice Department under the bus for that.
It sounded like, Aaron, if you were younger, that he would not be interested in this job, and in fact that he was advising other people that you may not want to do this job because it could be politically loaded. But he's said a couple of times, I've got nothing to lose and I only have my integrity essentially to retain through this process. So
Right.
I can be the one who can stand up for my principles here.
I thought that was maybe his best argument in this whole thing. I mean, it's not a totally novel way of arguing about things. We probably would have expected it. But he said, I feel I'm in a position where I can do the right thing and not really care about the consequences. In that sense, I can be truly independent. He added, I have a very good life. I have a very good life. I love it, but I also want to help in this circumstance, and I am not going to do anything that I think is wrong. And importantly, I will not be bullied into doing anything that I think is wrong. I am going to do what I think is right. Not that you'd expect somebody to say, come out and say, I can be bullied. Yeah, that's fine. If you push me hard enough, I will give in. But I also thought it was interesting, as strong as those statements were, there was another moment in there where he was also talking about this subject, and he allowed for the possibility that if he was in his 40s, he might be thinking about these things differently. You're not supposed to admit that kind of thing. You're not supposed to say, if I was ambitious, I would be handling these things differently, or I would be thinking about them differently. But, you know, that's kind of, you know, that's the past, this is the present, and that's an argument that I think actually works for him and could maybe allay some of the Democratic concerns. He has signaled that he doesn't have further ambitions. He has made that clear. He even said in his opening statement that he is not going, you know, he didn't want this job necessarily. You know, exactly how independent he would be once he's Attorney General, I mean, that's for us to figure out once he actually gets there.
Unsurprising, and we've heard this before from people who are put into positions of power or potential positions of power. I didn't go looking for this job. You know, I was perfectly fine. This sort of came to me. And yet he did, according to Democrats, from their perspective, have a bit of an audition over the past year, Devlin, when he sent this memo out that was shared widely, as well as with members of the president's own team, as we found out more information about last night, asserting his position on James Comey and making some statements about what he thought of the Mueller investigation. So some people did see that as sort of a resume flag in some ways.
Right, and he seems to push back very hard on the notion that, like, well, his argument is it's absurd to think that I would be auditioning for the job of Attorney General by talking to a bunch of people about the Mueller investigation. Like, if I want to audition for a job, his argument is essentially, if I want to audition for a job, I know how to audition for a job, and this ain't it. I don't know how good a sales pitch that is, but it was one thing that really jumped out at me is he said something really interesting about the Comey conversation that I think could have significant implications for the Mueller work. And he was asked to essentially give his opinion on how Comey handled the Hillary Clinton email investigation. He was very critical, and at one point he said, and you know, at the Justice Department, if we're not going to indict someone, we don't offer a bunch of negative information about them. That's not how we do business. Well, that has potentially huge implications for the Mueller investigation. If Mueller decides that he is, you know, finishes his work charging X number of people, and he's not going to speak, you know, by Barr's logic, Mueller may then not speak at all beyond what he has put in the indictments, other than to say, we looked at the following issues and we did not find chargeable cases in them. The implications of that statement about Comey are pretty intense for the Mueller investigation, and I'm very curious if any of the senators follow up on that and say, so is there a line between those two things? And if so, what is that line? Because that could completely determine what he views as, again, to get back to his earlier expression, you know, as much transparency as the rules and the practices allow. You know, these two things could come together in a way that may surprise some people.
And by that logic, by the way, you know, the Justice Department guidelines that exist right now say that a president generally should not be indicted. So it may not even be you know, if we were to take that logic even further, if you don't believe a president can be indicted and you don't include anything if you're not indicting a president, that would preclude any of this information from being released publicly, no matter how damning it is. I'm not saying that's what his angle on this whole thing is, but like you said, this is something that some of the senators probably want to probe a little bit further.
We did get more of a sense of what sort of a background he has with President Trump and what conversations he may have had, and that came up a little bit. We heard Dianne Feinstein get to some of it, but then Lindsey Graham took an extra turn as chairman and said, well, let's lay out some of those conversations, give us a sense of what was discussed. So we did learn through this exchange that he did meet with President Trump to talk about potentially joining his legal team or having some role in his private legal team. And he was approached through a middleman, which is not surprising, Ambassador David Friedman, who's the ambassador to Israel. Did you learn new facts and new information about how that conversation went?
I did, and I think it's interesting because what happens is, so the ambassador reaches out to Barr and they have a conversation. And Barr basically says, well, I'm really not that interested, but I'll go to the White House tomorrow and talk to you about it. So he goes to the White House, he has the meeting with the president, and by Barr's account, the president asks him, well, what about Bob Mueller? What about his integrity? And Barr, in his accounting of it, defends Mueller as an honest guy, a straight guy, and he says something like, and he should be dealt with as such. And this is in 2017 when some of these issues are a lot more up in the air than they are now. And what's interesting to me about that exchange is obviously the president's public posture is that Mueller is not an honest guy and that, these are all the angry Democrats coming after him. So in that instance, he didn't really take Barr's advice or decided he didn't see it the same way. But it's pretty amazing to think that the likely future Attorney General had a private meeting with the president where he tried to convince the president that Bob Mueller wasn't a bad guy.
The president, according to Mr. Barr, said, something like, are you envisioning some role here? And Barr said, basically, no, I'm not at this point. I'm
It's
not.
a weird way to be asked to come for a meeting about a job and then say, like, so what role would you like here?
What would you like to be doing here? But that's also an interesting history and something that the committee will certainly be weighing. This relationship that William Barr and Robert Mueller have is important because they do have a long-term relationship, Aaron. It's something we haven't talked much about yet this morning, but you did get some sense of it during the hearing today. Their families are friends. They've attended family weddings. And as you guys said earlier,
Bob,
and he even in his testament, Bob, and he did make this point of we plan to be friends after this is long over. How much weight does that carry?
I think if you are concerned about the future of that investigation, it has to hearten you a little bit that the guy who would be overseeing it potentially would be friends with the guy who is running it. Obviously these decisions are supposed to be made irrespective of personal alliances. They're supposed to be made, according to what the actual law is. It was probably always a little bit fanciful that Barr was going to come in and immediately shut down Mueller or defund him, as Whitaker has talked about, or do anything like that. I think but that also misses the point here. The bigger question is not whether he allows Mueller to finish his job or does anything to prevent him from finding whatever is out there that's important and the American people need to know. It's what happens after the report is issued and it actually comes out. Are there indictments? Does the report get released fully? These are all things that are not really necessarily for Mueller to decide. These are things that are for the Justice Department to decide. And so William Barr can think that Mueller is great and has done a great job and has acted within his purview, but can still disagree with the idea that this is all something that needs to be out there and with some of the finer legal points that he could take issue with.
We had his prepared opening remarks, and we were, of course, following along as William Barr read from them. And there was one deviation. So we noticed that he said, as he talked about Russian interference in the election, he instead used the phrase Russian attempts to interfere in the election. And he mentioned that again in the back and forth exchanges with the senators, interference or attempts to interfere with the election. Why is that a significant change in words? And is it to you? Because I found it of interest.
I think it's interesting, but I think it also points to one of the things that gets mangled or debated, I guess is the nicer way to say it, in all of this, which is that obviously there's a pretty wide body of evidence at this point that the Russians engaged not just in information ops, but hacking and a bunch of other things designed to shift the election outcome. What Trump and his defenders have been saying from the beginning is there's no evidence to show that it worked. And that is essentially an unmeasurable thing in many ways. There are ways to measure it. There are polling data that you can look at that might give you some hint, but ultimately it's not an answerable question. And I take his use of the term attempted as to be kind of throwing the Trump camp a bone there to say, look, we're not going to argue again about ballots and vote counts and all that stuff, and we're not going to go down the road of like, a semantic, war of words here. And I take it as a little bit of a nod to the Trump sensitivities on like, well, did the interference actually change the outcome? Because we all know Trump and his people are incredibly sensitive on that score.
Yeah, and we've seen Mike Pompeo, when he was CIA director, actually misstated the conclusions of the intelligence community on this point. He said that there was no impact and that they concluded that. We have seen Kirstjen Nielsen, the head of Homeland Security, offer a very Trump-esque version of this. This is clearly something that all of these people are very interested in casting in a very specific way for the president's benefit. I don't think the way Barr characterized it was not as controversial or objectionable as the way some of them have stated it in the past, but the idea that he would change that, I'm glad you raised that because I didn't notice it in real time, the idea that he would interfere to attempts to interfere seems very much geared towards making sure the boss is not upset about it.
Let's go live to Capitol Hill, where reporter Rhonda Colvin is standing by. Hi, Rhonda.
Hi, Libby. Yes, we're here again with our staff writer, Karun Demirjian. Karun has been inside the hearing, listening out for some of the things that we talked about earlier of things to watch. And Karun, to you, what has been something that has happened that stood out to you in this first part of the hearing?
Well, you heard Barr give a very full-throated defense of his memo and the reasons that he wrote it. He's basically trying to present himself this whole way as somebody who is a guardian of the rule of law, who can be independent, because he's older, he doesn't have to worry about, is he going to get fired? Is he going to upset his career or anything like that? And that he can be somebody who's just going to stand up for I believe he said, the independence and the reputation of the Justice Department. The question is, does everybody on the panel actually believe him? I think that you are not hearing too much. You've not heard anybody, say that they don't, but you've had people question exactly why he thinks he can assure them of this, because it would represent a turnaround from past positions, given what he wrote in the memo about not thinking that the Mueller probe could wade into obstruction of justice issues on various items. He says that he was keeping the bigger picture of what would be the precedent to set in mind, not the specific circumstance, and that's going to be potential points of tension going forward.
Are Republicans doing a good job at establishing that he has this professional background? He's already held this position. I know Senator Hatch brought up the point about the Cuban hostage situation that happened in Alabama that sort of put him at the forefront the last time around when he was being confirmed for AG under Bush. Are they doing a good job at presenting those facts and possibly, calming the fears of Democrats who don't know if he is equipped to handle this job in this administration?
Well, I mean, look, the William Barr was Attorney General in the early 1990s. I think that there's been a lot of discussion about the history that he brings to this position, because he's been there for spanning almost 3 decades. He's been not consistently at justice, but has been a figure that has been involved in policies that we're looking at it from a different lens today. So in a way, yes, Republicans are doing a good job bringing up that history, but it's got a positive and a negative side, right? We heard a lot of discussion about immigration, even more discussion about criminal justice reform, because remember, in the early 90s, we were pursuing far more draconian policies than we're talking about today. That was when there was the ramp up, and it was the war on, the war on drugs was about to start, and sentences were being increased and were being made harsher. And we just came out of a period where we were talking and passing criminal justice reforms to try to mitigate some of that, to have a more fair approach, to try to reduce prison populations and make sure that people's lives aren't being destroyed for minor crimes. And so you saw a lot of that back and forth too, where there's people on the GOP side too that are critical of what Barr stood for and the positions he took for a long time. And he's explaining both he's explaining his past both as an asset and also as a learning experience and the learning curve that he's had. And so I think impressing upon people about why that's a sincere change of heart that he's had on certain issues. We just heard him talking about how fentanyl is the new crack of our time, but you can't fight it by talking about sentences in prison. You have to do diplomatic action and other things to try to stem the problem before it gets into the country. we're hearing him give an explanation and a reckoning, basically, of this is who I was, this is who I am now, here's why they're connected, but here's why a person can grow and change. And just generally speaking, I think part of that tone that he's trying to cast for himself, being a person that, doesn't have to, that is in a position where he can reflect and he can draw upon his history, I think is also informing the way he's trying to present himself vis-a-vis Trump and the Mueller probe, when he said, no one can bully me, not Congress, not the media, not the president. And I think he's trying to use that to as much as he can, and to make that case. I don't think the case will convince everybody, because there's certain people who feel very passionately about certain issues, ranging from the drug crisis to criminal justice reform to the Mueller probe. But he's certainly making an attempt at explaining himself, his own record in detail.
Do you find it interesting at all? I know I found it a little interesting that we have entered day 25 of the government shutdown, and that doesn't seem to be playing much of a role in this confirmation hearing. He did mention it in his opening remarks, that his thoughts are with those who are furloughed, especially in the FBI. Did you think that was very interesting, that nothing really has come up about the fact that we are still in the middle of a shutdown?
I mean, right, he mentioned it. Durbin gave a little bit of lip service to it by talking about how we're in a shutdown right now because of the border, and I thought that Barr kind of dodged some of those border questions by deferring the policy questions he got to choices made by Homeland Security and not the Justice Department. I'm sure other Democrats are going to come back to that down the line. But yeah, I mean, look, this is the kind of parallel reality we're existing in right now, which is that this is a shutdown that is definitely gripping the headlines, but has not crippled every single part of the government. And so it's like business proceeds sort of as usual in some facets, as we're talking about the shutdown and how to end it, and it's going on and on and on. And so right across, not even across the Capitol, in different parts of this side of the Capitol, people are working on that issue, but it doesn't really seem to be trickling its way into here. And that's just, I don't know if that's just because of what I was saying about this being a quarter of the government and not the whole government, or if it's just, the sense of our time right now, where we juggle so many things and so many just happening at once, and there's so many crises at one time that you have to kind of separate them out in your head, and that seems to be what's going on here. But I'm sure we'll hear further mentions of that, and I would bet that we would hear quite a few more mentions of immigration policy, and that is at the core of what the shutdown debate is about. And if you start talking about immigration, I don't see how at least the Dem side of that bench doesn't also make a few more punches about the shutdown and how they don't think it has to be happening right now.
Yeah, good point. Thank you very much, Karun, for joining us again. And I'll send it back to you in the studio, Libby.
Thanks a lot, Rhonda Colvin, live on Capitol Hill. Let's talk about some of these important issues that Karin and Rhonda raised that are different than the Mueller probe, but still very important and large in senators' minds, namely criminal justice reform, immigration. A couple of things Bill Barr really did dodge. I mean, he was asked not just by Democrats, but by Republicans about immigration issues. Lindsey Graham asked about the money for the border wall. Does the president have the authority to redirect money to fund a border wall? And he didn't give an answer on that, Devlin.
Yeah, I mean, that's a tough one. It's a politically tough one. That's a legally tough one. I was not surprised that he dodged it, because you would be throwing basically a live grenade into what's otherwise a fairly rational room right now. So I don't expect him to take a role in it, but you could see the Justice Department, at least in the form of the Office of Legal Counsel, which offers opinions on these things, weighing in important ways as this goes on. We just don't know. But frankly, I think from Barr's point of view, the real world, the brass tacks of it is, I think from his point of view, you probably just figure this could all be resolved by the time I even get there. I am not, taking any shots on this.
There's really no incentive for him to weigh in on that. He also had a similar answer when he was asked about the emoluments clause. He basically said, I haven't even looked at it. I couldn't tell you what it says, which, I mean, I think we all have a general sense for what it means, but maybe he doesn't want to answer that question. Look, this hearing is going to be about Democrats getting him to say something that is going to be operable later, or make some kind of a mistake when he's talking about recusal, things like that. He is not going to weigh into policy issues where he doesn't have all the information, and that the things he says are going to come back to bite him later on, or affect the things that he is able to do as Attorney General. This is something that we see in all these hearings, and it's frustrating that these people cannot weigh in on specific policies and offer legal rationales for things that they haven't studied yet, but this is how it's now done, and people get confirmed anyways. So there's really no incentive for him to go down that road.
Senator Dick Durbin complimented Bill Barr and said, you seem like a rational person. And then he went through a list of people who've chosen to leave the administration. He talked about seeing what the former Attorney General Jeff Sessions went through in terms of feeling the criticism of President Trump personally. Senator Durbin called it unrelenting criticism, and then the criticism that President Trump has lobbed at the FBI and intelligence agencies, and basically said, "Why do you want this job?" But Bill Barr seemed ready to answer that. He didn't seem thrown by that question.
Yeah, that's where we got into the "I will not be bullied" answer, which I thought was a good way to respond to it. But on the other hand, even if you aren't ambitious for future jobs, if you are in Bill Barr's situation, you have to worry about your legacy to some extent. This is going to be his last major high-profile job. It is a pressure cooker. It has shown pretty much most members of the president's cabinet have found themselves on the wrong side of him a time or two. There is a real possibility that regardless of what Bill Barr, where he is in his career, that this could be a career-defining job for him. And so regardless of whether you can be bullied or not, there have to be considerations there for you personally that this is something that people will remember you for. And so being on the right side of that history has got to be something he's concerned about.
And Dick Durbin had this sort of soundbite moment where he said, colleagues have been asking, what's your breaking point? What's your Jim Mattis moment? So he's trying to sort of create this phrase of the Jim Mattis moment. And once again, Bill Barr was able to sort of bat that down by talking about his long career and being very comfortable where he's at. But even that turn of phrase is interesting. I mean, Dick Durbin's really trying to paint a portrait of an administration with a president that's very critical of people who even come on his team and the defections that have happened from the White House in the past year.
Yeah, it's interesting. When you talk to folks who have known Bill Barr a long time, one of the things that comes up quite a bit is how often he will not take much guff. And so, I had one conversation with someone who said, if the president yells at him, there's a 50-50 chance in my mind that Bill Barr just yells back. And I don't know how much of that the president experiences. I only have to worry about one corner of the government. But I do think that one of Barr's odd selling points in this process is that his part of his whole pitch is, I don't have much patience for bad behavior or people yelling at me, and I'm just as likely to just bark back. You saw with Sessions, frankly, when Jeff Sessions was the Attorney General, he seemed to go out of his way to try to somehow please the president in every way he could that wasn't the recusal, because the recusal was sort of a bell that could not be unrung. I suspect that what Barr is trying to say is, I'm not going to be a guy who's going to be seen as groveling in any other setting to try and make the big boss happy. That's frankly probably a good pitch to this group of lawmakers who have watched the last 2 years of the Justice Department. But it does suggest at least the possibility of some potential significant conflicts down the road, because I think a lot of folks who are around the president don't expect his behavior to change very much.
And the appointment, the nomination rather, is interesting. We talked about kind of how he is maybe an unusual pick for the president right now. Most of the president's picks for cabinet in recent months have trended towards people who are not going to question him. Frankly, it's becoming more and more difficult to find people who will, because they know what they're in for. So we've seen kind of a migration towards the Mick Mulvaney's of the world. John Bolton, who set aside his very hawkish foreign policy to serve on the president as the president's national security advisor. Larry Kudlow, a very notable free trader who is now leading the president's trade war. A lot of these people, this process is selecting for people who are willing to kind of do whatever the president wants and to set aside their personal beliefs. Barr seems to be somebody who could be from a completely opposite camp. This is somebody who is established, who comes from a different administration, and is really, I think maybe the president looks at that memo and sees an ally being installed in the Justice Department. I wouldn't be so certain if I were him that that's going to wind up being the case. Regardless of his legal judgment in certain instances that might affect the president, he doesn't know exactly what he's going to get with this Attorney General, or at least that's what William Barr wants him to believe right now.
Let's go even deeper into how Bill Barr sees the role of the Attorney General and sees the role of the Justice Department. This gets kind of in the weeds and kind of fantastically nerdy, but we heard Dick Durbin ask a question about a past speech he gave at UVA. And it was an important question because it gets at this question of politics and the role of politics in the Attorney General's position in the administration. Dick Durbin talking about back during the George H.W. Bush era when Barr served as Attorney General, how at this UVA speech he was proud of efforts they did on immigration to make it a top priority because it would play well politically. And so then we heard Bill Barr talk about, well, here's what I see as the role of the Attorney General, and there are essentially like 3 facets of it that are important. Devlin, can you break that down a little bit for us? Because there was this, element that he talked about enforcing the law, advising on the law, but also dealing with policy.
Yeah, and I think he actually explained the job fairly well. I think sometimes the public grapples a little with what exactly is the Attorney General's
And
like
who are you
principal
working
role.
for?
Right.
Yeah.
And so the Attorney General is the top law enforcement official in the country. But the Attorney General also has a boss, and that boss is the President. So the Attorney General job is both an enforcer of the law, this is Barr's point in his answer, but also someone who tries to carry out the policies of the administration and the President in particular. Those are 2 different roles that sometimes come into conflict with each other, as we've seen ad nauseum in the last 2 years. And frankly, we saw this a lot during the Obama administration too. There were a lot of arguments and debates as to how Holder was filling that role and whether he was being too closely aligned with the President on some issues. Those arguments, frankly, now feel a little quaint compared to what the Justice Department has been dealing with for 2 years. But it's not like that argument didn't exist then. It was just a much less intense and much less, frankly, frantic conversation. So there's those, I think of it as essentially 2 roles, and I think that attorneys general who do well in it are the ones who spell out what their political goals for the department are while they're there, while also carving out, making clear to the public what things they are not going to be taking a political stance on. And to the degree that those 2 things mix or get confused in the public mind or accused of having them mixed in Congress's mind, that's when attorneys general run into problems.
Yeah, early on in the hearing, we heard Lindsey Graham, the chairman, ask, do you believe that the Attorney General, Jeff Sessions, had a conflict because he worked on the Trump campaign? And oftentimes people who work in a campaign are then given positions in the administration. And I thought that was interesting because a lot of the criticism and concern wasn't the fact that he worked on the campaign, it was the fact that he was not forthcoming with answers to this committee, in fact, about his conversations with Russians, his interactions during the campaign. And so we ultimately heard Bob Barr say, I think he did the right thing recusing himself, which we knew that was his position prior to this. But that also gets at this element of politics mixing with a position that ultimately becomes about enforcing the law.
Right, and I think one of the arguments that happens all the time in the Trump administration is sort of some version of, can he do that? Is this legal?
Which is our podcast here at the Washington Post, can he do that?
Can he do that? And I think what you see time and time again is there are practices that are generally followed that aren't actually carved in stone, and when you don't follow that practices, when you don't follow those practices, you sometimes have a pretty intense debate about whether, is this so wrong it's illegal, or is this just a change in practice? And you saw it in the recusal conversation. He laid out in fairly accurate terms, ultimately the recusal decision is mine. The DOJ Ethics Office can say whatever they like, but ultimately the decision is mine. That is absolutely true. What I think is so jarring to people in Congress and to some degree in the public is it's pretty rare for the ethics office to say, sir, you should step aside for the good of the department, and then have that person say, nah, don't feel like it. That's alarming to people. And what he's saying is, look, at the end of the day, it is my call, and so you can't make me follow the ethics advice. And it's interesting, he said he did not say he would follow the ethics recommendation. So he's laying that out there as a possibility.
And correct me if I'm wrong, you would know better than I, but I believe that previous Justice Department nominees have offered a little bit more of an assurance on that question when they have been asked about this. They were not compelled to do so, but they basically decided, hey, you know what, I will abide by whatever they recommend.
Correct. And often, I think they referred to at one point in the hearing, a predecessor once pledged to both seek the advice and take the advice of that office. Now, but people play games with this too. I mean, Holder once recused himself from the John Edwards investigation, And there was never really much pressure inside the building for him to do so. He just kind of decided on his own he would recuse. Now, that was an interesting call for political reasons more than legal reasons. But, you know, there is some degree of control that the Attorney General has in making these judgments.
You're watching live coverage from the Washington Post, and we expect the Judiciary Committee to come back in about 12:15 after this brief break. We are only partway through the first round of questioning. We've heard from, by my count, let's see, 7 senators so far. There's 22 on this committee. Each of these senators gets 10 minutes in this first round, and then we expect them to break and then go through another round of questioning today, about 8 minutes or so. So it is a long and intense day, but one that William Barr has been through before because he's appeared before the Judiciary Committee multiple times and gotten through quite easily, Devlin. So this is a new experience for him.
And it speaks to how much has changed since he was last the Attorney General.
Nearly 30 years ago.
Right. You know, back then, attorneys general and FBI director nominees were, the goal of Congress was to put those through with as wide a margin, if not unanimous. And you've really seen in the last, let's say let's call it 3 or 4 years, that tradition has stopped, at least for the moment. And I'm not sure when it's going to start again because these issues are all now so charged. But I don't think Barr has any expectation of going through unanimous or anything close to unanimous this time.
But the key will be having Republican support because they have the majority on this committee.
Right.
Let's head back to Capitol Hill and Rhonda Colvin. Rhonda.
Of course, immigration and the debate over the border wall is not very far from discussion. We saw that in the first half, and we'll also see it later on today, most likely. During questioning, Senator Leahy did ask Mr. Barr his thoughts if the president could appropriate funds to pay for the border wall. Here's what he had to say.
In 1990, you argued that Congress appropriation power is not an independent source of congressional power to control the allocation of government resources. There are only 3 committees in the Senate to have a vice chairman. Appropriations is one of them. Obviously, as vice chairman, I kind of looked at that. You claim that if a president finds no appropriated funds within a given category, he may use funds from another category, as long as both categories are in his constitutional purview. Now, this says Vice Chairman Appropriations Committee. Don't be surprised I disagree. Congress's power of the purse, Article 1, Section 9, I believe constitutes one of the most fundamental and foundational checks and balances on the executive branch. So do you believe the president can ignore Congress appropriations allocations, conditions, and restrictions in law? Just ignore them and take the money and transfer
Not as a general proposition, but I just, that was a
general proposition.
I actually thought that was a good law review article. I gave it as a speech, and it was really a thought piece. And what I was really saying was, and I say right up front, that the more I thought about the appropriations power, the more confused I got. And I was just laying out a potential template, which is this. People frequently say, you know, the power to, you know, spend money on this division or this missile system is part of the power of the purse. And what I was actually saying was, you know, actually what the power being exercised there is the substantive power that Congress has to raise armies. And it's not, it doesn't come from the power of...
specific appropriations on agriculture or on defense. I mean, for example, could a president just build a wall along our southern border because he wanted to and just take the money, whether appropriate or not? What about eminent domain?
What about eminent domain?
Well, if you're going to build a wall, you got to take a whole lot of land away from landowners in Texas and elsewhere.
Well, you know, you'd have to show me what statute is being invoked and also what appropriations is being used. I can't answer that in the abstract.
So you're saying the president, though, can have the power to go into money even if the Congress is appropriated for a different purpose?
I didn't say that. But some...
You mean that?
I don't mean that. I'm saying that, you know, there are monies that the president may have power to shift because of statutory authority.
But that would have been because Congress gave him that authority.
Right.
Not because he has it automatically.
I'm not taking that position. As I said, my law review, it was published as a law review article, and it was a thought piece exploring what limits there might be to the appropriations power and where Congress's power comes from in certain areas.
Thank you. Thank you, Mr. Chairman.
Just to follow up on that real quick, and I won't take this against Senator Cornyn. Did the Article 2 powers, the inherent authority of the Commander-in-Chief, give him the ability to take appropriated dollars for the Department of Defense and build a wall?
I can't, without looking at the statute, I really couldn't answer that.
I'm not talking about a statute. I'm talking about the inherent authority of the President as Commander-in-Chief.
That's the kind of question I would go to OLC to answer.
Okay. Get back with us on that. Senator Cornyn.
So that does give us some insight on how he feels about that issue, plus how he feels about presidential power. Just a little glimpse into that issue. And of course, Democrats have wanted him to be very clear on where he stands on presidential power. So we'll likely see more questioning like that later on. Back to you, Libby.
Great. Thanks so much, Rhonda. Another issue that he dodged and sort of legally got out of was the question of children being separated from their families at the border. We didn't really see a firm answer on that. Which was a critical question posed to him as well, Devlin.
Right, and you know, that issue, it's interesting. One of the things that has changed since Barr was last in the department is that the immigration issue is much more radioactive than it used to be, but also within the government, there is a back and forth and a bit of a tug of war going on between the Justice Department folks and the Homeland Security folks, each of whom have a piece of the immigration enforcement, but neither of them control it completely. And what you saw in the family separation issue is that there are some tensions there just in terms of how do we execute what the White House is telling us to do when we have different roles to play in this. I'll be very curious to see to what degree does Barr, as Attorney General, inject himself into the immigration debate, because Sessions worked very hard to inject himself into that debate. But that's not typically what attorneys generals do when it comes to immigration. Attorneys General tend to let other parts of the government be the key and the point person on those things. Now, I think it would be an interesting tell to the degree to which, what degree Barr wants to keep the president happy, how much he talks about immigration.
No surprise that Jeff Sessions made that a key issue, because as senator, it was a very important issue for him. It was something that he and the president were aligned on back on the campaign trail. So he took that political philosophy into this job. But William Barr is coming from a different perspective as someone coming from the legal community first and foremost with this legal background.
Yeah, and I think that's a key difference here. Jeff Sessions was, it's kind of interesting that Jeff Sessions became something of a hero to the left when he recused and became President Trump's enemy, because he really was the most hardline immigration senator that there was in the U.S. Senate.
And the first to support candidate Trump before he became president.
The first endorser. So the fact that those two had a falling out and they couldn't kind of work together on these things and do the kinds of things they wanted to on immigration, I think is one of the more remarkable developments of the entire Trump presidency. And it just shows that how much their relationship broke down, that they couldn't kind of get past that recusal question.
Let's talk about Chairman Lindsey Graham and what sort of a tone he's bringing to these proceedings. Since this is his first hearing in this new role as chairman, we saw Senator Grassley by his side. Grassley stepped down from being chairman but is still on the committee. Right away, out of the gate, Lindsey Graham talked about Lisa Page and Peter Strzok, and said basically, do you know about this? Are you up to date on this? And starting to draw that line of questioning out.
Yeah, you always get a little bit of column A with Lindsey Graham and a little bit of column B these days. He started off early on and he gave a nod to the memo and how important that was. He said this is these are questions that you do need to answer. This is an important issue, the memo that Barr had written.
In the sense that you have to explain.
Yeah, like
your
he said this was a valid
to.
issue, basically, and that this deserved to be studied extensively in this hearing. But then his first questioning, as you noted, his first line of questioning was this idea that there is bias within the Justice Department. He talked in his opening statement about how morale is low. He said he wanted Barr to, quote unquote, right the ship over there, apparently referring to Peter Strzok's text. apparently referring to these other allegations of alleged bias within the Justice Department. And then he launches into those questions about Peter Strzok, which eventually resulted in William Barr saying, one, agreeing that he would launch some kind of an internal inquiry into this matter, which I thought it sounded like he was going to do that after Lindsey Graham asked him to, and then saying he was very concerned about Peter Strzok's text messages. He said that he was shocked to see them or something like that. I thought it was pretty remarkable that a hearing in which one of the major subplots is, will this guy go into the Justice Department and do the president's bidding if he asks him to investigate his political opponents? One of the first things he commits to doing, or seems to commit to doing in this hearing, was actually looking into those political opponents that the president has chosen.
Yeah, and
if I'm misreading any of that,
no, I don't
me.
think so. In fact, my read on it in the moment was that this is for an audience of one, that the president may be watching this hearing somewhere, and
especially right off the top. I mean, right up at the top, when interest is high, when someone like the president would be tuning in, presumably.
There's one person in particular who tweets a lot about Peter Strzok, and that is the president of the United States. So when the chairman starts off talking about it, my first read was I sort of assume that's for a certain particular audience. Look, the Inspector General has looked at a lot of stuff over at the FBI and the Justice Department, and he's found things that I think most people would agree are, at best, terrible judgment. And you know, if you listen to Republicans, something worse than terrible judgment. But I do think that anytime you're talking in a hearing like this about Peter Strzok and the Clinton investigation, that is always with at least one eye toward the White House.
We'll head back to Hart 216 in just a moment, full screen once this hearing gets back underway. I do want to make a nod to history here. We heard Senator Feinstein at the top of her remarks, she's the ranking Democrat on this committee, make reference to how this committee has changed just from a couple of months ago, because there are two Republican women for the first time ever, Devlin. And when they started talking about that, I sort of said to myself, wait, the first time ever?
Correct.
And that's the case. So we'll hear from Joni Ernst later on today, Marsha Blackburn, as they get a chance to ask questions on this committee. Senator Feinstein just talking about how she's glad this is an advancement for this body.
Yeah, I mean, one of the sort of knocks that you hear on the the Judiciary Committees for both the House and the Senate is that they tend to accumulate the more fire-breathing members of each side. And I think for reasons that frankly probably went unnoticed for a while, you know, some of the women senators tend to be more moderate members of that caucus. And so I think that's part of the rationale why you might not have seen a woman on that committee for all this time.
And it was just amazing though to hear Senator Feinstein talking about when Anita Hill testified before this committee during Clarence Thomas's confirmation process. It was all male.
Correct.
And you know, when we last saw William Barr before this committee, it was that era. It was 1991. Yes. It was the same time frame. And yet, despite the Anita Hill testimony, no women had joined the Republican side of the aisle, and it took a long time, obviously, to beef up the ranks of the Democratic side too. So
look,
diversity
the numbers
is a
are still
question.
the numbers are still wildly out of balance, right? We are nowhere near 50-50 in gender in Congress, but it is fascinating that the change is coming, and frankly, I think this particular change was precipitated, as you mentioned before, by the Kavanaugh hearing and the fact that the Republicans basically brought on a female prosecutor to do the questioning, at least in part because of the awkwardness of that.
Senator Feinstein, something else that she did, Aaron, was she threw in some questions that came from the chairman of the House Judiciary Committee. As she was asking questions, she said, a couple of these are coming from the House. Will you commit to making the report public? Will you make any report on this a special report public? And so she was also bringing in the bicameral relationship, trying to get some questions in from the House. So we see Democrats able to flex a little more muscle on the House side of things, but also having to work through the Senate at times as well.
Yeah, and I thought it was interesting that Feinstein at least tried initially to start with 6 yes or no questions. Yes or no questions are always great in theory, but they're not really great in practice at these hearings because these are complex legal questions that often require very nuanced answers. He actually answered a number of them with yes or no answers, but I don't think any of them were anything that we weren't
No
necessarily
surprises.
expecting. No,
Yeah.
no big surprises.
Thanks to Aaron Blake, Devlin Barrett. Let's go back now to the Judiciary Committee.
The hearing will come to order, and I recognize Senator Whitehouse. Thank you, Mr. Barr.
Thank you, Chairman. This is my first chance at a committee hearing to congratulate you on taking the gavel here. We worked well together when you were chairman of the Crime and Terrorism Subcommittee, and I hope that that will continue here. Mr. Barr, welcome. Did you make it a condition of taking this job that Rod Rosenstein had to go? Just to be clear, so we're not bandying words here, did you request or signal or otherwise communicate in any way that you wanted Rod Rosenstein to go?
No, the president said that the decision on the deputy was mine. Anything I wanted to do on the deputy was
So
fine.
we will find no William Barr fingerprints on Rosenstein's departure.
No, Rod and I have been talking, about his plans. He told me that he viewed it as a 2-year stint and would like to use, if I'm confirmed, my coming in as an occasion to leave. But we talked about the need for a transition, and I asked him if he would stay for a while, and he said he would. And so as of right now, I would say he has no concrete plans. I have no concrete plans in terms of his departure.
And you have not
we're going to sort of
undertaken-
play it by ear and see what makes sense.
And you have not undertaken to run him out in any way?
Absolutely not.
That leaves an opening at the DAG position whenever you work this out. Can you tell us, since attorneys general are very often defined by the immediate appointments around them at Chief of Staff, DAG, Criminal Chief, what are the characteristics and qualifications that you will seek as you fill particularly that position, but all three that I mentioned?
I'm sorry, the deputy, and what was the other
Deputy Chief of Staff and Criminal Chief.
one? There is already a criminal chief.
I know.
Yeah.
He's already a Deputy Attorney General, but he's leaving.
Well, for a deputy, I'd like someone who's a really good manager and who has had good management experience running government programs, and I want a first-rate lawyer and someone whose judgment I feel comfortable in.
Experience in the department?
Not necessarily, but experience in government at a high level.
When we met, I gave you a letter that you've seen, just so none of these questions would be a surprise, so I hope it is no surprise to you that I'm going through some of them. If you're confirmed, what will be the department's rule regarding communications between White House and Department of Justice officials regarding criminal and investigative matters? Who at DOJ will be allowed to have those conversations with the White House, and who at the White House will you entertain those conversations from at DOJ?
So, I've looked through the existing regime, and my instinct is to keep it, maybe even tighten it up a little bit more. I remember when George W. Bush's administration was coming in, my advice was start tight, and then as you realize who has judgment and so forth, you can go back to a...
They went the other way, and it was a bad day for Attorney General Gonzalez in the hearing room when that was brought to his attention. What is your understanding right now of who at the Department of Justice is authorized to have communications with the White House regarding
Well, it depends. It depends what it is, but on criminal matters, I would just have the AG and the deputy.
And what do you think the rule is now in the department?
I think that's what it is.
Okay. So if the reports are true that, as Chief of Staff, Mr. Whitaker was involved in conversations with the White House about bringing criminal investigations against the president's political enemies, that would not be consistent with your understanding of that policy.
Well, it would depend upon, what his understanding is with the Attorney General. I mean,
Well, the Attorney General was recused, so hard to step into the shoes of a recused Attorney General on that matter, right?
Well, I don't know what the communication's related to. I'm not really sure what you're talking about.
Okay. Well, I hope you'll become sure when you get there, because there's a fair amount of, I think, questionable behavior that has gone on that does not reflect well on the department that I hope will get your attention. I also asked you about the special counsel investigation and to give us a clear exposition of how that memo came to be, who you talked to, when, who was involved in it. There were a number of questions in that letter that at this point you have not answered. You have, I gather, told the chairman the names of some dozen or so people whom you contacted, as I understand it, once the memo was written, but it's not clear. Do you have any objection to answering the questions that I wrote as questions for the record so that the committee can understand who you worked with, who you talked with about this idea, who you worked with in preparing the memo, who helped you with things like citations that people at your level don't often do yourselves, and where it was circulated and vetted and what edits were made and so forth?
No, I have no objection to that.
Great.
But
We'll let that
just to be clear, no one helped me write the memo, and I know how to do legal citations, which I do.
Yeah, well, a lot of people know how, but that doesn't always do
I
it.
do it. I did
Okay.
it. Okay.
You might want to get out of that habit. You may have other things to look at.
I'd like to have some fun in life.
If you think citations are fun, you're not going to have the problem some other nominees have had. My letter to you also asked about the Bork order that set out a series of protections for the then independent counsel operation. Do you have any objection to any of those rules or principles applying, and should we see those rules and principles, which I gave to you then, as being more or less adopted into the statement that you made earlier about your protection of the Mueller investigation from political interference?
I looked at them. I think the current regime is what I'm happy with. In other words, I wouldn't change the current rule. Those rules were put in place at the end of the Clinton administration, and sort of, I think, reflects the back-on-back experience of the Reagan-Bush years and then the Clinton years, and then sort of Justice Department's thinking under the Clinton administration as to how to balance all the equities, and I think it's working well. So,
well, if there's anything that you would disagree with in the so-called Bork rules, I'd ask you to explain that in a
follow-up.
QFR, in a follow-up.
Okay. Okay.
Also, in my letter to you, I expressed my concern that Mr. Whitaker was paid $1.2 million through what I consider to be a front group that has very little reality to it, and that the funding that came to that front group to pay him the $1 million came through another entity that is essentially an identity laundering operation that has no independent business operation. And the result of all of this is that somebody out there arranged to get over $1 million to Mr. Whitaker, and we have no idea who that somebody is. And as I mentioned to you in our conversation, I don't see how the department can do a proper recusal and conflict analysis for somebody when the player who delivered the $1 million is still hidden behind the curtain. Is that something that you will help us fix?
Well, first, I don't think there was anything wrong done, or
well, we don't know that yet because we don't know what the facts are.
Yeah, well, I'm just saying, just the facts that you've said, doesn't necessarily mean there was anything wrong done. What you're saying is that if the ultimate financial backers are behind some entity and the current ethics laws require only the reporting of the entity, you're not really sure where the money is coming from. And that, I think that raises a very interesting point that I think I would like to review with the ethics people and experts and even OGE to talk about that, because the more I thought about it, the more I thought that the trick is going to be deciding what kind of entities and how far back you go, because that can be said of a lot of different kinds of entities.
Yeah.
And
I would
sometimes you
submit
have
to
first.
that if the department's money laundering folks looked at this operation, they would see it as almost amateurish and simple and something quite easy to penetrate. And it would be quite easy simply to ask Mr. Whitaker what he knew, to ask whoever is still at FACT, if it even has any existence with Whitaker's departure, what they knew, and to ask Donors Trust to cough up the identity of the donor, and then you can do your homework. And if they refuse to do that, nothing guarantees anybody a job at the highest levels of government who's not willing to provide those disclosures.
Well, as I said, one of my first considerations always is where do you draw the line, and also what are the implications for other kinds of entities? Because there are membership groups and First Amendment interests, and you don't want to disclose memberships and who's.
And my point was, I think if your money laundering folks took a look at that, they'd be able to help show that this is something that looks a little bit different than that. My time has expired, and see you on the second round. Thank you.
Senator Sass.
Filling in for Senator Cruz next. Thank you, Chairman.
Okay with me.
Thank you. Mr. Barr, I want to commend you for stepping forward. Thank you very much. And I want to say thank you to your family as well for being so supportive in this endeavor. I'm really pleased to have all of you here, so thank you for doing that. Mr. Barr, later this month, I do plan on reintroducing Sarah's Law, which is a bill that would require the detention of illegal aliens who have been charged with a crime that resulted in the death or serious injury, bodily injury of another person. Now that sounds pretty common sense, but I'll give you a little background. This bill is named after Sarah Root. She was a resident of Council Bluffs, Iowa, and Sarah was killed by an illegal alien who was driving drunk. And that alien had a blood alcohol content of more than 3 times the legal limit, yet he was allowed to post bond and has not been seen since. It's important to me that Congress act to close these loopholes in our immigration system and do better to enforce the laws that are already existing on the books. And I know that Attorney General Sessions, he had a real passion for this, and he had a strong record of trying to make sure that we're correcting wrongs in the system. How do you, as Attorney General, plan on making sure that we are restoring the rule of law in our immigration system?
Well, first, that sounds like a very commonsensical bill and something that I would certainly be inclined to support. I think one of our major problems, as the President says, is that the immigration laws just have to be changed and to provide sensible and common sense ways of processing immigration and claims of asylum. Right now, this goes all the way. This goes back 27 years. We were facing exactly the same kind of problem, maybe on a smaller scale. But Congress has to, where people are abusing the asylum system, coming in, they're being coached as to what to say, and then once they come in, we don't have the facilities to keep them, and they're released into the population. And this was a big abuse, as I say, 27 years ago, and it's gotten worse. We need to change the laws to stop that kind of abuse and enable us to run a lawful immigration system where we process people into the country who are entitled to come into the country, and we keep out those that are flouting our laws. And it's long overdue. And the President is right that until we're able to do that, we're just not going to be able to get control over illegal immigration, and it creates a lot of unsafe conditions for many people.
Absolutely, and I appreciate your thoughts on that. This is a very important issue. I think all of us understand that immigration is so vital to our country, but it has to be done in the right manner. And for those that are causing bodily injury and death to those here in the United States, we want to make sure that they are brought to justice. And in this case, that illegal, undocumented was not brought to justice. And I feel a lot of empathy for that family. I'll move into another situation that's really important to Iowans. According to the U.S. Department of Health and Human Services, after drug dealing, human trafficking is tied with arms dealing as the second largest criminal industry in the world, and it generates about $32 billion each year. The Department of Justice has said that 83% of sex trafficking victims identified in the United States are U.S. citizens, with the average age of a victim being between 12 and 14 years. 12 and 14 years. Since 2007, there have been over 300 cases of human trafficking in Iowa alone. And Iowa is a very rural state. 300 cases. That's very concerning to my constituents back home. What do you see as the main contributor to human trafficking here in the United States? And then how can the DOJ impact and combat and prevent those heinous crimes?
This is an area that, frankly, wasn't very much on the radar scope of the Department of Justice when I was last there. I know it's it's an abhorrent area of criminality that I know the department and Attorney General Sessions have been focused on, and have put in place various programs and entities within the department to focus on it and work with state and local law enforcement on it. I'm not sure what the major contributor to it is. It's an area that I'm going to have to study when I get into the department and see what are the factors contributing to it.
Okay, I appreciate that. And as I mentioned in my question as well, drugs and drug trafficking, that is also a very, very big industry. And in fiscal year 2017, 65% of drug-related prison sentences in Iowa were related to methamphetamine. We talk a lot about the opioid crisis, but in Iowa, it still is meth. In 2016, Iowa reported over 1,500 founded child abuse reports relating to methamphetamine being found in the child's body. According to the DEA, most of the meth available in the United States is being produced in Mexico and smuggled across our southern border. How do you see the situation at our southern border contributing to the prevalence of controlled substance use here in the United States?
Well, as been pointed out earlier, it is the major avenue by which drugs come into the country. Heroin, fentanyl, all the serious drugs are coming across that border. And again, I feel it is a critical part of border security that we need to have barriers on the border. We need a barrier system on the border to get control over the border. And I think obviously there's some places that more of the traffic comes over than others, but unless you have a system across the border, you're not going to be able to deal with it because you'll just displace it. If you build a barrier in one place, you'll just displace it to another. So we need a barrier system across the border. Part of that is illegal immigration, but a big part of it also is preventing the influx of drugs.
Mm-hmm. Absolutely. And you stated earlier that really the head of the snake lies outside of the United States. Is there a way that DOJ can be working with additional ideas, methodology with other departments that you might think would help?
Yes, this is an area, again, because I'm out of the government, I don't know how it's functioning, how the drug war is being coordinated, but I think justice can play a big role in pushing for partners like the State Department, Defense Department, the intelligence agencies, and so forth to help deal with this. It's not, to me, not just a law enforcement problem, it's a national security problem.
Mm-hmm. And you mentioned as well the situation on the border where we do need barriers in place to control the influx of whether it's drugs, human trafficking, gun trafficking, so forth. Do you believe that sanctuary cities play a role in harboring some of those activities?
Yes, I do. I think there are a number of sort of, of factors that have a hydraulic effect in that they pull people into the United States or induce them to take the hazards of coming into the United States and coming up hundreds of miles through Mexico and so forth. And things like sanctuary cities where they feel that they'll be able to come up and hide and be protected is one of those factors that I think is irresponsible because it attracts the illegal aliens coming in. Obviously, I think that the main problem with sanctuary cities is that they're not giving us information about criminals that they have in their custody. This is not chasing after, families or anything like that. This is going after criminals who the state, local law enforcement have in custody, and not allowing us to take custody of them and get them out of the country. That's the problem with sanctuary cities.
Correct, which could be the situation with Edwin Mejia, who killed Sarah Root. So we would love to see that young man brought to justice. Thank you very much for your time.
Thank you. Well, just follow up on that, Senator Klobuchar. Don't count this against her time. So you're saying that you want access to people who've committed crimes or accused of committing crimes outside of a status violation. Is that what?
That's right, Senator.
Okay. Senator Klobuchar.
Thank you. Thank you, Mr. Barr. I take it as a positive that your grandson has gotten out a pen and a pad of paper to take notes during my questions. I am also impressed by your daughters and that they all chose to go into public service. But as you know, employees at the Justice Department now are either furloughed or they are working without pay. And I have talked to a number of them at home, and it's an outrage. Very briefly, what do you have to say to them?
I would like to see a deal reached whereby Congress recognizes that it's imperative to have border security, and that part of that border security, as a common sense matter, needs barriers.
And you're aware that in the comprehensive Senate immigration bill that we passed, there was literally billions of dollars for border security back in 2013?
I'm generally aware of that.
And that also we had an agreement earlier last year which would allow the Dreamers to stay legally that also had money for border security?
The point is, we need money right now for border security,
Yes,
well, including barriers and walls and slats and other things, anything that makes sense in different areas of the border.
Okay, in different areas. That's a good point. So President George H.W. Bush said back in 1980 that he didn't want to see 6- and 8-year-old kids being made to feel that they're living outside the law, and you were his Attorney General. He also said that immigration is not just a link to America's past, but it's a bridge to America's future. Do you agree with those statements?
Yes, I think, as I said, I think legal immigration has, we have a great system potential. I think it needs reforming, but legal immigration has been good for the United States. It's been great for the country.
And that's why we were trying to work on that comprehensive reform. I want to just briefly turn to FBI leadership. The President has made statements accusing the FBI of making politically motivated decisions. Many of us up here and in the Senate have confidence in Director Wray and the leadership at the FBI and believe they can do their jobs without politics getting in the way. Do you agree with that?
I'm looking, if I'm confirmed, I'm looking forward to getting to know Chris Wray. From what I know, I think very highly of him.
Okay, thank you. In the memo from back in June, The one comment that Senator Grassley made, he talked about how much the Mueller investigation was costing, and I actually did a little Googling here, and there was a CNBC report that it actually could bring in more money than it cost because of the wealthy people being prosecuted, that Manafort's assets could be well over $40 million. I don't know if that includes that ostrich jacket, but do you think that's possible based on your experience with white-collar crime?
I don't know enough about it.
Okay. In your memo, you talked about the Comey decision, and you talked about obstruction of justice, and you already went over that, which I appreciate. You wrote on page 1 that a president persuading a person to commit perjury would be obstruction. Is that right?
Yes.
Okay.
Or any person who persuades
person.
another to, yeah.
Okay. You also said that a president or any person convincing a witness to change testimony would be obstruction. Is that right?
Yes.
Okay. And on page 2, you said that a president deliberately impairing the integrity or availability of evidence would be an obstruction. Is that correct?
Yes.
Okay. And so what if a president told a witness not to cooperate with an investigation or hinted at a pardon?
You know, I'd have to know the specific. I'd have to know the specific facts.
Okay. And you wrote on page 1 that if a president knowingly destroys or alters evidence, that would be obstruction.
Yes.
Okay. So what if a president drafted a misleading statement to conceal the purpose of a meeting? Would that be obstruction?
Again, you know, I'd have to know the specifics.
All right. You would seek the advice of career ethics officials in the Department of Justice for any recusal, and I appreciate that. And you said in the past that you commended Attorney General Sessions for following the advice of those ethics lawyers, but you didn't commit today to following that advice. Is that right?
No, I didn't commend him for following the advice. As the agency head, he's the one responsible for making the recusal decision. I don't know why he locked himself into following the advice. That's an abdication of his own responsibility.
So what did you think about what Acting Attorney General Whitaker did when he rejected the Justice Department ethics advice to recuse himself out of an abundance of caution?
I haven't seen the advice he got, and I don't know the specific facts. But abundance of caution suggests that it could have gone either way.
You've committed to recuse yourself from matters involving the law firm where you currently work. Are you aware of any of your firm's clients who are in any way connected to the special counsel's investigation?
I'm not aware. To tell you the truth, I'm of counsel there, and I have one client which I'm representing, and I don't pay very much attention to.
Well, you can also supplement that.
Yeah, I'll supplement my
answer. Okay, no
answer.
problem. Will you commit to make public all of the report's conclusions, the Mueller report, even if some of the evidence supporting those conclusions can't be made public?
You know, that certainly is my goal and intent. It's hard for me to conceive of a conclusion that would run afoul of the regs as currently written, but that's certainly my intent.
Secure elections, you and I had a talk about that in my office. Do you think backup paper ballots are a good idea? This is a bill that Senator Lankford and I have introduced, and with Senator Graham and Senator Harris.
Yeah, I don't know what's a good idea, what's a bad idea right now, because I haven't gotten into this area, but...
Okay, well, I'll just tell you backup paper ballots is a good idea.
Okay.
And we can talk about it later, as well as audits along the lines of voting. State election officials in North Carolina, as you know, contacted the Justice Department about the integrity of their elections. The Justice Department may have failed to take action in a timely manner. What steps would you take to make sure these failures don't occur again?
Not specifically with respect to North Carolina, you're talking generally.
Mm-hmm.
Yeah. Well, as I say, I want to make one of my priorities the integrity of elections, and so this is not an area I have been involved with deeply before, and when I get to the department, if I'm confirmed, I'm going to start working with the people and making sure that those kinds of things don't happen.
And part of this, of course, is also voting rights and our concern about some of the changes in department policy. And I hope you will seriously look at that, because the last thing we should be doing is suppressing voting, and that is what we've been seeing under this current administration. My dad was a reporter, so I grew up knowing the importance of a free press. We obviously have the tragic case of a journalist who worked right here at the Washington Post, Jamal Khashoggi, and it's a particular concern. So I want to ask you something I asked Attorney General Sessions. If you're confirmed, will the Justice Department jail reporters for doing their jobs?
I think that, I know there are guidelines in place, and I can conceive of situations where, as a last resort, and where a news organization has run through a red flag or something like that, knows that they're putting out stuff that will hurt the country. There might be there could be a situation where someone would be held in contempt, but
Well, Attorney General Sessions had said he was going to look at potentially changing those rules at one point, so I'd like you to maybe respond in writing to this, because that was very concerning. And when you and I were in my office, we talked about your work with Time Warner with this major merger on appeal from the Justice Department, and I just wanted you to commit today to what you committed to me in the office, that you would recuse yourself from any matters regarding that appeal.
absolutely.
Okay? And as you know, you were on the board of Time Warner at the time, and you signed a sworn affidavit questioning whether the Justice Department's decision to block the merger was politically motivated, given, and this is from the affidavit, the president's prior public animus towards the merger. Are you talking here about his view on CNN? What did you mean by prior public animus?
I'm sorry, could you repeat that?
Sure.
Yeah.
You were on the board of Time Warner, and you signed a sworn affidavit questioning whether the Justice Department's decision to block the merger was politically motivated, given the president's prior public animus toward the merger. And so what did you mean by that?
I mean, the affidavit speaks for itself in that at that meeting, I was concerned that the Antitrust Division was not engaging with some of our arguments, and I got concerned that they weren't taking the merits as seriously as I would hope they would. But I have no, I'm not sure why they acted the way they did.
Okay, very good. And I'll ask you more on antitrust policy-wise in the second round, and I appreciated the discussion we had on that. It's very important. Okay. Thank you very much.
Yeah.
Thank you. Senator Hawley did a good thing by allowing Senator Ernst to go, because she had no good deed goes unpunished around here, but you do have a credit with the chairman, so I appreciate that. Senator Cruz, you're next.
Thank you, Mr. Chairman, and thank you, Senator Hawley, as well, and welcome to the committee. Welcome to all the new members of the committee, and congratulations, Mr. Chairman. We are looking forward to the Lindsey Graham chairmanship of Judiciary, and I'm sure if...
They'll make a movie about it, I'm sure.
I am certain whatever else happens, it will not be boring. Welcome, Mr. Barr. Congratulations on your nomination yet again. And let me say thank you. You and I have visited before about this, but the past 2 years have been a difficult time at the Department of Justice. And you and I and many on this committee hold the Justice Department in very high esteem. Indeed, I would even say revere the department and its century-long tradition of enforcing the law without regard to party and without regard to partisanship. And I commend you for your willingness to go back and serve once again. I think that is a good step for the department and a good step for strengthening the department. You know, I would note 27 years ago, when you did this previously, when you were last nominated to be Attorney General, when I think you may have been about Liam's age at the time, it was a different time. Then Chairman of the Judiciary Committee, Joe Biden, said at the time that he found you to be, quote, honest, and that you, quote, understand and are committed to the dual responsibility of the office of the Attorney General. Chairman Biden also said that, quote, this commitment to the public interest above all else is a critical attribute in an Attorney General, and I will vote to confirm Mr. Barr. Senator Ted Kennedy likewise noted your dedication to public service. Senator Fritz Hollings said, quote, Mr. Barr has a distinguished academic background and impressive experience in private sector as well as in public service. Most important, Bill Barr is a known quantity. He has done a truly outstanding job as Deputy Attorney General for the last year and a half, during which time he has worked with many of us in this body, earning our respect for his professionalism and competence. And Senator Cole said that, quote, your willingness to discuss the issues is a refreshing change in the confirmation process, and it would be wise of future nominees to follow Mr. Barr's example. At that hearing, you were confirmed by this committee unanimously, as you had been twice previously for senior appointments to the Department of Justice. Now, we all recognize that was a different time. I think given the environment we are in now, few expect this committee vote to be unanimous. But I would hope those voices from the past, from Democrats who were respected by members of this committee, will be heard today as well. One of the questions you were asked, if I might paraphrase, was, why on earth would you take this job? And your answer, if I recall correctly, concerned your commitment both to the department and the rule of law. Would you tell this committee, in your judgment, why the rule of law matters? Why is that important?
Well, you know, as our framers said in the Federalist Papers, the art of setting up a government is to have a government that's strong enough to perform the functions that a government has to perform, while at the same time not being so strong that it can oppress its own people. And the rule of law ensures that precisely that the government does not oppress its own people. And when people are accused of wrongdoing, our system essentially gives them the benefit of the doubt and gives them rights to bring them up essentially to the same level as the government. And the process we go through is there to ensure that justice is not arbitrary, but it's done according to a set of rules. And the basic protection that we have is that the rule that applies to one applies to all. That, at the end of the day, is what keeps us all free. That is the protection of individual freedom. And to me, the rule of law is exactly that, that we don't allow special rules to go into effect for a particular individual. A rule has to be universalized. Anything we do against A has to be universalized across everyone who's similarly situated. That's our basic protection, and to me, that's what the rule of law is.
So I don't want to see a Republican Department of Justice or a Democratic Department of Justice. I don't want to see a Republican FBI or a Democratic FBI. What we should see, what the American people have a right to see and a right to expect, is a Department of Justice that is committed to and faithful to the Constitution and the laws, regardless of political party. And a corollary to that is a department that is willing to hold anyone who commits criminal conduct accountable, regardless of that individual's political party or whatever partisan interest there might be. Would you agree with that characterization?
Senator. Yes, Senator.
I would note as well, during the previous administration, There was concern by many, including me on this committee, that the previous administration, and in particular the IRS, had targeted individual citizens and citizen groups for exercising their First Amendment rights and had abused its power in doing so. The current Justice Department, I've been dissatisfied with the degree of scrutiny they have given to that potential abuse of power. And I'm going to ask you going forward, if you are confirmed, to examine that conduct and ensure that if laws were broken, that individuals are held accountable. Let me shift to a different topic. One of the most important safeguards of our liberties is the Bill of Rights. And the Attorney General has a unique responsibility defending the Constitution. Can you share for this committee, in your view, the importance of free speech, of the protections that the First Amendment provides to Americans to speak, and even to speak on unpopular or politically disfavored topics?
I think free speech is at the core of our system because we believe in the democratic process and power shifting through the processes of voting by an informed electorate. And free speech is foundational to the ability to have a democratic process. The framers, I think, believe that the dialectic, the clashing of ideas in the public marketplace, is the way to arrive at the truth. And that is one function. Another function of free speech is that it's the substitute for other means of settling differences. In some ways, it's a safety valve. People are allowed to speak their mind and persuade their neighbors of their position. And I think that performs a very important function in keeping the peace within a community. And if speech is suppressed, it can lead to the building up of pressures within society that sometimes can be explosive.
How about your views on religious liberty, and would you share your thoughts on the importance of the religious liberty protections in the First Amendment in terms of protecting our diverse and pluralistic society?
Yes, I think the framers believe that our system, they said that our system only works if the people are in a position to control themselves. Our government is an experiment in how much freedom we can allow the people without tearing ourselves apart. And they believed fewer laws, more self-control, and they believed that part of that self-control, and I know there are many people here who disagree, in our society, not here, but in our society who disagree, but they believe part of that self-control ultimately came from religious values. And I think it's important underpinning of our system that we permit, I believe in the separation of church and state, but I am sometimes concerned that we not use governmental power to suppress the freedoms of traditional religious communities in our country.
Final question. The Department of Justice is charged with defending the United States, but that doesn't mean that the Department of Justice always must argue for maximum federal power. There are important restraints on federal power, whether civil liberties protections in a criminal context, whether the Takings Clause, or whether the 10th Amendment and federalism. Can you briefly share your thoughts on the appropriate balance of respecting the limitations on federal power?
Well, as you say, the Constitution has many different forms of restraint on federal power. Part of it is, in fact, the separation of powers within the federal government. Part of it is the balance between the federalist system we have and the central government and respecting the rights of the states and local communities. And part of it is the Bill of Rights that on certain topics constrains the role of the federal government. And those are all important checks on federal power. And, you know, I am concerned about our country becoming just a unitary state that we try to govern centrally, 350 million people. I think a lot of our current tensions in society are because we are turning our back on the federalist model. There are certain things that have to be protected by the federal government. There's no ifs, ands, or buts about that. But the more we can decentralize decision-making, the more we can allow people a real diversity in the country of approaches to things, I think we'll have less of an explosive situation.
Very much agree. Thank you, Mr. Barr.
The freedom of speech has to be balanced by the freedom to question. Senator Coons.
Congratulations, Chairman Graham. I look forward to working with you in this Congress. And thank you, Mr. Barr, and to you and your family for their service to our country through federal law enforcement and the Department of Justice. You just faced some questioning from Senator Cruz about your own confirmation hearing back in 1991, and I'd like to take us back to a previous confirmation hearing, which was at a more similar time to today than 1991, 1973. Senator Leahy asked you about the confirmation of Elliot Richardson, President Nixon's nominee to be Attorney General. That confirmation took place in the context of a similarly divided period in American history where there was great concern over the, at that point, ongoing Watergate investigation. And Elliot Richardson reassured the country by making some important commitments during his confirmation hearing before this committee. Then Senator Strom Thurmond asked Richardson if he wanted a special prosecutor who would, and I quote, shield no one and prosecute this case regardless of who was affected in any way, shape, or form. Richardson responded, exactly. Do you want Special Counsel Mueller to shield no one and prosecute the case regardless of who is affected?
I want Special Counsel Mueller to discharge his responsibilities as a federal prosecutor and exercise the judgment that he's expected to exercise under the rules and finish his job.
Senator Kennedy followed up by asking Richardson if the special prosecutor would have the complete authority and responsibility for determining whom he prosecuted and at what location. Richardson said simply, yes. Would you give a similar answer?
No, I would give the answer that's in the current regulations, which is that the special counsel has, broad discretion, but the acting attorney general in this case, Rod Rosenstein, can ask them about major decisions, and if they disagree on a major decision, and if after giving great weight to the special counsel's position, the acting attorney general felt that it was so unwarranted under established policies that it should not be followed, then that would be reported to this committee.
Forgive me, I've got 7 minutes left. I have a number of other questions. Let me just make sure I understand you. Senators asked Elliot Richardson what he would do if he disagreed with the special prosecutor. Richardson testified to the committee the special prosecutor's judgment would prevail. That's not what you're saying. You're saying that if you have a difference of opinion with Special Counsel Mueller, you won't necessarily back his decision. You might overrule it.
Under the regulations, there is the possibility of that, but this committee would not, would be aware of it. A lot of water has gone under the dam since Elliot Richardson, and a lot of different administrations on both parties have experimented with special counsel arrangements.
Well,
and the existing rules, I think, reflect the experience of both Republican and Democratic administrations and strike the right balance. They are put together in the Clinton administration after Ken Starr's investigation.
That's right. So the current regulations on the books right now prevent the Attorney General from firing without cause the special counsel. They require misconduct, dereliction of duty, incapacity, conflict. Will you follow that standard?
Of course.
What if the president asked you to rescind or change those special counsel regulations?
I think those special counsel regulations should stay in place for the duration of this investigation, and we can do a postmortem then, but I have no reason to think they're not working.
So most famously, when directed by President Nixon to fire the special counsel, the prosecutor investigating Watergate, Richardson refused and resigned instead, as we all well know. If the president directed you to change those regulations and then fire Mueller, or simply directly fired Mueller, would you follow Richardson's example and resign instead?
Assuming there was no good cause?
Assuming no good cause.
I would not carry out that instruction.
Let me bring us forward to your 1991 hearing in front of this committee. You explained at the time how you would handle the BCCI case, and ironically, Robert Mueller, the same individual, was at that point the head of the criminal division. And you testified that you had directed Mueller to spare no resources, use whatever resources are necessary, and pursue the investigation as aggressively as possible and follow the evidence anywhere and everywhere it leads. Would you give similar direction to Robert Mueller today?
I don't think he needs that direction. I think that's what he's doing.
You also said at that hearing that Robert Mueller in that investigation had full cooperation, full support, and carte blanche. Could he expect a similar level of support from you as Attorney General?
Yeah, he will. As I said, I'm going to carry out those regulations, and I want him to finish this investigation.
I think we all do. And I am encouraged by things you've said about this and just want to make sure we've had as clear a conversation as we can. Attorney General Richardson also testified the relationship between the President and the Justice Department should be arm's length. You've said similar things about the importance of shielding the department from political influence. Can you make a similar commitment to us to maintain an arm's length relationship between the Justice Department and the President regarding the special counsel investigation and other investigations?
Yeah, well, remember I said that there are like 3 different functions generally that the Attorney General performs. I think on the enforcement side, especially where matters are of either personal or political interest to people at the White House, then there has to be an arm's length relationship. The White House counsel can play a constructive role in that as well.
Let me ask, if the President asked for information that could well be used to interfere with the special counsel investigation, to misdirect or curtail it in some way, would you give it to him?
No, I mean, there are rules on what kind of information can flow and what kind of communications can go between the White House, and I would follow those. But the basic principle is that the integrity of an investigation has to be protected. There are times where you can share information that wouldn't threaten the integrity of an investigation, like, for example, when I was Attorney General and we were investigating something that related to someone who had a relationship with President Bush, I could just orient them that, there's going to be a story tomorrow that, says this, but in that particular case, there was no chance that it would affect the investigation. So sometimes judgment calls are necessary.
If you learn that the White House, not directly through you, but through other means, was attempting to interfere with the investigation, would you report that information to the special counsel and to Congress?
Well, there's some conclusions in there about interfering, and if I thought something improper was being done, then I would deal with it as Attorney General.
Last, in that confirmation hearing back in 1973, then Senator Birchby of Indiana asked Richardson, suppose the prosecutor determines it's necessary to get the president's affidavit or to have his testimony personally. Would that be the kind of determination he, the special prosecutor, could make? Richardson said, yes. Will you give a similar answer today that you won't interfere with Special Counsel Mueller seeking testimony from the president?
You know, I think, as I say, the regulations currently provide some avenue if there's some disagreement. I think that in order to overrule Mueller, someone would have to the Attorney General or the acting Attorney General would have to determine, after giving Mueller's position great weight, that it was so unwarranted under established policies that it should not be done. So that's the standard I would apply. But I'm not going to surrender the regulations give some responsibility to the Attorney General to have this sort of general not day-to-day supervision, but sort of be there in case something really transcends the established policies. I'm not surrendering that responsibility. I'm not pledging it away.
What gives me pause and sort of led me to this line of questioning, Mr. Barr, was that June 2018 memo you sent to the Deputy Attorney General, in which at one point you state Mueller should not be permitted to demand the President submit to interrogation about alleged obstruction. If the special counsel wants to subpoena the President's testimony to ask questions about obstruction, and you're supervising the investigation, would you rely on that theory to block the subpoena?
Well, the question for me would be, what's the predicate? You know, and I don't know what the facts are. I don't know what the facts are. And if there was a factual basis for doing it, and I couldn't say that it violated established policies, then I wouldn't interfere. But I don't know what the facts are.
Well, if I might, just in closing, Mr. Chairman, we're in this unique situation where you've known Robert Mueller 30 years. You've said you respect and admire his professionalism, his conduct. He's been entrusted by you with a significant, complex investigations in the past. There's no reason to imagine, since he is the person who would know the facts, that he wouldn't be acting in an inappropriate way. So it is my hope, even my expectation, that you would trust Robert Mueller to make that decision about whether to compel the President to testify in an appropriate way and that he would not face any interference. Thank you for your testimony today. I look forward to a next round.
Senator Sass.
Thank you, Mr. Chairman, and congratulations on your new calling here. Liam, I have career advice. I won't do it on camera. We want to know if you're taking notes for your cousins about career advice, though. We'll ask you later. General, congratulations on your nomination, and thanks for your past service. I had planned to ask you for some pledges related to the Mueller investigation in private to me, in public today. I think you've already done that. How should the American people think about what the Mueller investigation is about?
I think that there were allegations made of Russian attempts to interfere in the election, and there were allegations made that some Americans were in cahoots with the Russians, and the word is now that's being used is collusion. And as I understand it, Mueller is looking into those allegations.
You know, a lot of the media summary of the investigation starts with people's views and who they voted for in the 2016 presidential election. And for those of us who spend a lot of time reading intelligence reports, a handful of us on this committee are about to leave to go to an intelligence briefing. What Russia is doing to the U.S. is big and broad and not constrained to the 2016 election. And increasingly, it feels like the American people reduce Russia to just how you thought about the 2016 presidential election. So since you'll have serious supervisory responsibilities over parts of the intelligence community, is Putin a friend or a foe, and what are his long-term objectives toward the U.S.?
Well, I don't hold myself out as a foreign policy expert, but I think that he is. I think the Russians are a potent rival of our country, and his foreign policy objectives are usually directly contrary to our goals. I think he wants to weaken the American alliances in Europe, and he also wants to become a player in the Middle East, more of a player in the Middle East. A lot of his foreign policy objectives are at odds with ours. At the same time, I think the primary rival of the United States is China. I think, Russia is half the size it was when we were facing them at the peak of the Cold War. Their economy is, long-term prognosis is nowhere near China's. I also feel that part of what Russia's up to is trying to hold on to Ukraine and Belarus in their orbit. But I'm concerned that the fixation on Russia not obscure the danger from China.
I want to ask you some China questions as well. I want to ask about your role on the President's Intelligence Advisory Board, but sticking with Russia for a minute. Does Putin have any long-term ideological alignment with the U.S., or does he have other objectives trying to sow discord broadly here?
I'm not an expert on this area, but I think there are, I think there may be some potential areas where our interests could be aligned.
But when he interferes here, does he have long-term interests in the success of one or another political party, or does he have specific interests in sowing chaos and discord to make Americans distrust one another? And one of the reasons I ask is because I'd love to have you say in public some of what you said to me about at the end of this investigation, what happens next? Are you concerned that when the Mueller report is received, quite apart from the narrowest pieces, you know where I'm headed?
Yeah. So, I think that the basic vulnerability of the United States in the age in which we live, the internet age, the globalization of information and so forth, is the vulnerability of that we're seeing, which is people can create doubt, undercut confidence in our election process, and also torque our public discourse in ways that we find hard to perceive. And this has long-term danger for the United States and the survival of a democratic society like ours. And so I hope that whatever the outcome of the Mueller investigation, that we view this as a bigger problem of foreign interference in our elections, which is why I said it was one of my priorities. And it's not just the Russians, it's other countries as well. And we have to focus on that. We have to ensure that we're doing all we can. And I'm not sure all of that is defensive either. I mean, in terms of law enforcement, I think we have to look at all options, including sanctions and other options to deter organized efforts to interfere in our elections.
So you have no reason to doubt any aspect of the intelligence community's composite assessment about Russian efforts in the 2016 election?
I have no reason to doubt that the Russians attempted to interfere in our election.
And Dan Coates, the National Intelligence Director, has testified in public and has said in different media contexts that Russia is already plotting for the 2020 elections in the U.S. You have no reason to doubt that.
I haven't, I haven't seen those reports. I had reviewed the reports about the 2016, but I have no reason to doubt it.
And can you explain what your role is on the President's Intelligence Advisory Board?
Yeah, I'm actually a consultant. I'm an advisor on sort of legal issues. Obviously, I'm stepping down from that position if I'm confirmed, but I've been just advising. I'm not a member of the board. I'm on the CIA's External Advisory Board, and have been participating on that as well.
When you talk about the long-term Chinese efforts to also sow different kinds of discord in the U.S., obviously not crossing any classified lines here, but long-term interests that other countries have in strategic rivalry with the U.S. to use gray space and information operations warfare against us. How do you see the role of the National Security Branch and the FBI more broadly fitting into the larger IC, and what responsibilities do you see would be on your priority list as you arrive at the department?
Well, I've been out of the department for so long. I'm not really sure about how that is currently being handled. I also think that we've had our attention focused on terrorism, which we can't let up. But I want to make sure that, and I'm sure Chris Wray is on top of this and, looking forward to talking to him about it, of making sure that the Bureau is playing a central role in combating, efforts by foreign countries to engage in those kinds of hostile intelligence activities.
You have unpacked a couple of times today the three different roles or functions of the Attorney General. Could you do that one more time in summary? And then I want to ask you a particular question. What are those three roles as you see them?
I see the three roles. In 1789, the first to set up the office, the first role was providing advice to the President and the Cabinet and representing the United States in cases before the Supreme Court. And I see the three roles as providing advice, being a policy advisor on legal and law enforcement policy issues, and the top law enforcement officer enforcing the laws.
And so in no way would the job of protecting the president be a subset of any of those three jobs? The language of protecting the president has been used occasionally in this administration to refer to the way it was conceived of how Eric Holder did his job. Is there any sense in which it's the Attorney General's job to protect the president?
No, that wasn't included in my description of the role of the Attorney General. Obviously, as in the policy arena, the Attorney General is someone who should be sympathetic to the administration and its policy goals.
But there are circumstances where those three roles could come into some internal conflict, or you could be asked to do things that don't align with them. And there's probably a list that you have. I want to ask you to enumerate it here. But there's probably a list of issues where you could imagine needing to resign because of what you were asked to do in the space of so-called protecting the president.
If I was ever asked to do something that I thought was unlawful and directed to do that, I wouldn't do it, and I would resign rather than do it. But I think that should be true of every officer who serves anywhere in government, whatever branch.
I am at time, but I had a series of questions related to some of what Senator Ernst did about Sarah's Law. She and I have jointly been active in that space. The tragic case of the young woman that she was talking about from Council Bluffs it occurred in Omaha, and Edwin Mejia, her killer, is still at large, and both the last administration and this administration have not prioritized that enough in our understanding, and I imagine that Senator Ernst and I will follow up with a letter to you on that as well. Thank you.
Senator Blumenthal.
Thanks, Mr. Chairman. I congratulate you, and I look forward to working with you, and congratulate also the new members of our committee that have joined us, and thank you very much, Mr. Barr, for being here today, for your past record of public service, and I hope I am perhaps the last to make reference to your grandson by saying that if he makes it through this hearing today, he can have any job he wants in this building. Let me say first that as a former United States Attorney, I share your allegiance and admiration for the Department of Justice, and equally so, the Federal Bureau of Investigation. And I know that you respect Mr. Wray, the current director, but I think you would agree with me that the FBI is probably one of the best, if not the most professional, accomplished, skilled, and dedicated law enforcement agencies in the world. Would you agree?
Yes, Senator.
And I hope that the President agrees with you and perhaps shares that view more publicly in the future. When the FBI begins a counterintelligence investigation, if it is of the President of the United States for working with a foreign adversary, that decision would be subject to multiple levels of review within the FBI, correct?
I assume. I don't know what rules were in effect at the time.
Well, in your experience,
Yes.
there would be.
Yes.
And you have no reason to think that those rules have changed.
I don't know what the practice was. There was.
And almost certainly in that kind of extraordinary investigation, you would agree with me, it would be extraordinary for the FBI to be investigating the president for working with a determined foreign adversary. There probably would be information shared with the Deputy Attorney General or the Attorney General. Agreed?
I would hope so. The reason I'm hesitating is because, you know, some of these texts that we've all read are so weird and beyond my experience with the FBI. I don't know what was going on.
Well, these reports are stomach-churning in terms of the absolutely stunning and unprecedented kind of investigation that they reflect. You'd agree?
You mean the texts are stomach-turning?
The reports of the investigation of the president.
I'm not sure what you're talking about when you say the reports of the investigation.
The reports that the FBI opened an investigation of the president for working with a foreign adversary, Russia.
And what's stomach-churning about that? What is stomach-churning? The allegation against the president, or the fact
that kind of allegation would be made and be under investigation? Well, let me move on. Yeah. I want to talk about transparency. Will you commit to this committee that you will not allow the president or his attorneys to edit or change the special counsel report before it is submitted to Congress or the public?
I already said that I would not permit editing of my report, whatever report I or whoever is the Attorney General makes.
And will you commit that you will come to Congress and explain any deletions or changes that are made to that report before it is issued?
Okay, so, you know, there are different reports at work here. Which report are you? There are two different reports.
The special counsel report.
Okay, well, under the current regulations, the special counsel report is confidential. And the report that goes public would be a report by the Attorney General.
Will you commit that you will explain to us any changes or deletions that you make to the special counsel report that's submitted to you in whatever you present to us?
I will commit to providing as much information as I can consistent with the regulations. Are you saying, for example, that if information is deleted that would be like for classification purposes, I would identify that and things like that?
Well, that you will commit to explaining to us what the reasons are for your deleting any information that the special counsel includes that you are preventing us or the public from seeing.
You know, that would be my intent. I have to say that the rules, I don't know what kind of report is being prepared. I have no idea. And I have no idea what Acting Attorney General Rosenstein has discussed with Special Counsel Mueller. If I'm confirmed, I'm going to go in and see what's being contemplated and what they've agreed to and what their interpretation, you know, what game plan they have in mind.
Will you permit
But my purpose is to get as much accurate information out as I can consistent with the regulation.
Well, the regulations and rules give you extraordinarily broad discretion. And I'm hoping, and I'm asking you to commit, that you will explain to us information that you have taken out of that special counsel report. And I also want to ask you about restrictions on the special counsel. Will you commit that you will allow the special counsel to exercise his judgment on subpoenas that are issued and indictments that he may decide should be brought?
As I said, I will carry out my responsibilities under the regulations. Under the regulations, whoever is Attorney General can only overrule the special counsel if the special counsel does something that is so unwarranted under established practice. I am not going to surrender the responsibilities I have. You would not like it if I made some pledge to the president that I was going to exercise my responsibilities in a particular way, and I'm not going to make a pledge to anyone on this committee that I'm going to exercise it in a particular way or surrender it.
Will you allow the special counsel to exercise his judgment as to what resources are necessary? Will you meet those needs for resources?
That would be my expectation. I think, I mean, if you believe the media, they're sort of starting to reduce their resources, so I wouldn't expect that would be a problem.
Will you allow the special counsel to exercise his judgment as to what the scope should be? The president has talked about red lines around finances. Will you allow the special counsel to exercise his judgment about what the scope should be, even if the president says that there should be red lines?
I think the scope of the investigation is determined by his charter from the acting attorney general. And if he wants to go beyond that charter, I assume he would come back and talk to whoever the attorney general is about.
Will you impose any restrictions on other prosecutors who are also investigating the president? As you're well aware, in the Southern District of New York, the president has been named, in effect, as an unindicted co-conspirator. The Eastern District of Virginia has an investigation that's relevant to the president. Will you impose any restrictions on those prosecutors?
The Office of Attorney General is in charge of the with the exception of the special counsel who has special rules applicable to him, is in charge of the work of the Department of Justice.
But you have a responsibility to allow prosecutors to enforce the law.
I have the responsibility to use my judgment and discretion that are inherent in the Office of Attorney General to supervise. And I'm not going to go around saying, well, this U.S. attorney or that U.S. attorney I'm going to defer to.
Well, you referred earlier to the possibility of firing a United States attorney. Would you allow the president to fire a United States attorney and thereby stop an investigation?
I would not stand by and allow a U.S. attorney to be fired for the purpose of stopping an investigation, but the president can fire a U.S. attorney. They're a presidential appointment.
But the president should have a cause beyond simply stopping an investigation for firing a United States attorney, even if he or she is a political.
Well, as I said, I would not stand by and allow an investigation to be stopped if I thought it was a lawful investigation. I wouldn't stand by for that. But the president is free to fire his officials that he's appointed.
I want to ask a question on a different topic. You said that, and I'm quoting you, I believe Roe v. Wade should be overruled. You said that in 1991. Do you still believe it?
I said in 1991 that I thought as an original matter it had been wrongly decided. And that was what, within 18 years of its decision? Now it's been 46 years. And the department has stopped, under Republican administration, stopped as a routine matter, asking that it be overruled, and I don't see that being turned. I don't see that being resumed.
Would you defend Roe v. Wade if it were challenged?
Would I defend Roe v. Wade? I mean, usually the way this would come up would be a state regulation of some sort, and whether it's permissible under Roe v. Wade, and I would hope that the SG would make whatever arguments are necessary to address that. I think the justices the recent ones have made clear that they consider Roe v. Wade an established precedent. It's been on the books 46 years.
And you would enforce the Clinic Access Protection Act?
Absolutely.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Barr, congratulations on your nomination. Thank you for being here. You were eminently qualified for this position when you were confirmed unanimously by this committee 27 years ago, and you are eminently qualified today. It's a pleasure to have you here. I want to start where Senator Blumenthal started as well, with the reports about the FBI counterintelligence investigation launched against the president, which I also find to be stomach-turning, though perhaps for different reasons. The New York Times report indicates that the FBI began the probe in part because they were concerned about the president's foreign policy stances, comments he made during the 2016 campaign about foreign policy, and the Republican Party's official position on the Ukraine. In your experience with the FBI, is it strange to have a counterintelligence investigation begun because members of that bureau disagree with the foreign policy stances of a candidate for president or a president of the United States?
Yes.
The Supreme Court has been unequivocal that the president in our system of government, the president possesses, and I'm going to quote now, the plenary and exclusive power as the sole organ of the federal government in the field of international relations, a power which does not require as a basis for its exercise an act of Congress. That's the very famous Curtis Wright case. To your knowledge, is that still good law?
Yes.
And do you think that was rightly decided?
Yes.
Let me ask you this. Would it concern you as Attorney General if FBI agents were making decisions about when and how to launch an investigation of an elected official if it was in order to avoid being supervised or directed by their agency leadership? Would that be concerning to you?
Yes.
As is, I might just add, reported by the New York Times. Let me switch gears and ask you about another topic that you mentioned a little bit earlier in the field when we were talking generally about antitrust. This is something you talk about things that have changed in the 27 years since you were last here. One of the things that has changed is the extraordinary concentration of power in our economy in the hands of a few corporations, no more so than in Silicon Valley, which you referenced earlier today. And I just want to ask you a little bit about that. Big tech companies like, for instance, Google and Facebook, who have drawn much attention of late, pose significant challenges not just for competition, but also for the larger issues of privacy and the free flow of ideas. The Justice Department has recently deferred to the FTC across this range of issues, and while I'm hopeful that Chairman Simons will right the course here, the FTC has perhaps too often allowed these companies, in my view, to violate privacy and maybe antitrust laws without meaningful consequences. Here's my question. What role do you think the Justice Department has working with the FTC or independently to address anti-competitive conduct, potential bias, and privacy violations by these big tech companies?
Well, obviously, competition is of central concern to the Antitrust Division, and you know there are, I guess, concordats that have been reached between the FTC and the Antitrust Division as to who has primary jurisdiction in different areas. But I would like to weigh into some of these issues. I'd like to have the antitrust support that effort to get more involved in reviewing the situation from a competition standpoint. I also am interested in the issue of privacy and the question of who owns this data. You know, it's not an area that I've studied closely or become an expert in, but I think it's important for the department to get more involved in these questions.
Just on the subject of ownership of data, as you know, Facebook is currently subject to a 2011 consent decree, as part of which it agreed not to release or share or sell personal user information without the knowledge and consent of its users. Facebook's CEO, Mark Zuckerberg, has adamantly insisted under oath as recently as April 10th of 2018, that on Facebook, users have complete control, those are his words, over everything that they share. However, as I'm sure you're aware, recent media reports have indicated that Facebook, in fact, routinely has shared user information without users' consent or even knowledge. Now, the Justice Department has the authority to enforce the terms of the 2011 consent decree and potentially to prosecute any violation. Will you consider doing so?
Well, because that is something that I might have to get involved with and supervise if I'm confirmed, I'd rather not, you know, make any comments about it right now.
Let me ask you this. These same technology companies also control the flow of information, or at least influence it, the flow of information to consumers to an unprecedented degree. I mean, you have to go way back in American history to find any analog, back to the paper trust, to find an analog of a small group of companies that control the information and influence the news and its flow to Americans to the extent that these companies do. And there's growing evidence that these companies have leveraged their considerable market power, if not monopoly status, to disfavor certain ideological viewpoints, particularly conservative and libertarian viewpoints. Do you think the Department of Justice has authority under the antitrust laws or consumer protection laws or other laws to address bias by dominant online platforms?
I would just say generally, I wouldn't think it would, I'd have to think long and hard before I said that it was really the stuff of an antitrust matter. On the other hand, it could involve issues of disclosure and implicate other laws like that.
Is there any point, do you think, at which political bias could require a response? And I'm thinking, for example, Harvard law professor Jonathan Zittrain has written how Google or Facebook, for example, could manipulate their algorithms to significantly swing voter turnout to favor a candidate of their choice. Would that sort of conduct require a response from the department?
I'd have to think about that. I'm not sure. I'd like to know more about the phenomena and what laws could be implicated by it.
Let me ask you this. The Justice Department's case against AT&T Time Warner focused on how the merged company would control or could control the distribution of information to discriminate against rival content. And I understand that you, of course, are recusing yourself from that matter. But generally speaking, do you see similar concerns regarding how dominant Silicon Valley firms could use their market power in social media or search to discriminate against rival products or services or viewpoints?
Yeah, and making clear that what I'm saying now has no application to, the transaction we just talked about, and talking about the other companies, yes.
Let me ask you more broadly about the question of antitrust and mergers, and you gestured towards this earlier in your testimony. I'm increasingly worried that the department is not enforcing vigorously the antitrust statutes in many sectors of the economy, not just technology. We see, again, as you've alluded to, we see growing concentration of power in various sectors held by just a few firms. And if you look at recent trends in the department's scrutiny of proposed mergers, it's at record lows. Last year, for instance, the Department of Justice Antitrust Division scrutinized mergers through second requests for information in less than 1% of all eligible cases. That is, I believe, the lowest level of merger scrutiny recorded since the FTC started tracking those statistics back in 1981. And just for comparison purposes, in 1981, that review was 5 times higher than it was in 2018. My question is, do you think that this record low level of merger scrutiny is appropriate? And if you're confirmed as Attorney General, what might you do to ensure that the Antitrust Division faithfully and vigorously enforces the law?
Well, I am for vigorous enforcement of the antitrust laws to preserve competition. And as I said, this is going to be an area I'm going to want to get into and work with Macon Delrahim on if I'm confirmed. I wouldn't necessarily use the incidence of merger review as a proxy for failure of competition. At the end of the day, it's competition we're worried about in different markets. But I am interested in exploring those, those statistics you were just using.
And do you think it's fair to say, would you agree that the historic levels of concentration that we're seeing in many parts of the economy, technology in particular, is potentially detrimental to competition? I mean, it is, again, potentially and in general, but it is something that is worth scrutinizing and being concerned about if one is concerned about free, fair, and open competition.
You said the size?
Yes, the historic levels of concentration.
Yeah, I think the thing I'm concerned about are the network effects that are now at work, where they're so powerful that particular sectors could essentially be subsumed into these networks. They're just very powerful network effects because of the size.
Yes, I see my time has almost expired. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Chairman, I welcome the arrival of the immigration Lindsey Graham of 2013. The other Lindsey Graham, we shall see, as you yourself have acknowledged. Mr. Barr, I ask these questions, these two questions of every nominee who comes before any of the committees on which I sit. And these are the questions. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No.
I have a question relating to recusal. You've been asked a number of times. It is very clear that the president does not want an attorney general who will recuse himself from the Mueller investigation. So when he came before us for confirmation in January 2017, Jeff Sessions wrote on his committee questionnaire that he would, quote, seek and follow the advice of the Department of Justice's designated agency ethics official if confronted with a conflict of interest, end quote. And in fact, he did do that, and he was basically pummeled by the president ever since. So Matthew Whitaker has not come before us for the job of Attorney General, but we know that when it came time to make a decision about recusal, he didn't want to be the object of Trump's wrath, so he proceeded to listen to and then ignore the advice of the career ethics officials at the DOJ who recommended recusal. So your answer to Senator Klobuchar makes it clear that you are going to basically follow the Whitaker model. Can you understand why that is not terribly reassuring to us? These are not normal times. This is not 27 years ago. Today, the president is Donald Trump, who will do anything to protect himself. He wants you, who has written a manifesto about why the president shouldn't be prosecuted, at least for obstruction of justice, who has met with and consulted with the president's defense attorneys, who has written op-eds defending his firings of Sally Yates and James Comey to be his attorney general. So in this context, just asking us to trust you is not enough. Why won't you simply follow Jeff Sessions' lead and take and follow, the critical portion being follow, the advice of the department's ethics officials?
Because the regulations and the responsibilities of the Attorney General as the head of the agency vest that responsibility in the Attorney General. And I am not going to surrender the responsibilities of the Attorney General to get the title. I don't need the title. If you don't trust me if
you have, excuse me,
Yeah.
you have repeated that answer many, many times. However, I think we all acknowledge that Jeff Sessions possibly didn't want to recuse himself, but he did. And so you have it within your power to follow the ethics advice of your own department, and you're telling us you're not going to. So that is the bottom line.
No, Senator, I think Jeff Sessions recused himself because of a different provision, which was the political conflict provision.
I think
He played a role in
the
campaign.
In the context of all of the things that you have done, basically to get the attention of President Trump to nominate you, I would say that there's a political context to what your decision should be also. Let me move on. You have said that you will allow Mueller to complete his work. Although, you know, I do want to ask you very specifically, because you did write that 19-page memo relating to the obstruction of justice issue. Would you allow the Mueller investigation with regard to obstruction of justice to also go forward unimpeded by you?
I don't know whether there's an investigation of obstruction of
Well, definitely obstruction of justice. You read the papers as well as we do, that is an element of the Mueller investigation. I don't think you can sit here and tell us that you do not think that that is a part of the investigation. But let's say that it is. Having written what you did, would you seek to stop that portion of the Mueller investigation? That being the obstruction of justice portion, assuming that that is in fact part of the investigation.
Okay, but you have to remember, my memo was on a very specific statute and a specific theory that I was concerned about. I have no basis for suspecting at this point that that is in play at all.
You mean that particular provision?
That
Mueller's
provision or theory,
Well, I did say, let's assume that, in fact, obstruction of justice is part of the Mueller
No,
investigation.
when I say theory, I mean, what I was addressing was, you know, whether the removal of Comey in and of itself would be obstruction.
Of course, it's not in
under
and
a
of
particular
itself.
under a particular statute.
I hate to be interrupted, but, you know, I only have 4 minutes, so thank you very much. You were asked about the investigations that are going on in the Southern District of New York, the Eastern District of Virginia, the District of Columbia, and there are various investigations brought by various U.S. attorneys' offices relating to the activities of Donald Trump, his campaign, his inauguration, his foundation, his businesses, his families, his associates. Do you consider these to be lawful investigations? Because I believe that you responded to Senator Blumenthal that if these are lawful investigations by the U.S. attorney's offices, that you do not see yourself interfering with them.
I have no reason to think they're not lawful investigations, whatever they are. Seem to know more than I do about what's under investigation.
That's reassuring that you're wanting to have the Mueller investigation go forward extends to all of these other U.S. attorneys' investigations. I believe you also said that the Mueller report will be confidential. It is confidential under the special counsel's, whatever the criteria are. So what I'm hearing you saying that in spite of the fact that you want to be transparent, neither Congress nor public will get the Mueller report because that's confidential. So what we will be getting is your report of the Mueller report, subject to applicable laws limiting disclosure. So is that what you're telling us?
I don't know what at the end of the day, what will be releasable. I don't know what Bob Mueller is writing.
Well, you said that the Mueller report is confidential pursuant to whatever the regulations are that applies to him. So I'm just trying to get as to what you're going to be transparent about.
As the rules stand now, people should be aware that the rules, I think, say that the the special counsel will prepare a summary report on any prosecutive or declination decisions, and that shall be confidential and shall be treated as any other declination or prosecutive material within the department. In addition, the Attorney General is responsible for notifying and reporting certain information upon the conclusion of the investigation. Now, how these are going to fit together and what can be gotten out there, I have to wait, and I would have to wait. I'd want to talk to Rod Rosenstein and see what he has discussed with Mueller and what.
But you have testified that you'd like to make as much of the original
right. And so
report
all I can say right now
open
is
as possible.
Yeah, all I can say right now is my goal and intent is to get as much information out as I can, consistent with the regulations.
So in the minute that I have, I'd just like to go over some of the policies that Jeff Sessions has followed. One is zero tolerance policy, which led to the separation of children from their parents. He refused to defend the Affordable Care Act and argued in the Texas lawsuit that key parts of the ACA was unconstitutional. He failed to bring a single lawsuit to enforce the Voting Rights Act to stop voter suppression efforts, and he issued a memo making it harder for the Civil Rights Division to enter into consent decrees to address systemic police misconduct. Do you agree with these policies? Do you intend to continue them?
Well, the last one, yes, I agree with that policy. The other ones, I'm not. I'd have to see what the basis was for those decisions.
So do you think that as to the last one, which has to do with consent decrees, that there is a role for the Department of Justice in addressing systemic police misconduct?
No,
you don't see much of a role in that, or you
no,
see
that's
a
your
more limited role?
That's your characterization of it. That's not what I understand the policy to be. Of course, the department has a role on pattern and practice violations.
So the Attorney General Sessions has issued a rule that makes it a lot tougher to enter into these kinds of decrees.
Why do you say it's a lot tougher?
Because it's not just relying on the career attorneys, that now it goes to the deputy AG or whoever. There are more political appointees who are going to get involved in that process, and that makes it much more limited, I would say, in utilization. Thank you, Mr. Chairman.
Arano, we'll take a 10-minute comfort break and start with Senator Tillis. My math is right. We've got about an hour left on round one, so 10 minutes be okay, Mr. Barr? Okay, thank you. Adjourn for 10 minutes.
You're watching live coverage from the Washington Post. This confirmation hearing for William Barr, set to be the next Attorney General of the United States. His first step is getting approval from this committee. I'm Libby Casey, and my guest is Aaron Blake. Aaron, no signs that Republicans are going to defect from this nominee. Obviously, it has a lot of support. We just heard Mazie Hirono, Democrat of Hawaii, ask some of the most pointed questions, really, of this hearing.
Yeah, and I thought that she actually drew Barr out a little bit more on this question of whether he would release the Mueller report in total. I thought that her questioning was a little bit kind of all over the place on that particular aspect of it, but he didn't seem to know what to do with that. And he actually said something that he hadn't said before, which it wasn't appreciably different than what he said before, but he also, and I forget what the exact quote was, but it was something to the effect of, I don't know what aspects of that report might be, quote unquote, unreleasable. So, you know, before he has talked about how he wants to release as much as he can subject to the law, here he kind of acknowledges that there could be things that he believes the law does not allow him to release. And so I thought it was interesting that he actually admitted that there could be things that fall under that umbrella. Exactly what those things are, we don't know yet, but I would expect that the Democrats might draw him out a little bit more on that.
This question of recusal is also very important, and he stayed firm on the sense that he is going to make the decisions of the Attorney General, and he's not going to defer that decision-making process to someone else. But that was a really interesting exchange because in the questioning, there are multiple Democrats who've gone on this line of questioning. The questioning is, if you get ethics guidance that you should not be overseeing the Mueller probe, essentially what will you do? Will you abide by that? And he's been really firm on saying, this is my decision, my choice.
Right. So early in the hearing, at the very top of the hearing, in fact, he said that this was his responsibility, that, you know, he was asked if he would abide by that, and he basically said, I have the authority to make the decision myself. He didn't specifically answer one way or another whether he would abide by that advice, but he suggested that he wouldn't. You fast forward a couple hours, and he was asked about this again, and then he got into a little bit more detail. He said that not only, you know, before he suggested that he wouldn't abide by it, then he said specifically, he was asked about Jeff Sessions, who did say that he would abide by that advice by the ethics officials, and he called that an abdication of his responsibility. He clearly said that this is not something that an attorney general should do. He went on to say a couple more times that he is not going to give up any of his responsibilities as Attorney General. So basically, if it is a responsibility that is vested in him by the regulations, he is not going to say, I'm just going to, of my own volition, give that up. I'm not going to volunteer anything for you guys. At one point, he even said something to the effect of, well, I don't really even need this job. Like he was saying, I'm only going to take the job if I have the responsibilities that come with it. And so I'm not going to make this promise to you guys just because you want me to. To me, that says...
But that's not what Democrats are trying to get at. They're getting at the heart of the matter of ethics, and whether or not, if an ethics recommendation is that you should not be involved in this. They're not talking about him ceding power, although he's framing it that way. They're talking about, you know, how this is looked upon big picture. He's taking a very different look at it.
Yeah, I think it depends on how you look at it. It certainly is a situation in which this is something that he can determine for himself. Legally speaking, he does not have to promise them anything. The only thing that's going to force him to promise them anything is if he feels like he needs to do it to win confirmation. He does not have to do that to win confirmation unless some Republicans are concerned about this. So until Ben Sasse or some Republican in the wider Senate like Mitt Romney raises a concern about this, he does not have to make that promise, and he can lose all the Democratic votes and still get confirmed.
I'm looking at the list of members of this committee, and we already heard Ben Sasse ask questions. There's not a sense that Republicans are going to give much pushback at this point. I thought Sasse's questions were really interesting because he was getting to this issue of Russia and what the relationship with Russia is. And while we heard Mr. Barr talk about Russia as essentially a rival, an adversary, he then pivoted to China and said that he thinks China is even more of a looming presence, which sounds in line with something I would think the White House would like to hear.
Yeah, we were talking before about the audience of one. That's very much the audience of one. People might remember before the 2018 election, you know, the White House and various Trump administration officials we're raising China up as the bigger threat, as the people who were actually allegedly interfering in the 2018 midterms, which there was no actual evidence of. And so, this has been a way for the administration to shift the focus and to argue that maybe Russia isn't so bad, that China is the bigger obstacle here. The fact that he inserted that, like he's inserted a number of other things that we've talked about before, I think is clearly a sign that he's there with at least one part of his brain thinking about what the guy who nominated him is thinking about this whole thing.
Aaron Blake, senior political reporter for The Fix. I'm Libby Casey. We're here with you until the hearing gets back underway. And even though we are not yet through round 1 of questioning, there's a whole second round yet to come, because this committee is going to get a second bite of the apple later on this afternoon. And we're still waiting to hear from some Democrats who are being watched for their political aspirations, namely Cory Booker, Kamala Harris. We already heard from Amy Klobuchar, and she had really, like Mazie Hirono, a rapid fire set of questions, and she covered a spectrum of issues. But there was a lot of heat there and a lot of pressure on him to sort of think fast on his feet and come up with some answers, some of which she seemed to accept and others that seemed to raise concerns for her.
You can tell as we're moving forward in this hearing which members of the committee are former prosecutors. Amy Klobuchar is a former prosecutor. She knew she had limited time. She wanted to move it along, get as many answers as she could. I thought it was really interesting when she drilled down on press rights. Obviously, we have an interest in those kinds of things, so it's interesting to us. But her father I grew up in Minnesota. Her father was a name that we all knew. He was a journalist at the Minneapolis Star Tribune. And so she drilled down on what kinds of limitations there could be on press rights. She asked whether journalists could ever be jailed. Barr gave an answer that was kind of in line with what the Bush administration, Obama administration have done. She say it should be a last resort.
But Aaron, like that, the whole exchange was really revealing, whether it was intended to be or not by Bill Barr, because she also invoked the name Jamal Khashoggi, who was a Washington Post columnist who was killed. And so she gave it this really weighty context of international press freedoms and what are you going to do here? And he sort of said, there wasn't an initial response of, look,
with it for a
press
second.
freedom
Yes.
is paramount to our country and the safety of journalists is of great concern. And even in his opening remarks, he seemed to bring up concerns about, the threat of political violence and things like that. He didn't make any big sweeping statement about, I believe this and these are the freedoms we hold dear. Instead, he went right to the legalities of, well, there are guidelines in place and I can conceive of a situation where, as a last resort, if a news organization has run past a red flag, essentially someone could be jailed.
Right.
So the tone of it was raised some eyebrows.
I do think that the tone was probably more notable than the content. As I said, the content of his answer was in line with how the Obama administration handled this, although they did get criticized for it, how the Bush administration handled this, although they did get criticized for it. He said this was a last resort. This is something that only happens if a news organization has been given red flags, if they do something that they know is dangerous to the country. He said that's about the only situation in which this would be allowed. But you're right, the fact that he didn't preface that a little bit by saying, offering even just some platitudes about the importance of the free press, I thought was interesting. And I think maybe Klobuchar, more than other members of the committee, maybe caught him a little bit off guard with that line of questioning that perhaps he wasn't really expecting.
Let's go live to Capitol Hill, where our colleague Rhonda Colvin is standing by. Hi, Rhonda.
Hi, Libby. Yes, we just spoke to Dianne Feinstein. Now, she is the ranking member of this committee, so she told us her insight on what has been going on, what she's seen, and basically she's very confident that this process is going very well as expected. She told us that he's being very forthcoming with his answers to them, and most importantly, that he is addressing the concerns that her party has about how he'll approach the Mueller investigation. And when I asked her, how long do you think this will be going on? Do you think this will be an easy confirmation? She said yes. She doesn't see a reason why it wouldn't be an easy confirmation. So that's the news that we have from the ranking Democrat on this committee, and which I think is very interesting for her to be pretty positive and confident about this process.
Rhonda, yeah, very revealing. Democrats don't have the votes, just by the numbers, Aaron, to stop this in its track. We don't know if Democrats are going to support him and pass him through committee. They could certainly pass him through committee and then opt not to vote for him on the floor. But unless any Republicans defect, he's got clearance, really,
Right.
through this process.
It's one thing to know the state of political play, and we've all acknowledged that this is very unlikely to be a defeated nominee. But it's another thing to come out and say that during the confirmation hearing, basically say we're probably not going to succeed here. I thought it was interesting, Chris Coons, during his time questioning the nominee, referenced the fact that he was, quote, encouraged by some of the answers that William Barr had given in the Mueller probe. You know, I think if there are two members of the committee where we'd expect that kind of honesty about, maybe they'd step outside of kind of what the base wants to hear from them, and they'd actually say what they actually think about the hearing. Coons and Feinstein would very much be those people. But I thought it was interesting. Coons didn't have to come forward and actually say that he was encouraged, and that he actually liked what Mueller was what Barr was saying about Mueller. I think saying something like that is going to make it more difficult for Booker and Kamala Harris to come out now and argue that those answers have been insufficient, which is something that they could have argued given that, Barr hasn't really played ball with the recusal question. He hasn't really given them any assurances that they necessarily thought that they would get.
Let's talk about the line of questioning that Amy Klobuchar started with, Senator Klobuchar, which referenced the furloughed workers and the government shutdown, which has not been addressed that much through this process. And Rhonda pointed out earlier that Bill Barr mentioned it in his opening, especially as it relates to members of the FBI who are not getting paid right now. But Amy Klobuchar put it out there right up at the top of her question. And it quickly got into a conversation about border security rather than furloughed workers or people who aren't getting paid. And she brought up the political fights the Democrats have had on border issues, on the Dreamers. And Bill Barr seemed to take a very traditional Republican stance on his responses to this question of quote-unquote border security and the political fight that's going on right now.
Yeah, he took the position that Republican senators are taking right now. He said something to the effect of, I hope the government can open up soon after Democrats come to the table and give us border security, including a barrier at the border. He doesn't have to sit on that dais right there and come out for the border wall. It would be conspicuous perhaps if he said he opposed the border wall, but he doesn't necessarily need to support everything the president does. He can implement the president's policies without supporting them personally. The fact that he waded into that very controversial aspect of this shutdown debate right now, I think speaks to the fact that he feels pretty confident about his political standing in this confirmation hearing right now.
And Bill Barr reseated there, so we'll head back to the confirmation hearing.
On our side is Kennedy, Senator Kennedy, Blackburn, and Tillis, and Senator Booker, Harris. Anybody else? I think that's it. And round one. So, Senator Kennedy.
Thank you, Mr. Chairman. Mr. Barr, do you know of any instance in which anybody has tried to interfere in Mr. Mueller's investigation?
No, I mean, I'm not in the Department of Justice, and I have I'm not privy to that information, but I don't know of any.
I understand you know Mr. Mueller, do you?
Yes, I do.
Is he big enough to take care of himself?
He's a Marine.
Yeah. If someone had tried to interfere with his investigation, based on your knowledge of Mr. Mueller, would he have something to say about it, including but not limited to in a court of law?
Yes, Senator.
I want to try to cut through some of the innuendo here. Did President Trump instruct or ask you, once you become Attorney General, to fire Mr. Mueller?
Absolutely not.
Did he ask you to interfere in Mr. Mueller's investigation?
Absolutely not.
Has anybody in the White House made that suggestion to you?
Absolutely not.
Has anybody in the Western Hemisphere made that suggestion to you?
Absolutely not.
Okay. I want to associate myself with the remarks of Mr. Blumenthal about the FBI being the premier law enforcement agency in the history of the world, in my opinion, in the high esteem in which we all hold the Department of Justice. But I have a question for you. This counterintelligence investigation that was started by FBI and Justice allegedly about President Trump. How did the New York Times get that information?
I don't know, Senator.
Well, didn't it have to come from the FBI or the Department of Justice?
I just can't say. I don't know how they got it, and I don't know whether that's an accurate report.
Right. What do you intend to do about the leaks coming out of the FBI and the Department of Justice?
The problem of leaks is a difficult one to address. I think the first thing is to make it clear that there's an expectation that there are no leaks, and punish people through internal discipline if there are leaks. Also keep exercise more compartmentalization and discipline, and make the institutions that are responsible, if you're talking about the FBI, that their leadership is taking aggressive action to stop the leaks.
Okay. You've had some experience with the enforcement of our immigration laws, is that correct?
That's right, Senator.
Do you believe it is possible to secure a 1,900-mile border without, in part at least, using barriers?
No, I don't think it's possible.
Okay.
When I was Attorney General, we had the INS as part of the department, and I remember another part of my kibitzing was trying to persuade George W. Bush's administration not to break that out. But in those days, I had some studies done, and I was trying within the budget to put as much as we could on barriers as we could.
Okay. Do you believe that ICE should be abolished, as some of my colleagues do?
Certainly not.
Okay. You're Roman Catholic, are you not?
Yes, I am.
Do you think that disqualifies you from serving in the United States government?
I don't think so, no.
Okay. Why is that?
Why doesn't it disqualify me?
Some of my colleagues think it might.
Because you render under Caesar that which is Caesar's, and unto God that which is God, and I believe in the separation of church and state, and if there was something that was against my conscience, I wouldn't impose it on others. I would resign my office.
Yeah. I think it's called freedom of religion,
Yes.
as I recall.
That's right.
If the federal government threatens to withhold federal money from a university, if that university doesn't investigate, prosecute, punish sexual assault in a way prescribed by the federal government, does that make the state university a state actor, or the university a state actor?
It may. I would have to look at the cases. I'm not up to speed on those, but I would think so.
Well, if the federal government says to a university, look, if you do not prosecute, investigate, punish allegations of sexual assault in a way that that the federal government says you must, otherwise we're going to take away your federal money. Does the accused in one of those sexual assault allegations still have the protection of the Bill of Rights?
I would hope so.
Should he or her?
I'd have to look and see exactly the state actor law right now. But what you're getting at is, the rules that were forced on universities in handling sexual harassment cases.
Right.
That I felt essentially did away with due process.
Yes.
And I think the victim, as a father of three daughters, I take very seriously any question of sexual harassment. It's a serious problem, and the word of a victim has to be taken very seriously, and it has to be pursued, but we can't do it at the expense of the Bill of Rights or basic fairness and due process.
Both the accused and the accuser deserve due process, do they not?
That's right.
Okay. Tell me what the legal basis is for a universal injunction.
I think universal injunctions are have no. Well, let me say that they are a recent vintage. They really started arising in the '60s, and I think that they have lost sight of a limitation on the judicial power of the United States, which is case or controversy.
It's all based on the D.C. Circuit
Right.
case, the Wirtz case. Is that right?
I forgot the name of the case, but I think the D.C. Circuit case was the first one. I think that was in the '60s, and people have lost sight of the fact that it's really a question of who gets the relief in a case, and under the case or controversy, it should be limited to the parties. And when earlier you could have a court in one jurisdiction decide it, and that would be the rule in that jurisdiction.
Mm-hmm.
But that didn't debar the government from continuing its policies elsewhere, and eventually you'd get differences, and they would work their way up to the Supreme Court. So I think that I'd like to see these universal injunctions challenged.
Well, I don't know how many federal district court judges we have. Let's say 650. As I understand it, one can enjoin a congressional statute nationwide, even if the other 624 judges disagree.
That's right.
All right.
And not just a statute, Senator. I think what's different, what we're seeing is the willingness of courts to set aside, even the kinds of exercises of national security power that 20 years ago would have been unimaginable for a court to challenge, and yet a district court judge somewhere can enjoin some action that has a bearing on the safety of the nation, and then the judicial process can take years and years to get that up to the Supreme Court.
I've just got a few seconds left. As I understand your testimony, General, Mr. Mueller will write a report, submit it to you as Attorney General, and then you will write a report based on that report and release your report. Is that right?
That's essentially it, but I wouldn't assume, it could easily be that the report is communicated to the department before, assuming I was confirmed. That could be a month away.
Well, let me tell you what I'm getting at. I've got 6 seconds. Now 4. The American people deserve to know what the Department of Justice has concluded. And they're smart enough to figure it out. I've said this before. The American people don't read Aristotle every day. They're too busy earning a living. But if you give them the facts, they'll figure it out, and they'll draw their own conclusions. Doesn't matter who spins them. They'll figure it out for themselves. And I would strongly encourage you to put this all to rest, to make a report, a final report, public, to let everybody draw their own conclusions so we can move on. If somebody did something wrong, they should be punished. But if they didn't, let's stop the innuendo and the rumors and the leaking, and let's move on.
I agree, Senator. And let me say, earlier I misspoke because the acting Attorney General is Matt Whitaker, and I referred to Rod as the acting Attorney General, but in fact, the report would go to Matt Whitaker.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. And I would like to remark, Mr. Barr, that your family is showing a prodigious level of patience, indefatigable endurance, and that should be marked for the record. You're a very lucky man. You know that about 30-plus states have legalized medical marijuana or adult use. You're aware of that, correct? Yes. In 2018, Attorney General Jeff Sessions rescinded the Cole Memorandum, which provided guidance to U.S. attorneys that the federal marijuana prohibition should not be enforced in states that have legalized marijuana in one way or the other. Do you believe it was the right decision to rescind the Cole Memorandum?
My approach to this would be not to upset settled expectations and the reliance interests that have arisen as a result of the Cole Memoranda, and investments have been made, and so there have been reliance on it. So I don't think it's appropriate to upset those interests. However, I think the current situation is untenable and really has to be addressed. It's almost like a backdoor nullification of federal law. To me, it's a binary choice. Either we have a federal law that applies to everybody.
And so I'm sorry to interrupt you, sir, but how would you address that? Do you think it's appropriate to use federal resources to target, marijuana businesses that are in compliance with state laws?
No, I said that. Yeah. I said I'm not going to go after companies that have relied on the Cole Memoranda. However, we either should have a federal law that prohibits marijuana everywhere, which I would support myself, because I think it's a mistake to back off on marijuana. However, if we want a federal approach, if we want states to have their own laws, then let's get there, and let's get there the right way.
And if you don't mind, I'm going to just move on, but it's good to hear at least the first part of what you said. During your previous 10 years Attorney General, you literally wrote the book on mass incarceration, or at least wrote this report, The Case for More Incarceration. You argue that we as a nation were, quote, incarcerating too few criminals.
In those days.
And that the solution was more incarceration for more people.
Excuse me.
Please, sir.
For chronic violent offenders and gun offenders.
Well, I mean that's the challenge, sir, and you argued against the bipartisan legislation in 2015 quite strenuously.
I did.
But that's not that's not the nature of incarceration in this country. In fiscal year 2016, only 7.7% of the federal prison population was convicted of violent crimes. Overwhelmingly, what was initiated in those times that led to an 800% increase in the federal prison population, overwhelmingly, that was nonviolent drug offenders. Right now, our federal prison population is overwhelmingly nonviolent. 47.5% of the federal prison population are incarcerated for drug offenses. And I guess hearing your arguments then and hearing your arguments against the bipartisan legislation that we brought out of the committee in 2016.
But Senator, I think that's wrong, what you just said, okay? I think when you have violent gangs in the city, killing people, murder and so forth and so on, sometimes the most readily provable charge is their drug trafficking offenses, rather than proving culpability of the whole gang for murder. So you can take out a gang on drug offenses, and you could be taking out a lot of violent offenders. Do you think that the murders in Chicago are they're related to gangs,
and
including
again,
gangs involved in
and sir, and again, and we can get into the data if you'd like, and I'd like to get some more pointed questioning. But this is the sort of these are sort of the tropes that make people believe that in inner cities we should have such profound incarceration rates. And I'd like to ask you specifically about that data, because I think it's language like that makes me kind of concerned and worried. You said you hadn't reviewed, you said earlier in your testimony you hadn't reviewed criminal justice data about this actual issue of incarceration versus non-incarceration. I just want to know, will you commit to commissioning a study on just the concerns that we're talking about right now about the efficacy of reducing mass incarceration and publish those results? Would you be willing to do such a study yourself?
Well, no, as I understand it, I've been told that there's a lot of data to support the First Step Act.
Yeah, and that First Step Act goes directly towards addressing a lot of the problems we've had in mass incarceration. And so if you're saying that it is necessary to deal with violence in communities by over-incarcerating, here's a bipartisan group of senators that's working towards reducing mass incarceration. And that's why I think it's very important, which I appreciate you saying you didn't know because you hadn't reviewed the data. I think it's very important that you review the data and understand the implications for the language that you're using, which brings up this language of race, which is often not said explicitly, but when you talk about Chicago in the way you just did, it brings up racial fears or racial concerns. And you stated that if a black and a white, this is quoting you directly, are charged with the same offense, generally they will get the same treatment in the system and ultimately the same penalty. You previously quoted, and I quote you again, there's no statistical evidence that there of racism in the criminal justice system. Do you still believe that?
No, what I said was that, I think that's taken out of a broader quote, which is the whole criminal justice system involves both federal but also state, local justice systems. And I said there's no doubt that there are places where there is racism still in the system. But I said overall, I thought that as a system, it's working, it's not predicated on.
So can I press you on that? Overall, the system treats blacks and whites fairly. From my own experience, I've lived in affluent communities, I've gone to the college campuses with you. There are certain drug laws applied there that's very different than the inner city community in which I live. But let's talk stats, let's not talk our personal experiences. And so I've sat with many of my colleagues and many conservatives who readily admit what the data shows. And so I have a whole bunch of reports which I'll enter into the record from nonpartisan, bipartisan groups, even conservative leaders talking about the rife nature of racial bias within the system. For example, the federal government's own data, the U.S. Sentencing Commission's research shows that federal prosecutors are more likely to charge blacks with offenses that carry harsh mandatory minimum sentences than similarly situated for whites. The federal government's own data shows that black defendants were subject to 3-strike sentencing enhancements at a statistically significantly higher rate, which added, on average, over 10 years to their sentences. And so with numerous researchers having found stunning racial disparities rife throughout our system and in the federal system, which you will be the chief law enforcement officer of, and primarily for overwhelmingly for drug laws. For example, I don't know if you're aware or not of the Brookings study that found that blacks are 3.6 times more likely to be arrested for selling drugs, despite the fact that whites are actually more likely to sell drugs in the United States of America, and blacks are 2.5 times more likely to be arrested for possession of drugs when there is no difference racially in America for the usage and possession of drugs in the United States. I don't know if are you familiar with the Brookings study?
No, I'm not.
Okay, so just a follow-up, will you commit to commissioning a study examining racial disparities and the disparate impacts of the policies that you talked about and that led to mass incarceration, the policies that you defended when you criticized the bipartisan 2015 sentencing reform legislation? Will you commit to, at least as the most important law enforcement officer in the land, to studying those well-documented racial disparities and the impacts it has?
Of course I'll commit to studying that, and I'll have the Bureau of Justice Statistics pull together everything they have, and if there's something lacking, I'll get that, and I'm interested in the state experience. But when I looked at this, I think 1992 was a different time, Senator. The crime rate had quintupled over the preceding 30 years, and it peaked in 1992. And it's been coming down since 1992.
And sir, I just want to tell you, I was a young black guy in 1990s. I was a 20-something-year-old and experienced a dramatically different justice system in the treatment that I received. Okay. And the data of racial disparities and what it's done to black communities, because you literally said this about black communities, and I know that your heart was in the right place. You said that, hey, I want to help black communities. This is what you're saying. The benefits of incarceration would be enjoyed disproportionately by black Americans living in inner cities. You also said that, quote, a failure to incarcerate hurts black Americans most.
And I'll tell you what's...
And I just want to ask you a yes or no question, because I have seconds left. Do you believe now, 30, 40 years of mass incarceration, targeted disproportionately towards African Americans, harsher sentences, disproportionately represented in the criminal justice system, with the American Bar Association talking about once you've been incarcerated for even a low-level drug crime, there are 40,000 collateral consequences that impact your life. Jobs, Pell Grants, loans from banks. Do you think, just yes or no, that this system of mass incarceration has disproportionately benefited African American communities? Yes or no, sir?
I think the reduction in crime has since 1992, but I think that the heavy drug penalties especially on crack and other things, have harmed the black community. The incarceration rates have harmed the black community.
And I would just conclude to my chairman and partner, thank you, sir, on this, because I'm really grateful for this bipartisan group, the Heritage Foundation. I've spoken at the AEI conference, just found such great partnership, but I worry about the highest law enforcement officer in the land and some of the language I still hear you using that goes against the data, and that you're going to be expected to oversee a justice system that you and I both know needs the faith and confidence of communities, that has dramatically lost that confidence because of implicit racial bias. And the DOJ, and I'll give you a chance to respond, the DOJ itself has said, mandated implicit racial bias training, and I hope that's something that you will agree to do. But this is the thing I'll conclude on, is that we live on a planet Earth where you can tell the most about a nation by who they incarcerate. In Turkey, they incarcerate journalists. Thank God we don't do that here, even though they've been called the enemy of the people. In Russia, they incarcerate political opponents. I'm glad we don't do that, even though with chance of lock her up. But you go into the American criminal prisons, sir, and you see the most vulnerable people. You see over-stigmatized mentally ill people clogging our system. You see over-stigmatized addicted people clogging our system. You see a system where, as Brian Stevenson says, it treats you better if you're rich and guilty than if you're poor and innocent. And you see disproportionately, overwhelmingly for drug crimes, African Americans and Latinos being incarcerated. The importance of your job, and I'll ask you this last question, because you haven't met with me yet, you've given that courtesy to others. Would you please meet with me in my office so you and I can have a heart-to-heart on the urgency, the cancer on the soul of our country's criminal justice system is the disproportionate impact of that system on those vulnerable communities, including women, over 80% of whom the women we incarcerate are survivors of sexual trauma. Can you and I sit down and have a longer conversation than these 10 minutes will allow on this issue?
I'd very much welcome that, Senator. You know, my experience back in 1992, when sort of blood was running on the streets all over the United States, my ideas were actually first formed when I went to Trenton. And the African-American community there essentially surrounded me and was saying, look, we're in our golden years. We're trying to enjoy our golden years, and we can't even go outside our house. We have bars on our house and so forth. Please, these gangs are running roughshod. So I developed this idea called Weed and Seed. And my attitude was, look, let's stop arguing past each other on let's attack root causes and let's get tough on crime. And I felt that for programs to work, like after-school programs and so forth, for all this, you know, for housing projects to be safe, we needed strong enforcement in those communities, and we needed those other programs to be brought to bear community by community. And it had to be done with the leadership of the community, and that was this idea of the partnership. And it caught on. It was very popular, and in fact, it was continued by a lot of the U.S. attorneys in the Clinton administration after the Bush administration was out. And it is actually, under a number of different names, has continued. So I'm very conscious of the issues you raise, but my goal is to provide and my motivation was to provide safety in these neighborhoods for the people trying to raise their children and for the older people and so forth. And I think the neighborhoods are, you know, the crime rate has gone down. I make a distinction between the way we treat these chronic violent offenders and the drug penalties. The drug penalties, as I said, very high and draconian, and in some cases that might have been necessary, but I supported revisiting the penalty structure.
And sir, I'm the only United States senator that lives in an inner city, low-income community. I've had shootings in my neighborhood. A young man killed last year on my block with an assault weapon. I know this urgent need for safety and security, and I'm not saying I'm necessarily going to vote for you one way or the other, but I believe your intentions are well, but I think that some of the things you've said in the past lead me to believe that your policies might be misguided in the way that Mike Lee and Cornyn and Graham and Grassley have been incredible partners in changing the American reality. I hope that you can be that kind of partner too, and I hope that you and I can have a good heart-to-heart conversation, trusting that we both want the same end for all communities, safety and security, but a justice system that is fair to all American citizens.
I'd welcome that, sir.
Thank you, sir.
Senator Blackburn.
Thank you, Mr. Chairman, and we appreciate your time today, Mr. Barr, and that of your family. I told Liam that Grandpa ought to give him whatever he wants to eat for dinner tonight. He has behaved very well and done a great job. Going back to something that Senator Kennedy mentioned on leaks, and you said you would address that by compartmentalization. Talk for just a little bit about your vision for the Department of Justice as you look at implementing first steps, addressing violent crime, dealing with the opioids, dealing with the online sex trafficking, the antitrust issues, the Mueller investigation, all the things we've talked about. How do you intend to lead that department that is very different from the DOJ that you led previously?
In some ways it's different, in some ways it's not so different, but my basic approach to things is to get good lieutenants, good subordinates who running different parts of the agenda, and give them their marching orders and watch them perform and get involved to the extent I can to make sure that we're pushing the priorities things ahead. One of the interesting things about the Department of Justice, it's a little different than many agencies, is one of our first priority has to be to enforce all the law. It's not like we can just come into work and say, well, we're going to just pay attention to this, so we're not going to enforce all these other laws. We have to cover the waterfront. That's number one. But beyond that, what I tried to do last time and what I would try to do if you confirm me this time would be, to make sure that even though we're enforcing things across the board, we have an understood set of priorities and we put the effort behind those priorities. And we define clearly what we're trying to achieve. So, for example, in the area of civil rights, when I was Attorney General last time, and I had discussed this with Senator Kennedy, I said, we're not doing enough on housing discrimination. Housing is very important. It determines where you go to school and all other, the safety and so forth. And I set up a program. We hired testers and stuff like that. And we had a very clear goal and priority for that. And we launched it. And that's what I plan to bring in area after area, defining what we're trying to accomplish and give the people the tools to get it done and give them the direction and motivation to get it done.
You've mentioned the Mueller investigation, your relationship with Mr. Mueller, having him finish the investigation. If we were to ask him about you, do you think his assessment would be that you are a fair and impartial leader that he can trust, that we can trust to lead the DOJ?
I hope he would say that, but I'm not going to put words in his mouth.
Yeah. We talked about technology and my interest in that area, and you've had Mr. Lee and Mr. Hawley have also talked about antitrust and some of the enforcement there. Big tech and Silicon Valley and the power that is harbored there, they are gobbling up a lot of their competitors. You've got Facebook and Google that are claiming to only be platforms for their users, but they are also getting into the content business. And that is why Facebook bought Instagram and WhatsApp, and Google bought YouTube and DeepMind for AI technology. So their tentacles are spreading, and they are moving away from a platform into that content, into artificial intelligence. And their market dominance is causing some problems. And as we discussed, these companies are violating users' privacy. They are recklessly sharing their users' personal data with third parties. This is done without explicit permission. We can't let these companies collude to drive out competitors or to ignore vital data privacy protections. And big tech operated really without regard to the law. And you and I talked a little bit about one of the edge provider CEOs who last spring, when he came before a House committee, he was also here before this committee, there was even reference to how I discussed how he subjectively manipulated, or asked if he subjectively manipulated algorithms, and how there was concern that some of these platforms referencing a statement he had made function more like a government than a platform or an information service. So how do you intend to begin this conversation and begin this work addressing the antitrust provisions with big tech?
Yes, you know, as I mentioned, I'm interested in these issues and would like to have them fully ventilated at the department with the antitrust division and also with, you know, outside experts so I can have a better understanding. I do want to say, however, that I'm going to be recusing myself from AT&T because
Time Warner, yeah.
Yeah, because now Time Warner is part of AT&T,
Right.
and I was told that under the rules that will carry over to AT&T. So until I talk to the ethics advisors of the department, I don't want to get too far ahead of my skis and sort of talking about the tech area. But as a general policy matter, I want to get into this area because I think it's on a lot of people's minds and how the law relates to these, you know, to these developments that we see with these large companies. And I don't mean to cast aspersions on any particular company or executive.
Well, and I think for many of us, if you're looking at a merger and they cannot prove the efficiencies and they cannot prove that there will be increased competition, then it does raise some questions as to how those would be evaluated. And let me go to one other issue that is developing on this privacy front. It is a data privacy problem that I don't think a lot of people realize, and it is the embedding of hardware and then the geolocation. And sometimes that information is sold. Now, it folds into the encryption issue because law enforcement has a very difficult time getting the information from devices and from the services on encryption. But we are now aware that many times bounty hunters will be paid a few $100s, and then they can go in and find the location of that phone. And some of these Android operating systems are specific enough that they do the barometric pressure readings, and they can tell you exactly where in a building that this phone is located. So I would hope that you are going to look at the legal procedures that surround this kind of data and this kind of tracking and the privacy provisions that are going to pertain to consumers as they use these devices.
Yes.
Good, thank you. Let me move on. Senator Ernst talked a little bit about the online sex trafficking. In Tennessee, we have followed this issue so closely because our TBI carried out an operation where they apprehended 22 traffickers. 22 men were arrested for sex trafficking. And much of that work and the work I've done in the House on the online sex trafficking, working to shut down Backpage.com and to keep our children and keep women safe from these online traffickers. And, you know, we were so pleased that last April, the Justice Department seized Backpage and charged 7 defendants for facilitating prostitution and sex trafficking crimes. And what we know is that when you shut down a site like Backpage, the big one, then you have a lot of small sites that proliferate. And we know that it is going to really take a lot of effort to arrest this situation so that you're not constantly playing whack-a-mole with these. So I would hope that you will be committed to putting an end to this kind of violence and online trafficking.
Yes, and I know how focused you are on it and the leadership you've provided over the years on it. I don't know that much about the problem and also about what resources are currently being devoted to it in the department, but I would like to come by and
Great.
talk to you further about it once I get exposed to it, if I'm confirmed.
Thank
Okay.
you. My time has expired, Mr. Chairman. I yield back. Thank you, Mr. Barr.
Thank you, Mr. Chairman, and congratulations. And to you, congratulations on your nomination, and thank you for your lifetime of dedication to public service.
Thank you.
In response to a question that Senator Ernst asked, you mentioned that we need barriers across the border to deal with drug trafficking. Are you advocating a wall?
Well, I think I'm advocating a system, a barrier system. In some places, and I'd have to find out more about the situation since I last visited the border.
From what you know, or do you believe that a wall would address the concern that you have about drug trafficking?
Well, the wall certainly would, but in some places it may not be necessary to have, what most people imagine as a wall.
Are you aware that most of the drugs coming into the United States, in particular through Mexico, are entering through ports of entry?
Yes, but they also come elsewhere, and so do illegal immigrants cross the border. And
But in
basically,
particular on the subject of drug trafficking, are you aware that most of the drugs that are trafficked into the United States enter through points of entry?
yes.
Have you recently or ever visited a point of entry, a port of entry?
Not
to the United States?
Not recently.
When
I
was the
used to
last
spend
time?
a lot of time, well, when I was Attorney General,
So a couple decades ago.
almost 30 years.
Okay, I'd urge you to visit again if and when you are confirmed. I think you'll see that a lot has changed over the years. Given status quo on marijuana and the fact that 10 states, including the District of Columbia, have legalized marijuana, and given that the status quo is what it is, and as you rightly described, we have federal laws and then there are various states that have different laws. If confirmed, are you intending to use the limited federal resources at your disposal to enforce federal marijuana laws in the states that have legalized marijuana?
No, I thought I answered that by saying that to the extent people are complying with the state laws, in distribution and production and so forth, we're not going to go after that.
Okay.
But I do feel we can't stay in the current situation because, if you can imagine any kind of situation, can an existing administration and an attorney general start cutting deals with states to say, well, we're not going to apply the federal law, some gun law or some other thing, and say, we're not going to apply it in your state.
I appreciate your point, but specifically, and I appreciate you answering the question, you do not intend to use the limited federal resources at your disposal to enforce federal marijuana laws in those states or in the District of Columbia that have legalized marijuana.
That's right, but I
Thank
think
you.
the Congress of the United States, it's incumbent on the Congress to regularize, make a decision as to whether we're going to have a federal system or whether it's going to be, a central federal law, because
I
this
agree
is
with you. I think
breeding
Congress should act.
disrespect for the federal law.
I agree with you. I believe Congress should act. I agree. Earlier today, Senator Leahy asked whether you would follow the recommendation of career Department of Justice ethics officials on whether you should recuse yourself from the Mueller investigation. You said, quote, "I will seek the advice of the career ethics personnel, but under the regulations, I make the decisions as the head of the agency as to my own recusal." You also said to Senator Klobuchar that you do not want to, quote, "abdicate your duty," since recusal decision would be yours. So my question is, would it be appropriate to go against the advice of career ethics officials that have recommended recusal? And can you give an example of under what situation or scenario you would go against their recommendation that you recuse yourself?
Well, there are different kinds of recusals. Some are mandated, for example, if you have a financial interest, but there are others that are judgment calls. And
Let's imagine it's a judgment call, and the judgment by the career ethics officials in the agency or that you recuse yourself.
Then
Under what scenario would you not follow their recommendation?
If I disagreed with it,
And what would the basis of that disagreement be?
I came to a different judgment.
On what basis?
The facts,
Such as?
such as whatever facts are relevant to the recusal.
What do you imagine the facts would be that are relevant to the recusal?
They could be innumerable. I mean, there are a lot of, for example, there's a rule of necessity, like who else would be handling it? It could be,
Do you believe that would be a concern in this situation if you are, if the recommendation is that you recuse yourself from the Mueller investigation? Do you believe that would be a concern, that there'd be no one left to do
no,
the
I'm
job?
just saying, well, in some contexts, there very well might be because of, who's confirmed for what and who's in what position. But apart from that, it's a judgment call, and the Attorney General is the person who makes the judgment, and that's what the job entails.
As a general matter, that's true, but specifically on this issue, under what scenario would you imagine that you would not follow the recommendation of the career ethics officials in the Department of Justice to recuse yourself from the Mueller investigation?
If I disagreed with them.
Okay, we'll move on. Senator Feinstein previously asked you whether you'd put your June 2018 memo, whether you put together that memo based on non-public information. Your response was that you, quote, did not rely on confidential information. Are you creating a distinction between non-public information and confidential information? No. Okay. In response to a question from Senator Durbin about harsh sentencing laws, you stated in response to the crack epidemic that community leaders, back when you were Attorney General previously, asked for these types of sentencing laws. Now, my understanding is that many of these community leaders at that time, and I was a young prosecutor during those days, knew and said even then that the crack epidemic was a public health crisis, and that was really the chorus coming from community leaders, not that they wanted drug-addicted people to be locked up. And similarly, now we can find that in most of the communities afflicted by the opioid crisis, they are similarly, these community leaders, asking that it be addressed for the public health crisis that it is. So my question is, if and when you are confirmed in this position, would you agree that when we talk about the opioid crisis, the crisis in terms of methamphetamine addiction or any other controlled substance, that we should also acknowledge the public health ramifications and causes, and that there is a role for the Chief Law Enforcement Officer of the United States to play in advocating for a public health response and not only a lock-em-up response?
Well, I think the commission that was chaired by Governor Chris Christie came up with a three-pronged strategy. And I think that recognized that part of it was treatment and education, recovery, and prevention. But the third prong of it was enforcement and interdiction, and that's the job of the Department of Justice. The Department of Justice can't be all things to all people. And
Sir, but I would suggest to you that in the intervening almost 30 years since you were last Attorney General, that there is consensus in the United States that when we look at the drug epidemic, whatever the narcotic may be, that there's now an understanding that the war on drugs was an abject failure, that America frankly has a crisis of addiction, and that putting the limited resources of our federal government into locking up people who suffer from a public health crisis is probably not the smartest use of taxpayer dollars. So if confirmed, I'd ask that you take a look at the more recent perspective on the drug crisis that is afflicting our country. And then I'll move on. Today, there is $1 billion.
Can I just say something in response to that?
Sure.
Which is, I was just making the observation that the job of the Department of Justice is enforcement. I recognize there are a lot of dimensions to the problem, and that's why we have places like HHS. The department can't be, can't do the job of everybody.
Sir, but I would remind you what you said, because I agree with it. You said earlier the role of the Attorney General, one, is to enforce the rule of law, two, is a legal advisor to the President and the Cabinet, and three, is policy. This is a policy issue, so I'd urge you to emphasize that role and power that you will have if confirmed,
I see.
and think of it that way.
I see.
I'd like to talk with you about private prisons. There's a $1 billion private prison industry that profits off of incarcerating people, and frankly, as many as possible. By one estimate, The two largest private prison companies in the United States make a total combined profit of $3.3 billion, that's what it be, dollars a year. In August of 2016, the Justice Department issued a report on the Bureau of Prisons' use of private prisons that concluded, quote, contract prisons incurred more safety and security incidents per capita than comparable Bureau of Prisons institutions. Given this conclusion that prisons run by for-profit companies have been found to be less safe than government-run prisons, if confirmed, will you commit to no longer renew private prison contracts?
Whose report was this, BOP?
This was, yes, from the
BOP?
Justice Department.
Yeah, I'd like to, I would obviously look at that report, yes.
Okay, and then...
But I'm not committing, I'd want to see what the report says.
Sure.
Yeah.
And then I'd appreciate a follow-up when you have a chance to read
Sure.
it. Thank you. My time's up.
Thank you, Mr. Chair. Mr. Barr, thank you for being here, and Liam, your granddaddy's doing good. Mr. Barr, I want to go back because it's a long time. I think I'm the last person in the first round, so I think we have to go back and maybe have you restate some things that you said earlier before I get to a few other things that I hope I have time to cover on intellectual property, Americans with Disability Act, and a GAO report back from 2014. I do have to ask a question while Senator Kennedy's here because I don't think he covered the full landscape. He asked about anybody in government, anyone in the Western Hemisphere, but did you in fact talk to anybody in the Eastern Hemisphere with respect to the Mueller probe?
No, I didn't.
Okay, thank you. We got that.
Ask him about the Milky Way.
We got that closed out. Would you go back again and please describe for me first off, I think you've made it very clear, in spite of the fact some people thought that you had coaching and some of the citations in the memo that you read, that this was a memo you wrote on your own. Can you explain to me again the motivation behind the memo, what precisely you were trying to communicate, just for the record?
Yes, Senator. So the public commentary and media commentary was sort of dominated by discussion of obstruction of justice, and everyone was throwing out obstruction theories and so forth. And the statute that relates to obstructing a proceeding that's not yet in being, that is some future proceeding, is 1512. And my view was of the particular provision, 1512C, was that it requires, what it covers is obstruction by means of impairing evidence, that you know some evidence is going to be needed in a future proceeding, and you impair it either by making it not available or by corrupting it in some way, altering it, destroying it. That's what I thought the scope of that statute dealt with. And to my knowledge, the only cases ever brought under it involved the destruction of evidence. Based on public reports, which may be completely wrong, I thought that it was being that the special counsel may be trying to interpret the statute to say that any act, not destruction of evidence or anything, but any act that influences a proceeding is a crime if it's done with a bad intent. My concern there is that unlike something like bribery statute or document destruction where you prohibit it, that's a bad act. You don't need to be performing that bad act if you're a government official. But if you say that any act that influences a proceeding is a crime if you have a bad state of mind, that's what the people at Justice Department do every day of the week, is influence proceedings. That's what they're there for. And what I was worried about is the impact on the department and other agencies if you say to someone, if you, in supervising a case or handling a case, make a decision for a bad intent, it can be a crime. And I thought that that would essentially paralyze the government. So just to give an example, Eric Holder made some pardon recommendations during the Clinton administration, which were controversial. Incidentally, I supported Eric Holder for his position. But could someone come along then later and say, well, if you did that for a political reason to help Hillary Clinton run in New York, that's a crime? And when he's exercising his prerogatives, you know, in that situation, and you can just see how that could paralyze government. And that was my concern.
You also referred to your concerns with the prosecution of Senator Menendez. Did that weave into that same thought process?
Yes, because in that case, my concern was that they were basically taking activities that were not, you know, wrongful acts in themselves. You know, the political contributions were lawful political contributions, and the things with you know, the travel on his friend, that was his friend for 25 years. They were taking a trip together, and you take those kinds of things and then you couple it with official action, and then the prosecutor comes along and says, well, we're going to look into your mind and see what your subjective intent was for performing these two sets of lawful acts, and we're going to say, you know, that you're corrupt. Good. So I just think that gives too much power to the prosecutor, and I think if that kind of, and by the way, you know, they've had cases like this for, you know, I mean, they've been pursuing things like this, and they've had to be slapped down a few times by the Supreme Court on these kinds of aggressive things involving, you know, quid pro quos on the Hill. So
let me, if I can, thank you. I just thought it was helpful because I think you tried to explain a lot of that and you were cut off, so I thought I'd use some of my time in the first round to ask you that. Also, I think somebody tried to characterize you as having somehow been opposed to any sort of Russia probe or Russia investigations. Have you ever gone on record as opposing any of the things that we're trying to do to figure out where Russia may have been involved in election tampering?
No, and in fact, in the op-ed piece where I said I thought the president was right in firing Comey, I said that the investigation was going forward under the supervision of Rod Rosenstein.
Yeah. Did you also say more than one time that you felt like the special counsel investigation should reach a conclusion that that Special Counsel Mueller shouldn't be, that he should be allowed to draw this to a conclusion, then he will submit his report, and you're going to do everything that you can to present as much of that information as you can, as you can, to the extent that confidential information is not being compromised?
To the extent the regulations permit it, yeah.
Did you also say that there's even a scenario where you can't imagine a scenario for cause, but even a scenario for cause where you'd have to take under serious consideration before you remove special counsel?
That's right.
Yeah, okay.
There hasn't been a special counsel removed since Archibald Cox, and that didn't work out.
Didn't work out too well, right. And so, and again, did you also say that under, in no circumstances have you had a discussion with the president with respect to, I think you said you had a discussion about you had a relationship with Mr. Mueller, but no discussion about the special counsel investigation and your opinions on it with respect to any discussions you've had with the president?
Right. That was the first meeting I had with the president, and then in November, I met with him about the Attorney General job, and there was no discussion of the substance of the investigation. The president didn't ask me my views about any aspect of the investigation, and he didn't ask me about what I would do about anything in the investigation.
With respect to the line of questioning about the states that have legalized marijuana, either for medicinal purposes or recreational purposes, I think what you were trying to say in a very, very respectful way is it's not your job to do our job. Is that right? That if we ultimately want to provide certainty for these businesses. You've done a good job in saying that you disagree with the policy of the states, but we are where we are, and you would not want to undermine that given that investments have been made, states have moved forward. But at the end of the day, we should stop talking about it here and making it your job. And those members, I don't happen to be one of them, who think that we should take these federal laws off the books should probably file a bill and try and get it done. Is that a fair assessment of your opinion?
That's generally fair, yes.
Okay. Just a few minor things so that we can get to the next round. There was a report by the Inspector General in 2014 that had to do with accountability in the Department of Justice. I don't expect you to be familiar with this report, but there were some very interesting observations there about a lack of follow-through on disciplinary action for a number of, I think the subtitle of the report was "The DOJ Could Strengthen Procedures for Disciplining Attorneys." It's something I would commend to you and maybe dust off and see if there have been any actions since this report. I didn't get a satisfactory answer when it was contemporary with a nominee from the Obama administration for the position you're seeking, which is one of the reasons why I opposed the nomination.
Actually, I think very highly of Inspector General Horowitz, and I haven't seen that report, but that issue is one that I plan to take up with him.
And then just so that I do finish on time versus pretend I'm going to and go 2 minutes early over. One, I want to get your recommendation on intellectual property. I think we have more work to do to give the Department of Justice tools to go after bad actors, which are China, Russia, India, a number of other countries, Brazil, that are stealing our intellectual property. Also want to talk about what I think is the exploitation of the Americans with Disabilities Act, particularly around website access. The web didn't exist, and now we have attorneys filing a number of frivolous lawsuits. Would like to get some feedback on that after you get confirmed. And finally, I want to make sure that you recognize in the First Step Act that faith-based organizations that have proven to help reduce recidivism are absolutely in play for the First Step Act, and hopefully we can make sure the Department of Justice move forward with that. Thank you, Mr. Chair.
Thank you.
Thank you, Senator.
I believe that's the end of the first round. Mr. Barr, you're able to go for a little bit longer?
Sure.
Okay. So we'll do 5 minutes. As you can tell, I've been pretty liberal with the time, but let's try to honor it the best we can. Senator Grassley.
Okay. Where he left off on working with faith-based institutions, you were very positive about that?
Yeah, absolutely, Senator.
That takes care of my first question. Enforcement of the antitrust laws is extremely important to ensure that markets are fair and participants don't engage in abusive activity harming consumers. I've been particularly active in making sure that the Justice Department and Federal Trade Commission carefully scrutinize mergers, as well as looking out for anti-competitive behaviors and predatory practices in certain sectors of the economy, and particularly in my state of Iowa, the agricultural industry, but I'm also pursuing things in healthcare. In particular is because I will be chairman of the Senate Finance Committee, I'm interested in making sure that companies in drug and healthcare industries are playing by the rules. Everyone's concerned about the high cost of healthcare and especially the skyrocketing price of prescription drugs. Do you agree that the Justice Department has a very important role in this area?
Yes, Senator.
And would you commit to making antitrust enforcement a priority?
Yes, it has to be a priority.
Okay, thank you. Now to a favorite issue of mine, whistleblower protection. Whistleblowers, as I told you in my office, are very critical to exposing waste, fraud, and abuse. There are eyes and ears on the ground. Their courage, when they have it, and most of them do have great courage, or they wouldn't come forward to expose government malfeasance. That's how important they are. So I hope I can have you have a favorable view towards the opportunity to listen to whistleblowers, protect them from retaliation, and promote a culture that values important contribution from those patriotic people.
Absolutely, Senator.
Okay. Now to the Foreign Agents Registration Act. I hope you understand there have been very few prosecutions under the Foreign Agents Registration Act since 1938. And so that lax enforcement, I think, is getting, obviously, even since the Mueller investigation, getting a lot more attention now. But we had a hearing on it before the committee, and I think it proves that we should see more transparency and more enforcement against bad actors, not less. Do you agree that the Foreign Agents Registration Act is a critical national security and public accountability tool? And if confirmed, will you commit to make sure that that act is a top priority?
Yes, Senator.
Okay. So then getting back to legislation that I think will improve that 1938 Act, I introduced the Disclosing Foreign Influence Act to improve transparency, accountability, and enforcement. You haven't probably read that act, but I'd like to work with you, even though it's not in this committee, it's in Foreign Relations Committee. I'd like to have you work with us so it's something that we can pass and make sure that this law is more useful than it has been over the last 80 years. I support the Freedom of Information Act and the public disclosure of government records. Transparency yields accountability. You hear me say that all the time, and that's true no matter who's in the White House. When I was chairman of the committee, I helped steer FOIA Improvement Act into law, which creates a presumption of openness, and that presumption of openness is a very important standard. The Justice Department oversees the federal government's compliance with FOIA. So I hope you would agree that FOIA is an important tool for holding government accountable. And if confirmed, then would you make sure it's a top priority to make FOIA and the faithful and timely implementation of the 2016 amendments a top priority?
Yes, we'll work hard on that.
Because you know what really happens in the bowels of the bureaucracy? It just takes them forever because maybe something's going to embarrass them, so they don't want it out in the public. So you get all sorts of excuses. We got to do away with those excuses. One way to make FOIA work better is by reducing the number of requests. This will have to be my last question. One way to make FOIA work better is by reducing the number of requests that have to be made in the first place. That's why I'm a strong advocate for improved proactive disclosure. If confirmed, will you commit to help advocate for more proactive disclosure of government records? Now, that's not just by the Justice Department, but because your government or your department's top dog in this particular area in the federal government overall.
Yes, Senator.
Thank you.
Senator Feinstein.
Mr. Barr, I see you have staying power, but I see it runs in the family, and particularly your grandson. I'd like to send a little care package down to him. He deserves a medal.
We'll get that to him. There you go.
Thank you, Senator.
You're welcome.
He doesn't have to share it with the rest of the family.
In 1994, you said that gun control is a dead end. It won't reduce the level of violent crime in our society. The year you made this comment, I introduced a federal assault weapons ban, and the president signed it into law. A 2016 study shows that compared with the 10-year period before the ban was enacted, the number of gun massacres between 94 and 04 fell by 37%, and the number of people dying from gun massacres fell by 43%. In addition, between 2004 and 2014, there has been a 183% increase in massacres and a 239% increase in massacre deaths. Do you still believe that prudent controls on weapons won't reduce violent crime? And if so, what is your basis for this conclusion?
I think that the problem of our time is to get an effective system in place that can keep dangerous firearms out of the hands of mentally ill people. That should be priority number one, and it's going to take some hard work, and we need to get on top of the problem. We need to come up with agreed-to standards that are prohibitors of people who are mentally ill. We have to put the resources in to get the system built up the way we did many years ago on the felon records and so forth. We have to get the system working, and as I say, it's sort of piecemeal a little bit right now. We need to really get some energy behind it and get it done, and I also think we need to push along the ERPOs so that we have these red flag laws to supplement the use of the background check to find out if someone has some mental disturbance. This is the single most important thing I think we can do in the gun control area to stop these massacres from happening in the first place.
Well, thank you. I'd like to work with you in that regard. In August of 2002, the Justice Department's Office of Legal Counsel issued opinions authorizing enhanced interrogation methods that included waterboarding and extended sleep deprivation. These opinions were later withdrawn, and the Justice Department's Office of Professional Responsibility found that they reflected a lack of, this is a quote, a lack of thoroughness, objectivity, and candor, end quote. In 2015, I worked with Senator McCain to pass legislation making clear that enhanced interrogation techniques are unlawful and limiting authorized interrogation techniques to those listed in the Army Field Manual. And that is the law today. If confirmed, will you ensure that the Justice Department upholds the law?
Yes, Senator. I think that was an important change because I think it gave clarity to the law, and I will support that.
Thank you. I'm delighted to hear that. And now, a lot of us have asked about the Mueller report and whether you would commit to providing it to Congress. When asked, I thought you said yes, but when I tried to clarify it, I meant the full report, including obstruction of justice. You again said yes. Then when Senator Blumenthal asked you about the Mueller report, you seemed to make a distinction and said you were going to provide your own report based on Mueller's report, but not the report, this is the way we understood it, but not the report he submits at the end of the investigation. This is concerning, as there is nothing in the regulations that prevent you from providing Mueller's report to Congress. While the regs refer to a confidential report to be provided to the Attorney General, the regs do not state that confidentiality means the report cannot be provided to Congress. So here's the question. Will you provide Mueller's, Mueller's report to Congress, not your rewrite or a summary?
Well, the regs do say that Mueller is supposed to do a summary report of his prosecutive and his declination decisions, and that they will be handled as a confidential document as are internal documents relating to any federal criminal investigation. Now, I'm not sure, and then the AG has some flexibility and discretion in terms of the AG's report. What I am saying is my objective and goal is to get as much as I can of the information to Congress and the public. And, you know, these are departmental regulations, and I'm going to be talking to Rod Rosenstein and Bob Mueller. I'm sure they've had discussions about this. There's probably existing thinking in the department as to how to handle this. But all I can say at this stage, because I have no clue as to what's being planned, is that I am going to try to get the information out there consistent with these regulations, and to the extent I have discretion, I will exercise that discretion to do that.
Well, I can only speak for this side, and maybe not all this side, but we really appreciate that. And the degree to which you can get us a prompt report in the fullest possible form would be really appreciated. And I think there has to be a realization, too, among the administration that this is an issue of real concern to people and to the Congress, and we should be able to see the informed information that comes out. So
I understand.
I'm very hopeful.
Thank you.
Let me ask this question on enhanced, did my time run out?
But go ahead.
On enhanced interrogation. During a 2005 panel discussion, you said the following, I think, about interrogating suspected terrorists, and I quote, "Under the laws of war, absent a treaty, There's nothing wrong with coercive interrogation, applying pain, discomfort, and other things to make people talk, so long as it doesn't cross the line and involve the gratuitous barbarity involved in torture, end quote. This is a panel discussion, Civil Liberties and Security, July 18th, 2005. Do you believe that torture is ever lawful?
No.
Is waterboarding torture?
You know, I'd have to look at the legal definition. You're talking about under the, right now, it's prohibited. So, you know, the law has definitively dealt with that. I can't even remember what the old law was that defined torture. I'd have to look at that and then, you know, figure out what's involved in it. But sorry.
Keep going. I didn't mean to interrupt you.
No, it's okay, sir. Sorry.
At what point does interrogation cross the line to the gratuitous barbarity involved in torture? That's your quote.
Well, I wasn't using that as a legal, the gratuitous barbarity. That's what I was I was saying torture is gratuitous barbarity. So I wasn't saying that gratuitous.
Well, that's helpful
Yeah.
then. That's helpful.
Yeah.
And you define waterboarding. You know, one would think these questions would never be necessary. I've thought that all my life, and then I found I was wrong, and they really are. And I was chairman of intelligence when we did the big torture report, and what I found and what I saw was really indicative of reform. So I think for the Attorney General, knowing the position is really very important.
Right.
So maybe you could concisely state your position on torture.
I don't think we should ever use torture, and I think that the clarification that was it your legislation of the putting in the Army
McCain's
the field manual.
That's right.
Was important to clarifying where the line is.
Thank you. Thank you, Mr. Chairman.
Senator Cornick. Mr. Barr, I want to talk about guns, and I want to talk about China in the 5 minutes we have together. Back in 1992, there was some discussion about your position on Congress's role when it comes to banning certain types of semi-automatic weapons. Sometimes people call those assault weapons. But in the intervening years, the Supreme Court has now spoken in both the Heller and McDonald case and recognized that the Second Amendment confers an individual and fundamental right to bear arms. Could you sort of bring us up to date from your views in 1992 and how they were affected by Heller and McDonald and what your views now are on the Second Amendment?
Sure. I think I opposed an assault weapon ban because I felt that that was really sort of the aesthetics of the gun. And but, you know, since that time, Heller has been decided. Actually, before Heller, I did work at OLC on this issue, and I personally concluded that the Second Amendment creates a personal right under the Constitution. It's based on the Lockean notion of the right of self-preservation. It's tied to that. And I was glad to see Heller come out and vindicate that initial view that I had. And so there's no question under Heller that the right to have weapons is firearms is protected under the Second Amendment and is a personal right. At the same time, there's room for reasonable regulation. And, you know, from my standpoint, what I would look for is in assessing a regulation is what's the burden on law-abiding people, and is it proportionate to whatever benefit in terms of safety and effectiveness will be conferred. As I said just a moment ago, let's get down to the real problem we're confronting, which is keeping these weapons out of the hands of people who are mentally ill. And I think all the rest of this stuff is really essentially rhetoric until we really get that problem dealt with in terms of regulatory approaches.
Well, as our colleague, the senator from Louisiana, Senator Kennedy likes to say, the Bill of Rights is not an à la carte menu. And I agree with that. I also agree that there are many facets to these mass violence incidents. After the shooting at Sutherland Springs, we found out that the background check system, the National Instant Criminal Background Check system, was not being used appropriately by the U.S. government, in that case, the Air Force. And if it had been, this individual who killed 20 people, injured 26 more at a Baptist church right outside of San Antonio, would not have been able to legally get his hands on the firearm by lying. But certainly the mental health issue that you mentioned, we've done work there with
Fixed NICS.
in the fixed NICS area. We've also done expanded pilot programs on assisted outpatient treatment for people suffering from mental illness, recognizing that it's difficult for any family member to control, particularly an adult, but that providing an opportunity to go to court and get basically a civil order that would require them to comply with their doctor's orders, take their medication and the like. I'm thinking of Adam Lanza at the Sandy Hook shooting, whose mother did not know how to control him as he was getting more and more ill, and only to have him take her very weapon and then kill her and then go murder the innocent children. So on China, do you agree with me that China represents probably one of the preeminent economic challenges to America, particularly because of their theft of intellectual property and their exploitation of gaps in foreign investment that we've tried to address through improvement of the CFIUS process, the Committee on Foreign Investment in the United States? But talk to me a little bit about what you see the challenge of China, both economically and from a national security standpoint.
Well, I think they're the paramount economic and military rival in the world. I think that they are very formidable because they take the long view. They've been stealing our technology, and they've been gradually building up their military power and investing in new technologies. I think from a military standpoint, it's very disturbing how much progress they're making, largely based on U.S. technology. I was very, I really thought that Attorney General Sessions was right on target in setting up his China initiative in the department to start going after the pirating of American technology and other kinds of illegal activities that Chinese nationals are involved in here in the United States and even abroad.
Do you share my skepticism at Chinese telecommunications companies like Huawei and ZTE in terms of how that, once in the hands or in the networks of unsuspecting countries, that could be used for espionage purposes and theft of intellectual property?
Yes, in fact, even in my old Verizon days, we understood the danger and would not use that kind of equipment, even though it would be economically attractive.
Before Senator Leahy, I'd like to, on behalf of Senator Feinstein, introduce into the record letters that express opposition and concern from groups like the Leadership Conference on Civil and Human Rights, Planned Parenthood, People for the American Way, National Education Association, Alliance for Justice, NARAL, National Urban League, the National Council of Jewish Women, Center for American Progress, and the Human Rights Campaign, and a letter from Representative Paul Gravala. I hope I got his name right, from Arizona. In support, we have letters from the International Association of Chiefs of Police, a letter from the National Fraternal Order of Police, numerous letters signed from 100 former federal law enforcement, national security officials, including 3 former attorney generals, and a lot of U.S. attorneys and heads of the CIA, FBI, and Department of Homeland Security, a letter from the National Narcotics Officers Association, a letter from the International Union of Public Police Associations, a letter from Major Cities Chiefs Association, a letter from the Association of State Criminal Investigative Agencies. Without objection, I'd like to enter all that into the record. Senator Leahy.
Thank you, Mr. Chairman. Just when you just mentioned being at Verizon, during the NSA's metadata program. We also had the PRISM upstream. It required telecom, internet providers, hand over huge amounts of data to the government. And you testified in 2003, the law is clear that a person has no Fourth Amendment rights in these records left in the hands of third parties, third-party doctrine. I actually disagreed with you at that time, and I hope you would now, especially as the Carpenter decision that just came down and written by Chief Justice Roberts, that this is generally requiring the government to get a warrant to obtain geolocation information through cell site location information. Does that change the opinion you had back then?
Well, it sounds like I haven't read that decision, Senator. It may modify my views. I'd have to read the decision. I was going on the Miller decision relating to bank records. But also, you mentioned you were tying this to the NSA collection because, and then tying it to my testimony because,
You had said that no person has no Fourth Amendment rights to these records left in the hands of third parties, the third-party doctrine.
Yeah, that was the.
Which seems to be undercut by Carpenter.
Okay, I'll take a look at that. But
then would you?
I don't want people to have the impression that Verizon was involved in
Would you respond
spying.
for the record? on
Yes,
that
sure,
question?
certainly.
And you said back in November 2017, you saw more basis for investigating the Uranium One deal than any supposed collusion between President Trump and Russia. And by not pursuing these matters, the department is abdicating its responsibility. Just about everybody's debunked the Uranium One controversy. I think probably the nail in the coffin was President Trump's biggest supporter, Fox News, debunked it. Did I miss something in there?
No, actually, you'll notice that there were no quotes around that, and then the next sentence is plural matters. And my recollection of that is I think it was relating to the letter and the appointment of Huber in Utah to look into a number of things. And the point I was trying to make there was that whatever the standard is for launching an investigation, it should be dealt with even-handedly. Whatever that trigger is should be applied to all. I have no knowledge of the Uranium One. I didn't particularly think that was necessarily something that should be pursued aggressively. I was trying to make the point that there was a lot out there, and I think all that stuff at the time was being looked at by Huber. That's my recollection. I may be wrong on that.
Well, I think the fact that the investigation has been pretty well debunked, we don't have to worry about it in the future. But we do have one thing that's happening right now. The Trump shutdown is in its 25th day. Justice Department has 13,000 FBI agents, 16,000 prison guards, 3,600 U.S. Marshals, 4,300 drug enforcement agents. They're all working without pay. The FBI Agents Association, I realize it's not part of the government, but the association described the effect of the shutdown as a potential national security issue. So let me just ask you, in your years of experience at the department, what impact do you believe a long-term shutdown has on law enforcement?
Well, I think most people involved in law enforcement are, I don't know if the lingo is still the same. They used to be called essential. I think it's been changed to something else, but I think they're on the job. But obviously, people would like to see the shutdown ended, and that's why people want to see some kind of compromise. And You know, you call it the Trump shutdown, but I mean, it takes two to tango, and you sort of wonder why
Only
can't.
because he called it that,
Oh.
his meeting at the
Okay.
White House, and I said, finally, I've got something I could agree with him on. And because
Well.
Senator Shelby and I had put together appropriations bills that passed almost unanimously in the Senate at a time when that would have kept the government open. That's at a time when it's hard to get something unanimous saying the sun would rise in the east. And I was just agreeing with the president, but no matter what you call it, isn't it a fact that this does have an effect on law enforcement?
Well, not having a wall also has an effect on law enforcement.
And not paying our law enforcement people. We both had experience in law enforcement, you at the national level, me at the state level. You don't pay our law enforcement people, I think there's an effect. You have some very dedicated people, but you have some very distracted people. Do you believe that voter ID laws and similar restrictions on voting actually promote democracy by discouraging voters who are not really paying attention to what's going on? Going back to a panel discussion you had a few years ago.
Yeah. What I said there was that in that panel discussion, there was a lot of people complaining about the lack of, that many Americans aren't educating themselves about the issues and they're passive, and that it was important to, and also that the voting participation was dropping. And I said my position was that the underlying problem is the citizen, you know, the citizen who's not paying attention to public events, not educating themselves about the issues and so forth, and that the non-voting is a symptom. And I didn't see driving up participation as addressing the primary underlying problem. That was my point, and I pointed out that when the Constitution was adopted, the turnout was about 33%, my understanding. So, and then I said, you know, low participation has been a problem from the very beginning. But my view is that voter turnout shouldn't be artificially driven up without also addressing the issue of an informed citizenry, which I think is a problem.
We do have voting laws that guard against discrimination, the arbitrary closing of voting booths in a predominantly African-American area, for example. Would you have any problem in vigorously enforcing our voting rights laws that are on the books?
Of what? Vigorously? No, not at all. I said one of my priorities would be that. I think we have to enforce the voting rights. And I wasn't suggesting that voting should be suppressed. I was just saying that the low turnout is ultimately attributable to sort of the, I don't know what the word to use is, but, you know, that the citizenry doesn't seem to be that engaged, you know, in the public affairs of the country.
Well, they are in Vermont.
Hmm?
So they are in Vermont.
Yeah,
We have one of the highest turnouts in the country.
That's good. Yeah, excellent.
Thank you.
Thank you, Mr. Chairman.
Thank you. We're going to have two votes at 4:10. Can you go for a bit longer? Senator Sass.
Thank you, Chairman. General, I'd like to return to the disturbing topics of human trafficking and sex trafficking. You've answered a few questions here today. I'd like to look at the November 28th Miami Herald investigative series that I know that you followed into the crimes of Jeffrey Epstein, and I want to quote from that. Epstein, a wealthy hedge fund manager, quote, assembled a large cult-like network of underage girls with the help of young female recruiters to coerce into having sex acts behind the walls of his opulent waterfront mansion as often as 3 times a day, close quote. The report continues, he was also suspected of trafficking minor girls, often from overseas, for sex parties at his other homes in Manhattan, New Mexico, and the Caribbean. The Herald series continues, quote, "In 2007, despite ample physical evidence and multiple witnesses corroborating the girl's stories, federal prosecutors and Epstein's lawyers quietly put together a remarkable deal for Epstein, then age 54. He agreed to plead guilty to 2 felony prostitution charges in state court, and in exchange, he and his accomplices received immunity from federal sex trafficking charges that could have sent him to prison for the rest of his life. He served 13 months in a private wing of the Palm Beach County Stockade. His alleged co-conspirators who helped schedule his sex sessions were never prosecuted, and the deal, called, again, this is the Miami Herald, a federal non-prosecution agreement, was sealed so that no one, not even his victims, could know the full scope of Epstein's crimes and who else was involved," close quote. The fact that federal prosecutors appear to have crafted this secret sweetheart deal for a child rapist obviously enrages moms and dads everywhere. On this particular case, will you commit to making sure that there's a full and thorough investigation into the way DOJ handled the Epstein case?
So, Senator, I have to recuse myself from Kirkland and Ellis matters, I am told, and I think Kirkland and Ellis was maybe involved in that case, so I need to sort out exactly what my role can be. But, I will say that if I'm confirmed, I'll make sure your questions are answered on this case.
Thank you. The Deputy Attorney General, obviously there have been media reports about the timing of his potential departure post your confirmation, and the DAG, as you well know from your prior history, has a key responsibility in deconflicting different parts of the department. Those of us who've been pressing on this matter have found in different parts of the department a lot of anxiety about the way this was handled, and yet kind of a hot potato of a bunch of people thinking they're not responsible. Right now, Rod Rosenstein has been helping, trying to deconflict some of that, but I'm worried if, with your potential recusal, if the DAG also departs, it's not clear who's going to actually deconflict this. So I'm grateful for your pledge that the department will be responsive, even if not you personally.
Yes, that's right.
More broadly than the miscarriage of justice in this particular Florida case, would you agree that justice has nothing to do with the size of your bank account or the number of attorneys you can hire?
Yes.
I agree, and I think that a whole bunch of Americans wonder about the Department of Justice and how we're trying to prioritize, or how we should be prioritizing our responsibility to the victims of sex trafficking who are left afraid and voiceless. In this particular case, many of the women who were clearly victims, trafficked rape victims, had no awareness of the fact, and I think in violation of federal statutes of victim notification, that this non-prosecution agreement had been agreed to, and not just that Epstein and his co-conspirators were not indicted, but the rest of the investigatory matters of the department were also suspended. It seems truly bizarre. I think moms and dads watching this hearing would like to know that you will pledge broadly to attack sex trafficking as a scourge in our society on both the supply side and the demand side, as these dirtbags demand this, but on the supply side as organizations clearly perpetrate these crimes. Can you pledge to us that this will be one of your priorities at the department?
They can count on it.
Thank you, sir.
I want to associate myself with what Senator Sass said about the Epstein case and the problem in general. And to the extent you can help us figure this out, please.
Yes.
Senator Durbin.
Thanks, Mr. Chairman. Mr. Barr, thank you for being with us. Mr. Barr, my colleague Senator Ernst asked a question earlier, which I'm sure would be asked in virtually every state we represent, what we're doing to stop the flow of narcotics into the United States. She asked about meth, I believe in particular, but about narcotics coming in from Mexico, and your reply was, and I quote, "It is the major avenue of how drugs come into the country. They come across that border. I feel it is a critical part of border security, and we need barriers on the border." That was your quote. I'm troubled by that answer, and I'd like to clarify it, because if we're ever going to have a rational conversation about border security, there ought to be some basics that we agree on. The DEA, which you'll supervise if confirmed, in its 2018 report said, quote, "The most common method employed by the Mexican drug cartels involves transporting illicit drugs through U.S. ports of entry in passenger vehicles which concealed compartments are commingled with legitimate goods on tractor trailers." The Customs and Border Protection's own data shows that customs officers at legal ports of entry seized the vast majority of lethal narcotics coming into this country. In fiscal year 2017, last year we have data, 87% of the fentanyl, which has been identified as CDC as the most deadly narcotic in America, 87% seized in our country coming in through ports of entry.
13% seized outside of ports of entry. So overwhelmingly, when we talk about building new walls and barriers to stop narcotics, we're ignoring the obvious. 80 to 90% of the drugs are coming in through ports of entry. I met with the head of Customs and Border Protection. He said the number one thing we can do is to put technology in the ports of entry to scan the vehicles coming through. Currently, only 17% of trucks and cars coming through those ports of entry are being scanned, 17%. That means 83% of them are just flowing right on through there, bringing narcotics to Iowa and to Illinois. Building a new concrete wall from sea to shining sea doesn't even address this issue. Technology does. I want to reach a point where we open the government and have this honest conversation. Would you reconsider your earlier answer as to the fact that we need to build more barriers to stop narcotics from coming into the United States?
Well, it wasn't tied just to narcotics. It was tied to overall border security.
You said a major avenue for how drugs come into this country. It's not.
I said was
The
across the
border.
wait a minute.
The border is the major avenue, but your answer was we need barriers on the border.
Right, and because we need barriers on the border for border security. Part of what we're trying to do is cut down on drugs. It's also illegal aliens. It's also other people from other countries who may wish to do harm in the United States that are coming in. And barriers are part of the answer. And from my experience, the threat is always dynamic. You put technology at the ports of entry, they'll shift somewhere else. It's a moving target, always has been. And I think we need a system that covers all the bases.
I think the reason we cannot reach an agreement with the Trump administration is fundamental to our exchange. And it's this. I don't disagree with you with the notion that barriers from sea to shining sea will at least slow people down. But when it comes to the next marginal dollar to protect kids in Illinois and children in your home state, it's ports of entry. It's technology to keep these narcotics out of the United States. And if we can't really start at the same premise based on reports from the president's own administration, we're never going to reach a point of bipartisan agreement on border security. So I think we're close to agreeing, and maybe it's semantics, I hope not, but I hope that we can agree that if we're going to stop narcotics, it's technology and personnel. The experts tell us that it's not a wall, and I hope that we can move from there. The last question I'll ask you, and at limited time, they asked me about your statements this morning, your testimony, and I thought they were good, responsive in most part. The one thing I'm stuck on, and many are, is this report you gave to this administration in June of last year about the investigation of the president.
You mean my memo?
Yes.
My memo, yeah.
And you said in there, Mueller should not be permitted to demand that the president submit to interrogation about alleged obstruction. You volunteered that. I'm trying to get around this. It sounds like it was an effort on your part to ingratiate yourself with an administration which is now nominating you for Attorney General. I'll give you one last chance. My time is up. Please respond.
Okay. Well, first, what I was saying there was, again, based on speculation on my part, was that there has to be an adequate predicate, and if he was relying on just the firing of Mueller or the statement about Flynn and this specific statute, those two things, I didn't think it was an adequate predicate. I wasn't saying he may have other facts, he may have other theories that would support it. I was just pinpointing that. Number two, I can assure you I was not trying to ingratiate myself with anybody. The furthest thing from my mind was coming back into government, I can assure you that. And if I wanted to ingratiate myself or signal things, there are a lot more direct ways of doing it than that.
For the record, I think you meant the firing of Mr. Comey. I think you said Mueller earlier.
Oh, okay, yeah. What did I say? Oh, yeah, the firing of Comey, yeah.
Thank you very much.
Just trying to help you.
Thank you. I'll just take a couple of seconds, see if I can help clarify this, because I think it's been a very interesting hearing. So if there was some reason to believe that the president tried to coach somebody not to testify or testify falsely, that could be obstruction of justice.
Yes, under that, yeah, under an obstruction statute, yes.
So if there's some evidence that the president tried to conceal evidence that would be obstruction of justice potentially, right?
Right.
Your point is just simply firing somebody, which is a personnel decision, is problematic for the system.
Right, especially if you, what I'm saying is that doesn't fit under that statute.
got you.
Show me some other statute, but that statute, no.
Yeah, okay. Who's next? Senator Hawley, thank you.
Thank you, Mr. Chairman. Mr. Barr, switching gears a little bit, yesterday a federal district court judge in Pennsylvania struck down the Trump administration's religious and moral exemptions to the contraceptive mandate under the Affordable Care Act. As part of this ruling, the district court judge issued a nationwide injunction to any enforcement or application of these rules. This is a growing trend. We've seen a lot of this in the last 2 years. We've seen lots and lots of district courts all across the country in various contexts, in the immigration context and others, issue nationwide injunctions. And now, of course, for those listening at home, the entire nation is not within the jurisdiction of these courts. These courts are district courts. They reach a specific geographic areas delineated by law, and yet they're issuing increasingly commonly these injunctions that reach the entire country. This is a fairly unusual and fairly recent practice. In distinction to this, the district court judge in Texas who recently heard a challenge to the Affordable Care Act case did not issue a nationwide injunction, and therefore allowing the appeals process to take its normal course. And of course, the ACA remains in full effect throughout that appeals process because he did not issue a nationwide injunction. So my question is to you, are you concerned about this growing practice of nationwide injunctions by federal district courts, and what do you think ought to be done about it?
Yes, I'm very concerned by it. Earlier, I was talking about this and saying that I think it mistakes the limitation on judicial power, which is a case or controversy limitation, and tries to grant relief to people who are not part of the case or controversy that's being decided. And as you said, it's really started in the 60s, and it's been picking up steam. And the fact of the matter is there are a lot of district court judges, and you can usually find one who somewhere in the country will agree with you. And so major democratic decisions can be held up by one judge nationwide. I'm also concerned that there's another trend, which is the willingness of some district court judges to wade into matters of national security, where in the past courts would not have presumed to be enjoining those kinds of things. And then the appeals process takes a long time, and so a lot of damage can be done before it gets to the Supreme Court and you get a definitive decision. And meanwhile, everything is stuck.
Can you just say more? You're concerned about courts that wade into national security issues where traditionally they have hesitated to do so. Can you just say more about that? What do you have in mind?
Like the travel ban.
Mm-hmm. And the concern there is that,
I mean, the president takes something based on national security, and and the Constitution vests that kind of judgment for that kind of emergency act or act that he has the authority to perform to protect the country. He's politically accountable for that, and yet a judge with a lifetime appointment sitting somewhere in the country who doesn't have the access to the information, has no political accountability, can stop a national security measure, globally, essentially, and it takes a long time to get that sorted out. That's really troublesome to me.
Yeah, I completely agree with you. Let me ask you about another recent case, this one from the Southern District of New York today, in which the district courts ruled that the attempt by the Commerce Department to include a citizenship question on the census is not permissible, and has stopped the Commerce Department from including that on the 2020 census. The department has argued, of course, and the Department of Justice is defending this decision, that including a citizenship question, as was done for approximately 100 years, on the census actually helps identify with greater accuracy the residents of the country who is and who is not a citizen, and of course helps more accurately apportion and draw congressional districts and make sure that representation is fair and the Voting Rights Act is fairly enforced. Do you agree with that position?
Well, it's being litigated now, so I really would prefer not to comment on it.
Do you anticipate that the Department of Justice will continue its vigorous defense of the position that the administration has taken?
I think generally, I have no reason to change that position.
Thank you, Mr. Chairman.
Senator Whitehouse.
Thank you. Mr. Barr, in order to put this in the FBI know about the business relationships and entanglements of senior officials with foreign interests and governments.
Well, usually, I guess, usually investigations are started because there's some act that comes to the attention of the law enforcement agency that suggests someone is being disloyal to the United States.
Except where
and
we
working for a
require
foreign
disclosure.
excuse me?
Except where we require disclosures in order to give the law enforcement folks that advantage of knowing in advance when a senior official has a business entanglement with a foreign interest or power.
Mm-hmm.
So what should we know?
What official are we talking about?
Well, let's start with the president.
Are you suggesting the president go through a background investigation by the FBI?
No, I'm suggesting that when there's evidence that he has business relationships with foreign interests, then that may be a factual determination that would be of some note to our counterintelligence folks.
Well, the financial disclosures that I think are filed by other, I don't even know if members of Congress file financial disclosures, do they?
Yeah.
They do.
So do many officials in the executive branch. So will you.
that's for financial conflict. I don't think that's for counterintelligence purposes.
Probably because very few people have business relationships with foreign interests, so it turns up much more often in a conflict.
Well, business relationship with a foreign interest is not ordinarily a counterintelligence concern.
Unless, of course,
Unless
you
the
are,
person is a traitor.
or in a position to make decisions that are biased or influenced by those business relationships.
Well,
counterintelligence and treason are not the same thing, are they?
Counterintelligence, you're usually trying to counter the intelligence activities of another country.
Correct. And you may want to head off things, you may want to be aware of things, you may want to, there are a whole lot of things short of treason that are the counterintelligence function.
Right. Including, counterintelligence focuses usually on foreign intelligence services and their activities.
Trying to
I think what
influence
we're
American officials
I
often.
think we're mixing apples and grapes or whatever here because
Well,
financial
maybe
disclosure
we're
goes.
just having a hard time answering what ought to be a really easy question, which is that when a senior government official has business relationships with foreign interests and powers, we ought to know about it. That ought to be an easy proposition, and in any other administration it would be.
Well, did congressmen go through background investigations to get access to classified information?
That's a whole separate question.
No, it's exactly
Yes,
the same question.
we do a lot more reporting than we do.
Well, your financial reporting, with all due respect, is not the same as a background investigation. You're elected by the people to hold an office, and, you don't get a background investigation to get on the Intelligence Committee.
But we do have to do a lot of reporting. Okay, you don't want to answer it. I'll move on. Let's talk about corruptly in obstruction cases. I'm not sure I heard you correctly, so I want to make sure you have the chance to explain. But it sounded like you were saying that the word corruptly, used, as you said, there be some form of destruction or interference with evidence, obstruction of justice, to impose an intent requirement, which is also what the Criminal Resources Manual of the Department of Justice says, and what I think virtually every appellate court has said. So it worries me if what you are trying to do here is to redefine the obstruction statute by narrowing the intent requirement and using the term corruptly to refer to something very different, which is the actual physical corruption changing or
I think I can
damaging
allay your
evidence.
concerns. Yeah.
Could you do that? Because that would
Yeah,
obviously
because if you
be-
read, if you look at the memo, you'll see that my discussion of corruptly is not up in the plain meaning section where I'm talking about how you interpret the statute. And my basic argument as to why the statute covers destruction of evidence and hiding evidence and stuff like that is based on the word otherwise, Supreme Court decisions in Yates and Begay, also the fact that if you actually read it otherwise, it swallows up all. It becomes a one-clause,
So my time
it
is
wipes out
up.
everything else.
If I can just cut to the
No, so then later on, I point out in my memo, I later point out that that reading is also supported by the understanding of the word corruptly, which the Poindexter case, D.C. Circuit case, I think had the most intelligent discussion of the word corruptly, which is it does refer to the kind of activity that's necessary, which is perverting a proceeding by corrupting it.
So in the event that the Mueller investigation has turned up evidence of obstruction of justice by the president or people close to him, you would follow the Department of Justice's existing legal guidance with respect to what that word corruptly means.
My interpretation of the statute was not predicated entirely on the word corruptly. I was just pointing out.
And it is not your intention to change
No, it's not my
department
intention.
policy or department standards or department definitions, particularly as they may bear on obstruction by the president or people around him.
That's right.
Thank you.
We're about to vote. Let's do one more. You deserve a break. You've done great. One Senator Ernst, then we'll take a break, go vote. I'm going to vote and come back, give you about 15 minutes, and we'll just plow through till we're done. Senator Tillis?
Well, I'll be brief. One question, because people have asked, they've gone to the wall. It almost sounds like they're trying to suggest that you believe that the fix for border security is a 2,300-mile physical barrier from the Pacific to the Gulf. Do you believe that's the best way to secure the border?
I'm not sure what the current thinking is on this, but when I was looking...
Have you ever advocated for a wall or some sort of monolithic structure as the plan for securing the border?
No, but I do believe we need to have a system all the way across. When I was looking at this, you know, there were certain areas where, you know, a wall didn't make any sense.
You've used the word barrier. I don't think a 30-foot wall makes sense on, for example, 1,000-foot cliff.
Right.
Or one that's out in the middle of nowhere. Would you agree that, you know, when we get away from this childish, everybody's saying it's a wall or not, that we're probably, the president's repeatedly said that we need wall structures, we may need steel slat structures, we may need to reinforce chain link fences with all-weather roads. We need aerostats so that we can identify people crossing the border that are otherwise desolate and not very frequently crossed. We need border patrol agents, and we need technology that interdicts all the illicit drugs at the legal ports of entry, that those are all elements of a barrier that actually will better prepare us to secure the border, eliminate the poison coming across the border, and perhaps reduce the amount of human trafficking that's coming through the legal ports of entry. Is that a better way to characterize your position on barriers
Yes.
that either are physical, technological, or otherwise?
Yes.
Thank you. Also, I can't leave without going back to, you were talking about a time when I was in my early 30s. I remember vividly just how dangerous things were getting back in the early 90s. I was 30 years old in 1990. I remember vividly the news reports and everything that we were trying to do to get ahead of the murderous environment that we were in. I think some people are trying to project, or at least maybe I've inferred, maybe incorrectly, but project what you were trying to do or what you were advocating for in the midst of a crisis, which was not mass incarceration of low-level nonviolent criminals,
Right.
onto your view of, let's say, the First Step Act and what we're trying to do today. If you, hypothetical, maybe you can't answer it, but let's say you were Attorney General when we were moving First Step, which I supported. I supported criminal justice reforms in North Carolina when I was Speaker of the House. Are you fundamentally opposed to what we're trying to do with the First Step Act?
No, I think some of those things make sense. If I had been at the table, I probably would have urged a few changes to it, but, you know, overall, I don't have a problem with it.
And you're fully aware the President and folks in the White House are supportive of the act, and
Yes.
so you'll do everything you can to help us take that intent, the statutory intent, the things that you'll need to do is implement in your role as Attorney General. I do believe you're going to be confirmed to make sure that we get the full positive effect that we'll get out of the First Step Act.
That's right, Senator. And, you know, there were a number of things being lumped together. What I espoused in the 90s, when we had the highest crime rates in our history, was taking the chronic violent offenders with long criminal history records of predatory violence, and especially the ones that use guns in multiple offenses, and getting them off the streets and into prison.
And I think you made the point that in some cases you were able to more clearly present evidence where they were involved in drug trafficking, but you knew damn well that they were a part of what was murdering these communities and making them very dangerous. And the point there was you were using every device possible to get them behind bars and off the streets so that you could make those communities safer.
Right.
Including the communities in Trenton, New Jersey.
Right.
Yeah.
So the other thing then there are drug penalties. And some of the drug penalties, yes, were draconian, and there were rational reasons for doing that at the time. And sometimes people got and we weren't going after people who needed treatment, who were, you know, just because they were addicts. We were going after the people who were distributing the drugs. And, you know, in the current circumstance, I understand there's data to support what was done in First Step. I understand those changes on the drug front. But I would not let up on chronic violent offenders because they commit a disproportionate amount of the predation in society.
I hope you don't, because they need to go behind bars for a very, very long time. Thank you.
All right, thank you, Mr. Barr. What we'll do, we'll come back with Senator Klobuchar. We're going to take a 15-minute break, and hopefully by then, both of us can vote and come back and continue, and we're just going to plow through till we get done today. So we'll be in recess for 15 minutes.
Is this a spelling?
goes on. That is correct.
All
We will go ahead and reconvene the hearing. I'll recognize Senator Klobuchar.
Thank you very much. Thank you, Mr. Barr. Thanks to your grandson for the mint. That was very nice. In your previous confirmation hearing for Attorney General, you stated that the Attorney General is the President's lawyer. You have also said that the Attorney General's ultimate allegiance must be to the rule of law. So I'm going to characterize that as the people's lawyer. And there have been times throughout our history, including during Watergate, when the personal interests of the President do not align with the interests of the country. In those critical moments, is the Attorney General the people's lawyer or the President's lawyer?
Well, the reason I referred to the Attorney General as the President's lawyer is because in 1789 they said that the Attorney General is to provide legal advice to the President and the Cabinet, and that's in their official capacity. And my view on that is that, like any lawyer, you give the best advice as to your view of the law. But if the President determined that he wanted to do something that you thought was still a reasonable construction of the law, even though you might not have decided that way as an Article III judge, just as you support congressional enactments that are reasonable, you do the same for the President.
But how about in a situation like Watergate?
So, if the President directs an Attorney General to do something that is contrary to law, then I think the Attorney General has to step down.
Okay.
It's that simple.
Thank you. Under the special counsel regs, the special counsel must send a second report to Congress documenting any instances where the AG prohibited the special counsel from taking an action. Will you follow those regulations and send the report to Congress?
Yes.
Thank you. And then a few just things that I care a lot about. You had a great discussion with Senator Booker about the First Step Act and nonviolent drug crimes. Will you support the use of drug courts? Something my county, when I was prosecutor, was one of the first to do that in a big way. And now we have federal drug courts. Will you support them for nonviolent offenders?
Yeah, I think they're generally a good idea.
Okay. And there's a bill that I have that we're reintroducing on guns and stalking. And it's a pretty narrow bill. It fills a loophole that's called sometimes the boyfriend loophole. I don't know if you know what that is, but it's when someone is not married, but they're living together, and then the question is, would the gun laws apply? And we actually had a hearing, and a number of the Republican witnesses agreed that they should. So that's part of it. And then the other involves stalking, and whether or not that could also fall under the prohibitions on guns. So we had the meeting on guns at the White House, and the President said he thought the bill was terrific. I just kind of lead you into that, but. And it hasn't passed yet, but I'm just asking you to review it.
Absolutely.
Okay, and I hope we would have your support. It would be nice to get that done. And then I also have a second bill with Senator Cornyn, the Abby Hunold Act, and the bill would expand the use of evidence-based practices in responding to sex assault crimes. And I hope you would look at that as well. And it's part right now of the Senate package on the Violence Against Women Act. And my bill aside, I hope that you would support the reauthorization of that bill. You would? Of the Violence Against Women Act.
Well, I haven't seen it, but if it's reauthorizing what's in effect now, yes.
Okay. And then I just want to end here with a second chance, second go-around on a question. I decided to leave my antitrust questions for the record, so I can ask this. I asked earlier today this question because I really meant it as an opportunity for you to kind of address your troops and not a gotcha question. So immigration debates aside, putting aside the differences in this House and in the White House, and we have now thousands and thousands of extraordinary people devoting themselves to a good cause, and that is justice, at the Department of Justice and the FBI, including a few of them right behind you in the front row. And many of them right now are either furloughed or they're doing their jobs every single day without pay. And if you get confirmed, you will be their leader. And do you want to say anything to them or about them? And I appreciate it.
Well, thank you, Senator, for getting the opportunity, because one of the reasons I want to do this
serve as Attorney General is because of the opportunity to work with the outstanding people at the Department of Justice. And I think the country can be very proud of them as of their dedication as they stand their post and continue to perform their mission. It's a great sacrifice for many of them with the paychecks not coming in. So I hope this ends soon. But one of the reasons the department is such an important institution to me and a big part of my life is the quality of the people there. And I'm looking forward, hopefully, if I'm confirmed, to joining them again.
Okay. Thank you very much.
Thank you.
Thank you, Senator Klobuchar. I love the upward mobility on this committee. This is my first committee hearing, and I get to chair. So thank you. I appreciate it very much. I'll go ahead with my second round of questioning, and there has been a lot of discussion so far about the Mueller investigation, which I do think is very appropriate. And as I understand it, the underlying premise of that investigation was to determine if there was collusion by an American entity or person with the Russians during the 2016 election cycle. Is that accurate?
That's my understanding.
Okay, and we do know that there was Russian meddling in our 2016 election cycle. We do know that. And what can the DOJ do in the future to prevent whether it's Russia or other foreign entities from interfering with our elections process?
Yes, well, I adverted to in my opening statement is obviously the department is a law enforcement agency.